News Live, I'm Patty Ann Brown. A Palestinian peace negotiator is accusing Israel of an act of war. The cabinet minister says Israel chose the path of war by launching missile strikes on targets in and around Gaza City. The targets include police headquarters, a refugee camp, and headquarters of Yasser Arafat's Fatah party. About 30 people were hurt. Israel says it only launches such raids in response to attacks by Palestinians. The missile attack is retaliation for a deadly bombing earlier today in the Gaza Strip. Shrapnel hit an armored bus carrying Jewish children and teachers. 2 adults were killed. 9 people were hurt, including 5 kids. A debate in Japan's parliament got nasty today. A former wrestling champ tossed a glass of water at opposition lawmakers. The session quickly erupted into a frenzy, and the water thrower was later expelled from parliament. The lawmakers were debating a non-confidence vote on Prime Minister Yoshiro Mori. Well, one person died when an American Airlines jet made an emergency landing today in Miami. The A300 jet had just taken off when an engine fire light came on. The plane landed and passengers got out on emergency chutes. Some passengers were injured sliding down the chutes. It's not clear how the one passenger died. The plane was headed for Haiti. Federal agents will help investigate an explosion that ripped through a South Dakota high school. 2 people were killed. The probable cause is a propane leak, but the Bureau of Alcohol, Tobacco, and Firearms wants to know for sure. Teens in Coeur d'Alene, Idaho, have found a new way to have fun. They hang out in an underage nightclub in an unusual place, their high school. On Thursday and Friday nights, a classroom is transformed into an improv club called the Blue Room. It has become a showcase for local talent and a safe place for teens and even their parents to have fun. And those are the headlines. Now more coverage of the election deadlock on Fox News Live.
At 28 minutes before the hour, it is the calm before the storm. Team Gore and Team Bush facing off in Florida Supreme Court in less than half an hour from now. Mainly at issue those hand recounts. But there is also some big news this hour about the military ballots from overseas. Fox News senior correspondent Jim Engel is live with that in Tallahassee. Jim?
That's right. The Attorney General, Bob Butterworth, who was the chairman of the Gore-Lieberman campaign here in Florida, seems to be trying to settle one of the disputes that has hurt the Democrats here, and that is whether or not military ballots, absentee ballots from overseas, can be counted if there is no postmark. A number of those were excluded, even by some Republican election officials, saying the Florida law specified that they must do so. Butterworth has issued an opinion, or a letter at least, to all of the county supervisors and all county canvassing boards saying that is not the case. He is urging them to immediately revisit this issue and amend their reported vote totals if appropriate. He says a ballot is good if it is either postmarked or signed by the individual by the date of the election. There were some protesters who were raising this issue here in front of the Supreme Court today. Now, he also says that his office urges supervisors and canvassing boards, if they have any further questions, to seek a clarifying opinion from the Secretary of State, someone with whom he has differed and fought over other electoral rule matters. So for the moment, the Attorney General is saying you must count those military overseas ballots if they are signed and have a date on them, even if they do not have a postmark. That could help George W. Bush. Back to you.
Senior correspondent Jim Engel, live from Tallahassee. Jim, thank you. You just saw a live picture inside the Florida Supreme Court. In about 16 minutes from now, the judges will go into what's called the robing room, put on their robes, and come into the courtroom in order of seniority. In case you're wondering, who are the justices who are going to be making what will be a very important decision? Correspondent Orlando Salinas is live in Miami with some details. Orlando?
Hi, Linda. You know what? Let's talk real quickly, if we could, about this Miami-Dade recount. It is still rolling along, but the question, Linda, really is, will any of those recount votes really matter? That question is certainly sitting in the hands of the state's 7 Supreme Court justices. And considering, as you said, that these oral arguments will be heard in less than 20 minutes from now, this is probably a good time to probably take a little bit closer look at who these 7 Supreme Court justices are for the state of Florida, how they got there, and certainly where they're planning maybe on going with today's oral arguments. Now, all were appointed to the High Court by Democrats. The Chief Justice since July is Charles Wells, appointed to the court in 1994 by the late Governor Lawton Chiles, a Democrat. Records show that through the years, Wells contributed thousands of dollars to a number of Democratic candidates and causes. Next, Justice Leander Shaw, the longest-serving justice on the court, appointed in 1983 by then-Governor Bob Graham, now a Democratic U.S. Senator from Florida. Shaw, as a former public defender, is considered the most unpredictable. Justice Major Harding is the next longest-serving, appointed in 1991, also appointed by the late Lawton Chiles. Justice Harding grew up in North Carolina, got his law degree at Wake Forest University, and he is seen actually as the most conservative. He is a former U.S. Army judge advocate. Moving on, Justice Harry Lee Anstead, appointed to the court in 1994, also by Lawton Chiles, with law degrees from a couple of places, University of Florida and the University of Virginia. A former trial lawyer, he is considered the most liberal. The first of 2 women, Justice Barbara Pariente, appointed by Lawton Chiles in 1997, originally from New York, got her law degree at George Washington University Law School in D.C. She has given money to Democratic candidates, we understand. Now to Justice Fred Lewis, appointed by Democrat Lawton Chiles as well. Lewis joined the court late in '98, comes from West Virginia, got his law degree from the University of Miami. And the last member, the second woman, Justice Peggy Quince, the newest member of the board and the only black woman appointed jointly by Lawton Chiles and Republican Governor Jeb Bush. Quince, a former appeals court judge, many say that she does have an independent streak. Let's do this now. Let's talk quickly about the Miami-Dade recount. Almost 4 hours now. That is how long the manual recount's been going on inside the county government building. 25 teams working at tables, sitting across from Republicans and Democrat observers as well. A good chunk of security standing there making sure that that recount goes on orderly and legally. Now remember, Miami-Dade still is the largest county here in the state. More votes were cast here in the Miami-Dade County area than any other county in the state of Florida. Election Supervisor David Leahy says that he hopes to be done with this monster recount maybe by December 1st. Again, though, remember this 7-member Supreme Court justice set to begin hearing oral arguments probably in about 14 minutes, somewhere around that. Certainly Fox News Channel will be carrying that live as it goes on. Right now we are live in Miami. Orlando Salinas. Linda, back to you.
All right, thanks, Orlando. We go now from one recount battle zone to another, this time to Palm Beach County. It's a little bit further ahead in the county than Miami-Dade, but it's still going slowly. And now there is this new twist about the order from the Attorney General to revisit some of the overseas absentee military ballots. David Lee Miller is live in West Palm Beach. David?
Hi there, Linda. First, let me tell you that a county court judge a short time ago issued a ruling saying that he did not have the authority here to order a new presidential vote in Palm Beach County. At least half a dozen lawsuits have been filed here by Gore supporters who say they mistakenly voted for Pat Buchanan. They say the infamous butterfly ballot here was not only confusing, but that it was also illegal. But the judge in his ruling said, quote, the relief sought by the plaintiffs is not permitted by law. Now, as for the count, it continues at this hour, and it has been going on since about 7:30 this morning. They have 103 of 531 precincts now calculated, and they say it gives a net total advantage to George W. Bush of 7 votes. Both Republicans and Democrats, though, are very unhappy with the recount process that is unfolding here. The Democrats say that because they are not counting dimples, Al Gore has lost 200 votes. Meanwhile, the Republicans say the entire process itself is flawed. They say the ballots are being mistreated, there are signs of tampering, and ballots being misplaced. As for when all this is going to end, a few minutes ago we talked with the canvassing board chairman, Charles Burton, and he says now it is going to continue past Thanksgiving, pending, of course, some type of decision by the Supreme Court that could bring it to a grinding halt. For now, Linda, back to you.
All right, David Lee Miller live in West Palm Beach. David, thank you. Straight ahead, the Florida Supreme Court possibly holding the keys to the election deadlock. The hearing getting underway at 2 p.m. Eastern Time, 1 p.m. Central. A preview is just ahead with a former Chief Justice of the Florida Supreme Court.
Highlights in the world of sports. 55,000 ball fans gathered for the All-Star game at Briggs Stadium, Detroit. Rival pilots Del Baker and Bill McKechnie. Dizzy Dean, ex-ball player and budding radio announcer. Cleveland's Bob Feller and Whitlow Wyatt of the Dodgers. They pace the pitching in the major leagues. The Yankee Clipper Joe DiMaggio and brother Dominic of the Boston Red Sox. So run the headliners, but here's that eighth-inning heartthrob. Edgar Smith whips over a fast pitch to Archie Vaughan, and with it goes a hatful of all-star records. For when Vaughan hangs the apple in the second tier of the right field stands, it marks his second and successive circuit cloud of the ball game. With Johnny Mize scoring ahead of him, the National Leaguers have forged to a 3-2 lead. Joe DiMaggio tees off in the Americans' half of the eighth with a scorching double to left center. Again, the house comes down. Although not counted in regular season batting records, it nevertheless keeps his consecutive game hitting streak intact at unofficial number 49. And when Paso pitches to brother Dom DiMaggio, there comes into view the first all-star brother act. When Dom single to right center scores brother Joe with a third American tally. Comes it now the ninth and the panic. With one out, Travis walks, the bases are loaded. And who should be coming up at the Yankee siege gun? Joe DiMaggio. But the hero's accolade is not for Joe. DiMaggio grounds to short, forcing Travis at second. Keltner scores, and up comes Ted Williams. The first pitch, a called strike. Paso worked to a count of 2-1 when Williams lays into one with everything he has, and the ball game is over. A tremendous home run crashing against the stadium roof sends Gordon and DiMaggio romping home ahead of him, and the American Leaguers hang up their sixth all-star triumph in numbers reading 7-5, while Ted Williams, the 400 batting pride of the Boston Red Sox, becomes baseball's man of the hour. With the entire net proceeds of the game going to the United Service Organizations, Chairman Thomas E. Dewey speaks for the USO.
The baseball world certainly did a great job today for the men in uniform. On behalf of the United Service Organizations, I want to thank the 55,000 fans and the leaders and players for their help.
Here's the latest on the election deadlock. At 2 p.m. Eastern Time, Florida's Supreme Court will start hearing arguments on the Florida recount. The court has to decide whether the Florida Secretary of State was acting lawfully when she decided to exclude late hand-counted ballots from the state's election total. A Florida state judge has ruled that he does not have the authority to order a re-vote in Palm Beach County, and Republicans accuse Broward County of caving into political pressure after the county reversed a decision to disqualify ballots with dimple or one-corner chads. With over two-thirds of that county's precincts tallied, unofficial figures show Gore gaining 108 votes, but the official total has him behind by 930. And one Broward County Republican observer says at least one ballot counter was spotted eating chads. A Democratic congressman says Republicans are just making that up. I'm Patty Ann Brown.
All right, at about 27 minutes before the hour, while the lawyers are warming up for their arguments, the hand counting is going on in the contested counties. We're joined by a Democrat voting observer from Boca Raton, Florida, Lillian Kaminer. Nice to have you with us. Thanks for joining us. Hi. We have heard so much over the past several days of bickering going on in those rooms where you have observers saying, no, I don't like this, or those chads fell on the floor, or whatever. Can you give us a sense of what the atmosphere is really like in there?
I haven't seen anything like that. I'm recounting in Palm Beach County, and the atmosphere is very businesslike, very efficient, very organized, and very quiet, and I haven't heard any bickering at all. Well,
there have been some disputes that I think even Charles Burton admitted to, that in terms of some a Republican and Democratic observer being upset with where they were sitting, and they had to be moved because they weren't getting along, and in other cases that people who were handling ballots, this was actually substantiated, people who were handling ballots accidentally put Bush ballots in a pile of Gore ballots. And then finally it took a Democratic observer to catch it and call it to everyone's attention.
Well, as far as putting the ballots in the wrong pile, that's why we have observers, to make sure that doesn't happen. It did happen in one case in one of the precincts where I was observing, but the counter found that out, and we fixed the problem. And I didn't hear any bickering about where people were supposed to be sitting or not getting along with the person they were with. If there was a problem, I'm sure it was taken care of in due course.
So you have not had any tense moments, shall we say, with the Republican observer
Not at all.
teamed next to you?
Not at all.
There have also been some reports that just pure fatigue, plain old fatigue, kicks in. That the lighting in the room is poor, and that at a certain point, after hours and hours and hours of doing something that is just so focused that you have to stare at so closely, people are admittedly tired. True?
The lighting is very, very good where I am, and we were instructed before we started that if we became tired or fatigued or felt that we couldn't do it anymore, that we should raise our hand and be replaced. They have replacement observers, and they have the people to take your place.
Very quickly, we've heard now that it looks like the count in Palm Beach County is going to continue beyond Thanksgiving, which means some more long days for you. Are people, should I say, discouraged that you've got many more days of this?
No, not at all. I think the process has to take as long as it's going to take, and everyone that I've talked to is very willing to be here and do it.
A lot of friends on both sides, and they're going to interpret the law as they see it, and I don't think something like that is going to be an influencing factor.
You are, I would imagine, familiar with some, if not all, of these justices. Are they, all of them, I mean to a person, willing to buck expectations and maybe even their own political leanings if their conscience requires it?
I believe they are. You know, a judge is trained to try to the extent humanly possible, set aside any inner biases or prejudices or leanings that they have and render a judgment that they intellectually and in good conscience believe that the law requires them to do. I've made decisions that I didn't like very well. If I had my choice, I'd have ruled the other way, but I felt the law compelled me to do that. These judges are not afraid to make unpopular decisions. They're going to rule, I believe, and I have confidence in the way they interpret the law.
Just a human question. You said in one article this morning that you figure the justices have to be tense about it. Can you give us a sense of what it must be like for those justices, no matter how cool their heads may be, to be on national television and perhaps determining the fate of the next president?
Well, you've got to, it's a heavy responsibility, and they're human, and they're certainly going to be on edge, and certainly, you know, feel so strongly to make the right decision in their lights, by their lights, and so it's natural for them to be tense. I think anybody would be in that situation, but they've been long experienced judges, and they can handle it.
Well, many people watching, no doubt, will be tense as well. Judge Stephen Grimes, we thank you so much for being with us. We really do appreciate it. And as we stand at about 7 minutes from the Supreme Showdown, as you know, Florida's highest court is going to be hearing arguments from Team Gore and then Team Bush on those hand recounts, of course. That's starting at 2 p.m. Eastern Time. Now, in the last couple minutes before we get to that, we want to bring in some of our correspondents who have been in the lead in reporting on the story. We want to bring in Carl Cameron, who's in West Palm Beach, Brian Wilson, who is in Austin, Texas. We're also going to bring in correspondent Jim Angle, who is in Tallahassee, who's getting a microphone on as we speak. We had to switch a satellite hitch up for Jim. But we want to begin with Carl Cameron in West Palm Beach. Carl, starting with you. And the question of Bush camp expectations, because on Friday, the Bush camp was dealt a couple of blows. And just when things actually looked grimmer for the Gore camp, now they have to go in here facing a heavily Democratic court. Is there a sense in the Bush camp that this is an uphill battle?
Sure, but they don't know really what to expect, because they first had the lower court ruling on Friday that said that Secretary of State Katherine Harris was within her rights to discount and exclude the manual ballots. Then the Supreme Court came in. The Gore campaign did not think that they were in a particularly strong position. And then, of course, the Supreme Court, having not been asked, said that, in fact, the certification could not go forward on Saturday. And that was indeed a surprise and a setback to the Bush campaign. They have been furiously preparing their briefs and getting ready for this afternoon's arguments, and they don't, frankly, know what to expect. What they want is for this judge, the Supreme Court judges, all 7 of them, to uphold the statute and do a strict and literal interpretation of Florida law, And if that is the case, they believe that they are on very firm ground, as is Secretary of State Catherine Harris, and that ultimately these manual recounts can be excluded from the final certification. There is some question, however, because this panel of judges in Florida has something of a reputation for legislating. It's a bit of an activist judge. It's an activist panel in the view of many Republicans with a reputation for reinterpreting statute to suit the times. And if they were to determine, as the Gore campaign wants them to, that what they must do is come up with a fair resolution to this in the Gore campaign's perspective, Bush campaign would be in a lot of trouble.
To Jim Engel now in Tallahassee. Jim, I want to hit once again this question of Dexter Douglas being brought in by the Democratic side. Somebody who pointed out that was involved in the selection of at least 4 of those justices on that court. Now sitting at the Democrats' table, could that be a factor?
I don't think so. I mean, a lot of these people know each other in political and legal circles. I think a bigger factor are the questions of law here, and those are quite important. If this court were to decide against Al Gore, for instance, the election would be all but lost for him. The issues here are critical, as Carl was talking about. I mean, they must decide whether or not recounted votes are legal, whether or not they are legal even if they come in after the deadline, whether or not the Secretary of State had the authority and the discretion to set that deadline and to exclude all recounted votes that came in afterwards, and they may address the question of what is a legally cast vote, what kind of vote can be recounted for a candidate that wasn't counted for the candidate in the first place. Is a dimpled Chad or a pregnant Chad count? That has not been addressed except by counties with different standards at different times. Some going loose, then harder, some expanding the kinds of ballots they would take. That question could be answered, but not necessarily answered by the Supreme Court. That too, a looser standard, what is called a generous standard, that they will not get enough votes in the recount to actually win this election. So there are a lot of critical questions here. There couldn't be more riding on this Supreme Court decision, Linda.
Correspondent Jim Engel in Tallahassee, Carl Cameron in West Palm Beach, and apologies to Brian Wilson in Austin. We just didn't get a chance to bring Brian into the conversation. That's because... Stay with us, because after this, Tony Snow is going to take over the helm. He's going to anchor our live coverage of the 2-hour Florida Supreme Court hearing.
A two-piece playsuit of printed jersey is displayed as an American fashion group visits Mexico. And here comes a diver, for this is Acapulco with its famous high dives. Look at the hand-painted blouse blowing in the wind, but look at the dive down into the sea. Diving and a good neighbor style show, and how he takes the leap through space and plunges safely into the water is almost like a miracle, says she in her black moire bathing suit with a white fringe trim. This presentation of the awards of the Academy of Motion Picture Arts and Sciences is always a distinguished occasion in Hollywood. Producer Darryl Zanuck and Mrs. Zanuck and Wendell Wilkie discuss movie affairs. Linda Darnell and Cesar Romero are among the film stars in attendance, as are Betty Grable and George Rath. Donald Crisp and Mary Astor are acclaimed for the year's best performances as supporting players. For the best acting by stars, Joan Fontaine and Gary Cooper get what Hollywood calls the Oscars. Top honors for producer go to Darryl Zanuck, award presented by Walter Wanger.
Colonel Zanuck, it's indeed a pleasure to be able to present you with this award
for the most distinguished picture of the year, How Green Is My Valley, a picture which has brought great credit to the industry and to Commander Ford, who made it, and you, who produced it.
Thank you very much, Mr. Wanger. It's a great pleasure to accept this award for the entire 20th Century Fox studio.
The chambers of the Florida Supreme Court in Tallahassee, Florida, where in just a few moments 7 justices will file in and begin to hear arguments in the case of Palm Beach County Canvassing Board versus Katherine Harris et al. Now, at issue is whether Florida's Secretary of State has the legal authority to say to 3 counties in Florida that they cannot submit hand recounts of their balloting for the presidential elections, and instead they must stick with the certified totals that they presented to the Secretary of State 1 week after the election. The Gore campaign says that that's not only not fair, but it's an arbitrary reading of the law. The Bush campaign says no, that Katherine Harris is in fact within her rights. Now, here are the ground rules. Each side is going to get 1 hour to present its arguments. First comes the Gore camp, then the Bush camp. However, it's going to be kind of like a soccer match in this sense. The justices at any point may interrupt the attorneys and ask questions. So the attorneys will get 1 hour total to present their cases, but the justices can spend as much time cross-examining either side as they wish. When it's all done, everybody will stand up, the justices will file out, and then at some point we will get a verdict. However, as soon that may be, we just do not know. Now, to give us a little perspective on what we're likely to see and how this is likely all to work, we're going to go to Stephen Grimes, who is a former Chief Justice of the Florida Supreme Court. Justice Grimes, let's begin first by talking about, I know you've talked about this many times, people have made a lot of mention of the fact that 6 of the 7 justices on the court are Democrats. One's an independent. All originally were appointed by Democrats. We need to point out that although once you're appointed, you serve a 6-year term and then you stand for re-election. So that's kind of how this...
That's true, on a yes-no basis.
That's right. So it's not as if there's an opposition, but somebody can be thrown out if the electorate, and it would be an extraordinary circumstance, would decide to get rid of a justice saying that they had not rendered they hadn't provided competent service. On the issue of ideology, again, I know you've been asked this many times. Let's go through it one more time. Do you think ideology is going to play a role in the way the court handles the arguments it's going to receive today?
Well, of course, all of us come to a question with certain life experiences and biases and such as that. But judges are trained and recognize their responsibility to the extent humanly possible to set that kind of thing aside and to decide the case solely on its legal merit.
Okay, Justice Grimes, I'm afraid...
And I believe they'll do that.
Okay, Justice Grimes, I'm going to cut in because the justices are just about to file into the courtroom.
Draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court.
This is Bailiff Wilson Barnes, who is introducing the justices who are now filing in. The 7 justices, by the way, are Chief Justice Charles T. Wells, Leander Shaw, Major Harding, Fred Lewis, Harry Anstead, Barbara Perriente, and Peggy Quince.
Ladies and gentlemen, the Florida Supreme Court. Please be seated.
And Chief Justice Wells will speak first.
Good afternoon, ladies and gentlemen, and welcome to the Florida Supreme Court. The court is certainly aware of the historic nature of this session and is aware that this is a matter of utmost and vital importance to our nation, our state, and our world. And we ask that during these oral arguments that we must expect everyone to remain in order during the entire time that we are hearing oral argument today. We would expect that we will have, at the end of the appellant's initial argument, a 10-minute recess. And at that point, we would ask you to, if you intend to come back for the remainder of the argument, that you remain in the building and really in the courtroom, except to use the restroom facilities. And that will facilitate us getting back to the argument immediately after the recess, and also anyone who leaves the building, we are unable to allow them to come back in for the remainder of the argument. I would also like for the lawyers to have an understanding that the court, of course, has considered the papers carefully, which each of you have filed. We appreciate the diligence that counsel has taken in getting all of these issues framed and to us. And since we have a limited amount of time here, we would ask that we get right to the heart of the matter as you see it, and because we are fully cognizant of the facts and the procedures that below that have brought you here. So on the papers that the clerk has presented to me, it is my understanding that Mr. Butterworth's counsel will go first. Mr. Barkdale. Please also, counsel, be cognizant of your time so that we are respect the time that's been divided here.
Mr. Justice, Chief Justice Wells, members of the court, please permit me to introduce Paul Hancock, who will present the argument for Attorney General Butterworth. Mr. Hancock is Deputy Attorney General, formerly with the U.S. Justice Department for over a quarter of a century, and a major part of his time in the Elections Department. Mr. Hancock.
Thank you. Mr. Chief Justice and members of the court, I'm honored to be introduced to you by Judge Barkdale. The Constitution of the state of Florida establishes the Attorney General as the chief legal officer of this state. As such, he has primary responsibility within the executive branch of government to interpret our laws. This court has previously referred to the Attorney General as the people's attorney, and I stand here on behalf of the Attorney General in that capacity. I would summarize the views of the Attorney General regarding the issues before this court in this manner. Public officials have a responsibility to count and recognize the votes of all Floridians who voted in this presidential election. Factors such as administrative inconvenience, expediency, or the limitations of vote reading machines pale in comparison to protecting the voting rights of our citizens. And of course, the right to vote includes the right to have that vote counted. That right is applicable to all persons in our state, throughout the state, in each geographic region of the state, as well as to our residents who are temporarily absent from the state, outside of our boundaries, such as the men and women of the military. The Florida Constitution begins with a proposition which we submit should guide the resolution of these cases. All political power is inherent in the people. That means that our citizens are the owners of our government, and the role of public officials is to listen to their voices. We do that in part through public elections. The right to vote is perhaps the most cherished right in our democracy. The real parties in interest to this lawsuit are not the presidential candidates nor the parties that support them.
Mr. Hancock, excuse me for interrupting you, but let me ask you if are you prepared, or other counsel, and I would really like for counsel on both sides to pay attention to a concern of mine that I would like to lead in here to, and that is that we recognize that the election election was on November 7th, and that the recounts have been going on in the county, Broward County and Palm Beach County, and that there is this issue as to whether the recounts were permissible and whether there should be allowed under Florida Statute 102.112 amended certifications based upon those recounts. Right. And what I am particularly concerned about is what prejudice is there to both the voters whose votes are already been certified pursuant to that, and the voters whose votes are within the recounted counties under the total scheme of the state scheme and the federal scheme for the counting of Florida's electoral votes. It seems from my reading we have a continuum from November 7th to some point in December, and that's when my concern is. And so I'd like to sort of get this hammered down to that framework.
Yes, Your Honor, I will address that. The starting point then is determining what the legal standard is, what votes should be counted, when can a county do a recount, and when can it not do a recount, and what are the standards for doing that recount. And that raises the issue of the conflicting opinions that have been issued by the Division of Elections of the Secretary of State and the Attorney General of the state of Florida. The difference in those interpretations of the law, and I want to say to you from the get-go that the Attorney General and the Secretary of State are friends and enjoy a cordial working relationship. The differences here are just professional differences involved with what Florida law means. The view of the Attorney General is that the state has a statutory structure that allows recounts in certain circumstances. Those circumstances are described by statute. A candidate can request a recount in a county. The county officials then have the discretion to determine whether to allow that recount. If they exercise that discretion, it begins, as you know, with a sampling of the votes that were cast, reviewing at least 1% of the votes that were cast to see whether that sample indicates that there may be a problem in the county. If the sample indicates that there may be a problem in the county officials, according to the law, have options to select from. And
Is the Secretary of State involved at this point of the counting? Once a request is made, does the Secretary of State play a part at that point?
No, Justice Quince, the Secretary of State does not. The Secretary of State has very narrow authority in the conduct of elections. The law provides that counties conduct the elections. They submit those returns to the Secretary of State, and pursuant to the Florida statutes, the Secretary of State or the State Canvassing Board cannot look beyond those returns.
Is the right to a manual recount a right solely created by statute, or is there a common law right that the citizens of this state have to request a manual recount?
Justice Perante, citizens don't have the right to request a manual recount, or we might be recounting forever. But candidates do have a right, pursuant to the statute, to request a manual recount.
Well, absent the statute, is there a right that would have existed, for example, prior to 1989 when the particular manual recount statute was enacted, to have requested a manual recount? And the reason I'm asking that is because we're talking about rights of voters, yet the scheme puts the discretion as to whether to allow the recount, even the very first step, with individual boards. So already you have a situation where there can be lack of uniformity from county to county.
Yes, and again, we do have a situation where a substantial amount of discretion is delegated to the counties. That's not unusual among the states. In fact, the one case I would cite to the court is the Raudebusch v. Hartke case that was decided by the United States Supreme Court in 1972 involving the senatorial election in the state of Indiana, in which Vance Hartke won. That was a very close election. It triggered a candidate requested a recount in one of Indiana's 92 counties. That was the issue that went before the United States Supreme Court. And in deciding that case, the United States Supreme Court noted A recount is an integral part of the Indiana election process and is within the ambit of the broad powers delegated to the states by Article 1, Section 4 of the United States Constitution.
Mr. Hancock, let me ask you that if I could refocus on the question that I was asking before, is that there's the recount provision, which we recognize in the statute that gives the county's canvassing board that opportunity. There's also 111, or 112, which says that there is a 7-day time period upon which those must be sent to the state. Really, and that was done, as I understand it. But the question really revolves around amended certifications.
Right.
Now, my question is specifically, what is the Attorney General's position as to the date in December that the Florida's electoral votes would be prejudiced or not counted in the Electoral College if there is not a certification by the Department of State under 103.011? What's the date, the outside date that we're looking at in which puts Florida's votes in jeopardy?
December 12th, Your Honor, is my understanding. The Electoral College meets on December 18th. The issue, and we have constitutional law professors here who can address this, but my understanding is it's December 12th.
Okay, now if it's December 12th, under Title III of the U.S. Code, in that Section 5, it seems to indicate that in order for that December, that 6-day provision to have meaning, that all contests and controversies concerning the state votes must be resolved in order for the state's resolution to be final. Now, would you fit that provision of the federal statute into the Florida provision so that we would have some guidance on what is really the prejudice?
Well, we don't know what contest will arise. I think what this points to is the importance of this court using the full reach of its authority to establish procedures that ensure that this results in a process that, first of all, is fair, that is perceived as fair to the world, and in fact is fair, that it counts the vote of all people who attempted to exercise that vote. At the same time, in light of the schedule that we face, I think it would be appropriate in the court, and I refer the court to State versus Haskell, a 1916 decision of this court, in which the court expounded on its broad jurisdiction to correct election returns. If it doesn't correct election returns, elections are determined by county officials, not by voters. So it's important, we submit, that the court use the full breadth of its authority to establish the standards that will judge the counts that are going on, what votes should be counted. Perhaps the court should consider how they should be counted, and to put the county officials under some timetable so that...
Let me return to a more mundane statutory issue and invite you to tell us what you perceive to be the purpose of the statutory provisions that require the Secretary of State to give local election officials opinions about the statutory scheme for elections and election issues, and then bind those officials to follow those opinions. What do you perceive to be the purpose of those statutory provisions and their effects here?
The purpose, Your Honor, is to provide uniformity and guidance to county election officials. We don't dispute the authority of the Secretary of State's Division of Elections to issue those opinions. However, we do suggest that in reviewing that, the actions of the Secretary of State in issuing those opinions, that review here is de novo. It's not merely abuse of discretion. The question is whether she applied the correct standard of law. And I will, if I may quote to you, A long time ago, Justice John Marshall talked about the use of discretion in applying it to district courts, and John Marshall was reviewing a subpoena issued in the Aaron Burr litigation, and in talking about discretion said that, but a motion to its discretion is a motion not to its inclination, but to its judgment, and its judgment is to be guided by sound legal principles. Our concern with the Secretary of State's interpretation of Florida law and everything that followed from that interpretation is that it was not guided by sound legal principles. It's flatly wrong. It elevates the machines over voters. We have a situation in Palm Beach County where the election officials reported that 10,000 people, 10,000 ballots, did not record a vote for president. Now that should raise an issue. I mean, maybe people went to the polls to vote for the speed train, but the logical assumption is that most people who went to the polls were there to vote for president and vice president. And if 10,000 ballots don't have a vote for president and vice president, that raises an issue of what should be done. Fortunately, our state has a procedure for dealing with that, and that's the recount procedure. We submit to the court, and it's plainly set forth in the statute, that in that recount, county officials should look at those ballots to discern the intent of the voter. That is a standard that's in the law, that's in lockstep with every decision of this court for over 100 years on how we review election returns and how we review ballots.
But there's also a provision of that statute that says it should be done within 7 days.
Yes, Justice Harding, there is. And there's the following section after that says that the first section you cite says they shall be done in 7 days or not counted. The next section says they may be counted if they're not done in 7 days. So there's a conflict. We submit that the election laws have to be read in their totality. Yes, counties should get their returns in 7 days, and they should work hard to do it. But the law also has provisions for recounts, and the statute allows at least 3 days for a candidate to request recounts. It then requires a sampling of ballots. It then requires, if a problem is found, a full recount. Now,
if we knock out the 7 days, as you are suggesting, and we cut off the time limits, and then we're to set an outside barrier beyond which this section, or these sections of the statutes govern statewide election, gubernatorial elections as well. They don't have to, I think the absentee ballots from overseas don't have to be counted in those in 10 days under federal law for a presidential election. What do we do with this statute if we reconstruct it, or as you are suggesting?
Well, again, Justice Harding, I would suggest that the law needs to be read in its totality, that it's not physically possible under this law. And it's not surprising that this issue has arisen in our most populous counties, where it can't be done in a week. It's simply under the statutory schedule, it can't be done in a week.
Is that really something that we have in the record, that it can't be done? And what is the significance of 7A that requires as many county teams as necessary to manually recount? What evidence in the record is there that it couldn't be done in a normal situation, understanding there's here some claims that there was obstruction, but what evidence do we have that it couldn't be done within a 7-day period?
I don't know that there's any evidence in the record. I think it's intuitive that with this big a task, and to us, to the Attorney General, the important part is recognize the voters' rights. If the Secretary of State refers to the problem as voter error, I submit to you that if a voter punches a hole in a ballot to indicate their choice and the Chad simply doesn't fall off for one reason or another, that is not voter error. That voter has cast a vote.
Mr. Hancock, I think your time.
Yes, thank you.
Thank you very much. Mr. Rogo.
Mr. Chief Justice, and may it please the court. A week ago Sunday, the Palm Beach County Canvassing Board, around 2:30 in the morning, voted to do a full manual recount after having done the initial 1% recount and determining that the figures extrapolated could have affected the outcome of the election. And they began that manual recount.
As a part of your presentation, would you explain what prompted the board to ask for an opinion from the Secretary of State?
There was concern on the board, at least from one member of the board, as to whether or not it was proper to do a full manual recount. And so that member of the board posed that question. The board then voted to ask the Secretary of State for the opinion. Excuse me. And when the opinion was received, of course, the opinion was that there was not a right to do a full manual recount. But
prior to that opinion, had there been precedent in Palm Beach County for performing manual recounts in cases other than machine error, such as in close elections?
Justice Parente, I don't know the answer to that question of whether or not full manual recount. Certainly nothing on the scope of this had been required before in Palm Beach County. But there was no question in the board's mind that given the figures that they had seen, that the full manual recount was the proper decision for them. They made that decision, and then, of course, the full manual recount was stopped when the Secretary of State said that there was no basis for it.
Well, was the concern that there was, with the question of what an error in vote tabulation meant, or was the concern as to whether the error in vote tabulation could affect the outcome of the election in requesting in looking at the statute?
Justice Parente, I don't think the concern was so much with what vote tabulation meant as it was with the fact that maybe there could be an argument made that vote tabulation was something other than the kind of error that they were seeing. They were seeing, obviously, in that 1% recount, that people had voted, and they could see that the chads had been penetrated, and therefore they could discern the intent of the voter. And having done that, they decided then to move on to the full manual recount.
Justice Lewis. Mr. Rogo, do you have a suggestion or an interpretation for us to give meaning to the entire statutory scheme? Because we've got the 166 recount, but we also have the 168 section for contesting those results. And if this recount extends up until the eve of the reporting for the Electoral College, then we would then write out, would we not, the provision for contesting what has occurred during this recount.
Justice Lewis, I don't know if you're asking me that as an officer of the court or as the counsel at this moment for the Palm Beach County Canvassing Board, because I'm in a kind of an interesting position. The Canvassing Board filed this in the nature of an interpleader, this initial writ, and we really are not taking a position on the merits, the dispute between the Attorney General and the Secretary of State. We will follow whatever this court says the law is. And so I want to preface my answer by saying that I
think since you have a limited amount of time that you ought to direct your attention to the issues that your party has. And I would ask one of the other counsel to note Justice Lewis's question and address that.
Yes, Justice.
It's an important question.
Did the canvassing board ask for the Attorney General's opinion?
No. No.
How did that come about to your knowledge?
It was provided, I think, that a request had been made by other people for the Attorney General's opinion. And the Attorney General's opinion then, of course, became extant and known to the Canvassing Board. I think from the Canvassing Board's position, the question is this: does the recount count? Several hundred people have been working thousands of hours, several thousand hours in doing this recount, Democrats and Republicans. It's being done in a way that is open, absolutely open to the public. It's televised, as a matter of fact. It is tedious work, but it is being done tenderly by the Canvassing Board with care to try to protect the votes of the voters of Palm Beach County.
A certain point, Mr. Rogo, when the Secretary can cut off the recount. For instance, if it would affect her getting the votes in to the Electoral College to be counted, could she cut off the recount?
I don't think she could cut off the recount on that basis, Justice Shaw. I think that what's interesting here is, of course, the certification which we made after 7 days is really only a partial certification, because the absentee ballots are not due until 3 days later, 10 days after the election. So the process is an open, ongoing process, and we think that the time, of course, is there to complete the process.
Do you think she has any discretion? All of her duties ministerial?
Now, Justice Shaw,
that's the way you see it.
Now, Justice Shaw, you're placing me in an area in which I think I should defer to counsel for the participants.
Thank you, Mr. Rogo. The Broward County Canvassing Board, Counsel Mr. Myers.
Thank you, Justice Wells.
Mr. Myers, let me get directly to the method by which I know you've raised in your brief that there's some issue as to the standard, and then that's been changed since you filed your reply brief. What I am particularly interested in the counting that's going on in Broward County, do we have a situation in which there are certain votes that are going for the vice president and certain votes that are going for the governor, about which there is no contest, and a vote in the middle in which there is a disagreement?
Yes, sir, that's correct.
So are those votes being separated so that we know which votes are in the middle?
Yes, they are. They are being held separate, and initially the canvassing board in Broward County had used what we call the two-corner rule. So they went through the ballots, and they initially just determined intent based upon two corners of the Chad being removed. If they didn't find that, they kept the contested ballots separate. And based upon their decision yesterday, they intend to go back just for process purposes. They don't want to start applying the new standard now until they finish going through and making the first cut.
Was the two-corner rule that you've just announced or stated that the Broward County Board is following, was that a standard that was in existence as of the date that this election took place, or is this something that has come up after the fact?
Justice Pariente, this is something that came up after the fact based upon, as it turns out, what we believe to have been an early review of what the law requires.
Well, has Broward County before this date done manual recounts? And if so, what standards did they apply?
I'm not aware of manual recounts, ma'am.
Would you address Justice Lewis's question, if you could, as to how 102.168, the contest statute, fits into this, where there are amended certifications, and can you contest at the point in time after the amended certifications?
Mr. Chief Justice, what I would prefer to do would be to defer to somebody who could answer that better than I can. What I'd like to try to bring to the court is our perspective in Broward County. And Justice Pariente, you asked a question that I can answer, and I know other people can't. So I'd like to stick to those issues, if that would be okay, sir.
Thank you.
You raised the provision about the number of counting teams, and the implication, if it wasn't directly stated in the Secretary of State's brief, is that we could just increase the number of counting teams and use our resources in order to get through this in 7 days. That's not true, Justice Pariente. What happens is that we can have as many counting teams as we can find, and in fact, we have a bunch of them in our Emergency Operations Center. But after the counting teams go through their decision-making process, all of the ballots then go to a 3-member canvassing board. And the canvassing board is 3 members, whether it's a tiny county or it's a county the size of Broward County.
When you say all the ballots, I thought only the ballots where the question of the voter's intent needs to be resolved.
No, ma'am. Actually, all of the ballots, it's my understanding, are going back there. What they're doing is they're confirming the vote, and then they're making decisions where there's a contest. So basically, they're double-checking. They're actually manually recounting every ballot, I believe, 588,000. And then where there is a challenge or a contest, they're actually looking at each of those ballots. They can only proceed as fast as 3 people can proceed. And in Broward County, the counting teams are far ahead of the 3-person canvassing board.
There was a representation in one of the briefs that the counting in Broward County would be completed as of today. Is that not accurate?
That is no longer accurate, ma'am, based upon my understanding. That was based upon applying a mechanical 2-corner rule. And we're going to have to go back based upon what we believe is a correct interpretation of the law to discern the intent of each ballot from the totality of the ballot.
Isn't there something unusual about changing the rules in the middle of the game?
I don't think so, Justice Harding. I think the important thing is that we do what's right at the end. And this has been an evolving area since
But you made a deliberate decision as to how you're going to count them. You started out counting them that way?
Yes, sir, we did, but at the same time, we kept the ballots separate in the event as information unfolded. And Justice Harding, since that time, we've received direction from both Judge LaBarga in Palm Beach County and from Judge Miller, who's handling a case for us down below, both of whom stated that our two-corner rule wouldn't be valid. So, and that's consistent with our understanding of the law.
Not valid. You mean too restrictive?
Too restrictive, ma'am. Our members of our canvassing board have stated that they can determine the intent of ballots in ways other than the two-corner rule. And in fact, there are ballots that are not presently being tallied for one side or the other from which they can determine the intent.
Thank you, Mr. Myers.
Thank you very much.
Counsel for Vice President Gore will be next. Mr. Douglas.
Mr. Chief Justice, members of the court, I'm here to introduce the speaker today who will argue the case for us, Mr. David Boyes from the state of New York. Mr. Boyes.
Thank you. Mr. Boyes.
May it please the court. Let me begin by addressing Justice Lewis's question as to how you reconcile a protest under Section 166 with a contest under 168 and how that all happens within a time frame that allows both to coexist. First, if you look at Section 102-111, it talks about having the returns come from the county by 5 p.m. 7 days after the election. It then talks about, separate term, the official returns. After the official returns are in, you have a certification and then a declaration of the winner. So you have the returns, you have the official returns, followed by a certification and then a declaration of the winner. In this particular case, the declaration of the winner would be under 103.011, which is the declaration of who are going to be the electors. And under the statute, the 5614, 101-5614, it talks in subsection 8 about the official returns, including not only the machine count, the initial returns, but also the absentee ballots, which obviously are coming in after the 7 days, and the manually counted ballots, which are coming in after the 7 days. So we believe that if you read all of those sections together, what you have is a requirement of the counties to come forward with their returns 7 days after the election. That those returns will then be supplemented by manual recounts, by absentee ballots, and then there will be an official return. And that official return will then be certified. And at that point, we believe 168 contest takes place if there's going to be one.
How do we know?
Go ahead.
What I'm concerned about is the timing. Let's assume that the absentees and recounts come to the eve of reporting day, and there is insufficient time, just as a matter of fact, to conduct a contest. So then, are we not eliminating 168 from our statutory scheme?
I think you would be if that happened, Your Honor. I think there are 2 points. One is, I think, the same basic standard for the protest is the same basic standard for the contest, except that you don't have to worry about the timing of when the county is
Mr. Boyce, let me focus back in following up on Justice Lewis' question, is that if the counsel for the Attorney General is correct, and December the 12th is the date by which the certification has to be made for the Electoral College. And as I read Section 5 of the U.S. Code, that what that date means is that all of the controversies and contests in the state have to be finally determined by that date. Okay? Do you agree with that?
I do, Your Honor.
Okay. In order for them to be conclusive in the Electoral College. Now, if we have then contest under 168, or we have this protest going on in Broward County, for instance, where they've got some votes in the middle. And how is it going to work within that time period for the votes to get totally recounted? And then if Governor Bush wants to contest that, for him to get a contest finally resolved? Or isn't it, I'll pose my whole question, isn't it something that the Secretary of State, as the person who has to do the certification, should separate out those that are uncontested on both sides, and then with the ones in the middle, there would have to be a determination made in the final certification as to whether there was you could get that finally determined or not, and how many votes you're talking about, and whether those votes in the middle would actually cause the election to be different. Do you get my drift?
I do, Your Honor, and I think I agree with maybe one exception, and that is the court talked about the Secretary of State dealing with the votes in the middle. I think that under Florida law, those are first counted by the county canvassing boards, and then there is a judicial question as to whether those votes have been properly counted, but that is not a question for the Secretary of State. I also think that this court certainly has the power to say, what we're going to do is tell the county boards that you've got this amount of time to complete your recount. And at that point, those votes are then subject to being contested by Governor Bush or Vice President Gore, and those contests then take place in a time frame that allows everything to be completed by December 12th. So I think it is clearly within the power of this court to say, in order to meet the date of December 12th, you've got to have all of your votes manually counted that are going to be included in this initial certification by a particular date, and then the contest, if there is one, takes place between that date and December 18th.
Do we have information in the record that can guide us? Do we know how long it's going to take to do these things? Or are we just going to reach up from some inspiration and put it down in paper?
Your Honor, I think it is in between. I think there's some information in the record, but to be completely candid with the court, I believe that there is going to have to be a lot of judgment applied by the court as well.
And is this not something that the legislature tried to do in setting these time limits when the vote should be in and set up some reasonable, or what you contest is not reasonable, but some procedure, and isn't that what they've done?
I don't think that's what they have done, Your Honor, because if you look at sections 102.111 and 102.112 together, just those two together, even leaving aside the manual recount provisions, what you see is that the legislature is saying you must get your returns in by 7 days. But then the official returns, and there's nothing in that statute that says the official returns have to be completed by 7 days. Then the official returns, as defined in statute, to include the result not only of the initial returns, but of the manual recounted votes and of the absentee ballot votes that are not included in those first 7 days. I think when you see those provisions, even if you leave aside the manual recount provisions, you've got a statutory system that does not contemplate that 7 days brings down a curtain.
What is the time limit then?
Well, Your Honor, if I were sitting in your chair, that would be a difficult question for me. It is an even more difficult question standing where I am.
Well, it's also difficult for us because this statute governs statewide election and not necessarily only presidential.
It does, Your Honor, but in a statewide election, you don't have quite the same problem. In a statewide election, if you put off the decision, you are not disenfranchising the voters or potentially disenfranchising the voters, as you may be in this case because of the federal deadline of having the electors selected. So this is a situation that is different than the usual situation that the court confronts. And I think that if you, picking up from what Justice Lewis said, if you work backward from how much time do you realistically need for a contest, that amount of time, working back from December 12th, could guide the court in determining what was the outer date from the time that the recount had to be completed.
Justice Shaw.
Why shouldn't the Secretary of State be the person to set that date instead of a court? Why couldn't the Secretary say that this is the time frame that I need in order to fulfill my duty of getting the certification in and set an arbitrary date?
But Your Honor, the Secretary of State's function is a ministerial function. She is not going to be the person who presides over the contest. The contest, if there is one, is going to be a contest that is going to be before the circuit court and ultimately before this court.
However, Mr. Boyce, that brings us to the may ignore language in that statute. And wouldn't you have to agree that the may ignore does connote some degree of discretion? And why isn't that discretion set on the basis of that she may ignore them if they're going to, if the acceptance of the amended certification would prejudice the other voters whose votes would be certified because they were already there and get timely counted in the Electoral College?
I think, Your Honor, you could say, and this is not that different from what we have argued, that as long as the manual recounts will not impair the final certification in time to permit the selection of electors by December 12th, that those manual recounts must be included. That is, the Secretary of State's discretion, to the extent that she has any, would be discretion to say, I need to have the results by this particular date in order to be sure that the results are included by December 12th.
If that's the case, then should we be trying to determine also this whole issue about the faulty chads? Because I would assume that that would be a part of any contest that would be made of the recount. But if we're worried about this time limit, is that something that we should be concerned with now, and is it squarely before this court now?
Your Honor, I think it is squarely before the court, and I think the court must be concerned with it now, because I think that given the particular deadline, the wall that is set up by the federal provision, that this court needs to act expeditiously to set the standard, because we don't frankly have time.
And where would we find case law or whatever to tell us what this standard should be?
Your Honor, I think you find it partly in Florida law, but I think you can also find it from the laws of other states that have dealt with these very same questions. If you go back into Florida law, the test has always been the intent of the voter. And that is written into Section 166, the manual recount provision. It talks about first the counters and then the canvassing board looking at the ballot to determine the intent of the voters.
So if that's the case, would it be your, would you be telling this court that any mark made by the voter would be evidence of that voter's intent and should be counted as such?
I think so, Your Honor, and that is really what for example, the Delahunt decision that we cited in our papers from the Supreme Court of Massachusetts, or the Illinois cases that we cited, or a number of the other cases that we cited have expressly held. That question has never been before this court directly, but that has been dealt with in the cases from other jurisdictions that we've cited that we would hope the court would find persuasive. In addition, we cited, perhaps for obvious reasons, the statute from Texas, which provided statutory guidelines for defining that.
Is the uniformity of how these manual recounts are conducted essential to the integrity of the process or also to the constitutionality of the statute?
Your Honor, I think it is important to the integrity of the process. I think if you had very wide variations, you could raise constitutional problems.
Well, for example, if right now in Palm Beach County, chads that are not detached at all, but I guess are these dimpled chads are being counted, but in Broward County they're not counted, then does that say that one vote is being counted in one county and not in the other? Is that, if that's an argument, then what do you say to the Governor Bush's argument, the Secretary of State's argument, that for those counties that did not have manual recounts but also have punch cards, because I guess not all counties have the punch cards, that if those votes did not get manually recounted, that is unfairly giving certain counties a greater voice in this election than other counties?
Well, the first thing, Your Honor, is that any candidate could have requested a manual recount in any county. So that the manual recount provision is something that by statute is given to the candidates. And wherever there has been a manual recount requested, the counties have gone forward, and indeed some of the results that have already been certified have been results that included manual recounts.
Do we know in Volusia County whether they used, what standard they used? Is that in the record?
I do not believe that is in the record, Your Honor. I would say that I think that for the reasons that you point out, it is quite important that this court be as specific as possible in terms of the standard to be applied so that we will have uniformity. I also think, Your Honor, that if you concluded that it was essential to avoid unfairness or some kind of overweighting of one county's vote over another county's vote, this court has within it its equitable power to have a statewide recount if you concluded that was necessary.
Along that line, I take it then, if this court should hold that the 72-hour, the 7-day period was not specifically enforceable, then you would say that there should be a window of opportunity for both sides to request recounts in additional counties?
I think the court has the power to order that if it believes.
Well, what is your position on that?
Your Honor, we don't think that's necessary because. So
would you try to strictly enforce the 72-hour provision of 166?
Well, the 72-hour provision in 166 had already passed by the time that the 7-day period had passed.
But the certification had not.
But the certification not, Your Honor. And it was for that reason that Vice President Gore informally, obviously he didn't have the power that this court has, but informally proposed, as the court may or may not be aware, that he would be prepared to accept a statewide recount. We are not urging that upon the court, but certainly that is something that we've indicated that we would accept, and we believe the court has the power to order that or to order, as the court suggests, a window.
Well, how do you think a statewide recount would impact on the whole idea of getting these things done before December 12th, is it? And aren't we just adding another layer if we order a statewide recount?
You could be, Your Honor. However, since the recount takes place county by county, it will proceed in parallel. And since the most populous counties are the ones that are already underway, we believe that those recounts, it would be practical to do those recounts if the court felt it to be desirable.
What would be this court's authority to open up this window of opportunity when it has not been requested within the time frame?
Your Honor, that was the hesitancy on my part in answering the Chief Justice's question. I believe that the broad equitable power that this court has under the Constitution to assure that the election results really reflect who got the majority of the votes or a plurality of the votes would enable the court to do that. the deadline has passed. I think particularly if you had a situation in which both candidates were prepared to accept that, you would have a situation in which the court would have the power.
Previous question, you indicated that you thought the Secretary could set a final date to certify, provided if it would interfere with her doing getting the vote in to the Electoral College on time. Would she have, what would be her burden to justify this? Could she just say, I need 10 days to get the vote in and arbitrarily set that? Or could she say, I need 30 days and completely close it out?
Well, Your Honor, this court is, I think, experienced with reviewing the exercise of discretion in lower courts. And I think that when all is required is a ministerial act of preparing the papers to declare the winner, I would think this court would hold that that did not require very much time.
Well, you keep referring to it as a ministerial act, but isn't there under 103.011, doesn't the Secretary have a duty to protect Florida's electoral votes by getting the certification made?
Yes, Your Honor. And what I meant to be saying was that in order to get that certification made, she needs to have enough time to make that certification. But the fact that the certification is a ministerial act doesn't mean it's not important. It simply means that it's an act that, in our view, can be done relatively quickly, that she doesn't need 5 or 10 days to do it.
You're in your rebuttal time.
Thank you, Your Honor.
So I think the time has now arrived when we would take our 10-minute recess. I would announce, Mr. Hancock, that the marshal says that the clock went off 3.5 minutes too soon for you, so you will have that amount of time of rebuttal. Thank you. And we'll be in recess for 10 minutes.
So there you have it. The Florida State Supreme Court is going to be in recess for 10 minutes. On the other side, attorneys representing the interests of Texas Governor George W. Bush are going to present their case, arguing that Secretary of State Katherine Harris, in fact, has the authority and maybe even the duty to make a deadline for when we count votes in the state of Florida, or when the state of Florida does its vote counting. Now, sitting next to me during all this is Paul Rothstein, the law professor who can try to make sense of what we've just seen. What really was fascinating for those of us who haven't watched this court before was how the justices cut right through all the big speeches the attorneys had prepared and immediately started peppering them with questions. And at least 2 themes came forward, maybe 3, and let's talk about them. Number 1, there was a lot of questioning about December 12th, which is the statutory deadline in Florida for selecting electors to the Electoral College. What do you read into that, if anything?
I think they are concerned about time. Also, I think they would like to find some kind of time cutoff so they can avoid the difficult judgment. You can never be sure that they're not just trying to gather ammunition from, for example, Mr. Boyes, who's arguing for Mr. Gore, so that they can ultimately decide in his favor. In other words, when they're very skeptical about somebody's argument, maybe they're just trying to find out, gather ammunition. But I think they are concerned about time, and there is an indication that they think Boyes' system might be impractical.
Okay, Boyes' system, by the way, was the court had it within its own power, even though there's no specific legislative warrant, to say, let's recount the whole state.
That's right, because several of the justices seem to be concerned that if the different ways of counting the Chads in the different counties is inequitable, then any recount in selected counties is inequitable with respect to those counties that aren't being recounted. So they've kind of turned Boyes' argument around on him. So he, in order to answer that, he said, well, if you like, recount all the counties, but that makes it even more impractical to meet the deadline, although he thinks you can meet the deadline.
Because they would be counting in parallel. One of the other things he said was, since there is no clear legislative language to determine what is and is not a valid punch card ballot, that the court also could make that determination.
Yes, that's a late comer to the argument. That was inserted over the weekend, that not only is this court going to decide when and under what conditions the Secretary of State can call a halt to the recount or not count the recount, but they added now, if the recount proceeds, what should be the standards for the recount. Three-cornered chads, halfway chads, pregnant chads, dimpled chads, what should be the standards?
Let's bring in Stephen Grimes, former Chief Justice of the Florida Supreme Court. Justice Grimes, you saw there that attorneys were asking the Supreme Court to use its, quote, broad equitable powers to basically expand state law to create recounts beyond the legislative deadline, and also for the court to hand down standards for what would count as a legitimate ballot and what would not. Is that an extraordinary kind of request of the court, or is that an ordinary request?
Unusual, yes. You know, and one of the problems I guess the court would have is they would be a little concerned about their expertise in deciding whether a dimple chad was good as contrasted to a two-edged chad, or whatever you call it. Of course, Mr. Boys makes the point that they need definite standards, and certainly the court would think that if you're going to get into that, they ought to be uniform. They were concerned, I think, by a question that one county was using one and one was using the other. Mr. Boyce said, well, you ought to set down those standards, but that wasn't precisely the issue, I think, that the court thought that they were going to be faced with going in.
Justice Grimes, also one of the issues that came before the court was whether the Secretary of State's duties in this particular case were purely ministerial. David Boies was arguing that basically all the Secretary of State has to do is add up the ballots, you know, declare a winner, and that's it. She just has, her job is basically to do addition and to sign a sheet of paper. Is that, in fact, the limit of the authority of the Secretary of State?
Well, you know, it's an argument that you know, that they can make. One or two of the questions questioned whether or not really under the statute there wasn't some kind of discretion. Certainly Judge Lewis, a trial judge, had held that she had discretion, but it had to be controlled discretion and couldn't be arbitrary discretion. And Mr. Boies, arguing for the Democrats, would characterize her role as ministerial. Again, it depends, I guess, on how you interpret the statute, particularly that may, the words may ignore, whether that gives the secretary the right to, quote, ignore those that she felt were not appropriate within her discretion.
Justice Grimes, I'm sorry, go ahead.
Yeah, the judges still have to interpret those statutes and see how they mean, see what they mean. They were also interested, of course, in if they allowed the recount to go forward, when, you know, I'm confident they don't want it to go into next year, and they're concerned that if they were not, if they had a recount, certainly there'd have to be an outside deadline, which at least the council so far would say would be December 12th.
Okay, Justice Grimes, one final question. You just mentioned that they want to get everything done by December 12th. Another part of the argument is that all appeals have to be completed by that time. There was talk of appealing this to a federal circuit court and even to the United States Supreme Court. Is that the kind of thing that is going to enter into the justices' thinking? Are they trying to calculate right now how long it would take to exhaust all appeals and whether that would be the basis on which this entire case might hinge?
Well, I think they would know that if all of the appeals went the normal process and there wasn't some deadline, that could be a year or two off. And they also know that that's just frankly an impossible result, I think.
Okay. Former Supreme Court Justice in Florida, Stephen Grimes, actually Chief Justice, thanks for joining us. We're now going to go to West Palm Beach, Florida, where Carl Cameron is standing by. He's going to help us preview the Bush team strategy when it begins to argue in court in a little fewer than 5 minutes. Carl?
Hi, Tony. Well, there are a number of things that the Bush team, the attorneys, will actually make. First of all, they will say that Secretary of State Katherine Harris was reasoned and reasonable when she sought to enforce the deadline for the absentee ballots from overseas on midnight and the original deadline for the certification of the mechanical recounts more than a week ago. They will say that she was within her rights and that she did not act arbitrarily by enforcing that deadline. They'll then get into an argument over whether or not it's actually fair for these 3 Democratic-leaning counties to be conducting manual recounts, whereas 63 or 64 other counties in Florida are being uncounted. There are a number of arguments that they will make, principally that the manual recounts are unfair and not as reliable as the mechanical recounts.
Okay,
Tony?
Carl, we got to cut you off because the court's back in session.
Is the first respondent represented by Mr. Glock.
Thank you, Mr. Chief Justice. We are also representing the Canvassing Board and Commissioner Crawford, who is here as well.
Okay, that's the Elections Commission Canvassing Board under the Chapter 102.
Yes, and for ease of confusion, perhaps, Mr. Chief Justice, we can refer to as the Commission. I think if I could start with something that I think is a point that needs to be addressed. I believe that the problem that is created here, really, and as the questions of the court go back and forth, you can see it. The difficulty that we have here is not really a legal problem, it's a political problem. We have a 2-tiered process in Florida as far as election returns are concerned, and that has to do with, first, the counting and the certification of ballots, and the second is the contest. And most of what you are being asked to deal with today is the problem that is created by the contest. And if you think about it, it creates an enormous number of problems as far as the court is concerned, a number of which have been addressed by the different justices. But if we start out from the point that what we have here, the Secretary has certified the first election returns that came in, then in between that time and Saturday, when she probably would have certified along with the Commission the overseas ballots, the stay was entered by the court and naturally is respected by both the Canvassing Board and by the Secretary. But the fact of the matter is that until such time as the certification is made, the process of contesting the election cannot stand. The question raised both by the Chief Justice and by Justice Lewis, which is what is the impact of the 2 statutes, is very clear. Mr. Boyce said that, it's all kind of one thing and you can really handle it one way or the other, but that's not true. For instance, the whole issue of the overseas soldiers' ballots can't be resolved until such time as the election returns are certified and a challenge can be made as to whatever standards are being used to not include those ballots. There are a number of other things that can't occur until that happens, and then the suggestion that the Supreme Court can set a date, although they're not willing to even suggest to you what that date should be, comes back to the point that what is it that they really need to have happen here? For the Secretary to be successful, all that has to occur is that the court lifts the stay and affirms or simply lets sit Judge Lewis's order. For the petitioners here to succeed, a number of things has to occur.
But Mr. Glock, let me get you to my concern.
Yes, sir.
Quickly. The concern that I have is that it's not that we have a long-standing policy out of other courts of this state that say that the real parties in interest here are the voters. Now, what I want to know is that and this 112 has a provision which says that some voters' votes may be ignored. And what I am concerned about is in what is the boundaries on which the Secretary or the Commission could exercise its discretion and have those voters ignored. And I pose to you that in this particular presidential election, doesn't it revolve around the Electoral College and the fact that the prejudice that's involved here is the prejudice of not allowing Florida's votes to get counted?
Well, Mr. Chief Justice, the beginning point here is that there are 6 million voters, of course, and the focus here is on 72,000 of them in 3 selected counties. The Attorney General started out by saying that the Attorney General's position is that all the votes in the state of Florida be counted, but that, of course, is not what is underway at this point. The problem with respect to the electoral votes in Florida only occurs if the status quo is maintained, if the votes cannot be certified, if the contest procedure cannot begin.
Well, would they have to be certified today?
Well,
under the federal scheme, is there a mandatory certification today?
Well, Mr. Chief Justice, it's governed by Florida law as far as certification is concerned.
But what I'm concerned about is the ramifications under the federal statutes, which is your opposition says here is December the 12th, or 6 days before December 18th. Now, what I want to know is, on what date does the Secretary take the position that her duty to certify those votes is going to be jeopardized, and what is the basis of that jeopardy if the votes aren't certified on X date?
Respectfully, Mr. Chief Justice, the Secretary is governed by the Florida statutes. She is mandated to certify the election results 7 days after the election, and then to pick up the overseas ballots later. Now, the question that you're asking, I can't exactly answer, because what you're now balancing is the right of the counting process versus the right of the contest process. I can't, Your Honor, I don't know how to answer that question.
Is the rights of those voters who may not have their votes counted if we don't honor the recounted votes, and the rights of those of all the voters who might have their rights denied if the certification doesn't get in within the time limit and on the basis that it will be accepted under Title V of the 3 U.S. Code.
But respectfully, sir, at this point in time, the only bar to that is the stay order that has been entered by this court. If the stay order is lifted, the votes can be certified. Once the votes are certified, then a contest can take place if anyone wants to take a contest, and that may have to be done on an expedited basis. But the fact of the matter is, I'm sorry, sir.
Go ahead.
The fact of the matter is that all of the relief that is being sought here by these folks is basically relief that should be in the context of a contest when it's possible to have a record. A lot of the questions asked by Justice Pariente that have to do with record kinds of facts, there are no answers to, because there, of course, is the most fluid of records in this case.
Hasn't the local canvassing boards followed the statutes in regard to having a request for a recount and then making a count the 3 precincts or 1%? And then making a determination that on that basis a manual recount would follow?
Justice Harding,
they followed the statute.
Justice Harding, the statute basically says is you're supposed to certify 7 days after the vote is taken. If there is going to be a request, if the Secretary has discretion, which Judge Lewis, of course, found that she does, then that discretion has to be exercised either to permit or not permit late filings. Reasons were given to the Secretary. She sent a letter out. She asked for the reasons. They provided the reasons by 2 p.m. on the day after, on Wednesday, I believe, and then she promptly responded after applying them against a set of criteria that she had developed to exercise her discretion.
When did she develop those criteria?
You're asking me as a matter of fact, Your Honor, starting within probably an hour after Judge Lewis entered his decision, she asked for input on the kinds of criteria that would be appropriate for her to exercise her jurisdiction.
Is that rather unusual as for a way for an agency head to come up with a decision in this state to just come up with something within a few hours as to whether to allow something or not allow something?
Well, Justice Pariente, I was kind of refreshed because the agency had actually asked for legal advice on it and what the legal standards would be for her to properly exercise her discretion, and she was pushing against a deadline, so I considered it excellent, frankly.
But she didn't really exercise her discretion. What was said was that a reason that she was not going to recognize as a reason for late filing manual recounts being conducted in accordance with 166. That was no discretion exercised. It was in accordance with her prior legal decision that recounts that were not based on machine errors were not going to be allowed, and that was what she announced the day before.
Well, Your Honor, the decision that the opinions that come out from the Division of Elections, Mr. Roberts' group, is not exactly the Secretary. The Secretary is the one that had the obligation under the statute to exercise her discretion in this case, and what she basically did was she looked at the various criteria in challenging an election, and she looked at other criteria as well, and she said that a manual recount that is undertaken solely to solve voter error is not the kind of thing that is sufficient to allow a breakdown of that deadline scheme. That was the reasonable exercise of her discretion.
So what is the Secretary saying that the reason that these manual recounts were not going to or are not going to be allowed is because they're too late? That is, they were not in within 7 days after the election?
Well, two things, Your Honor. First, what she is saying is...
Is that number one?
Well, as you know, Volusia County complied with 200,000 voters. In 3 days, they did the recount.
So we have within the state's recounts one county that has counted those votes by hand, correct?
That is correct. And Justice Pariente as well, the Secretary and the Canvassing Board have no right to go beyond the certificate that comes from the Canvassing Board. And Volusia County did a manual recount, irrespective of what the Secretary may think legally that the board had the right to do that. Once those returns are certified, neither the Secretary nor the Canvassing Board can go behind them. So this entire problem that we have here today, irrespective of whether you buy into the concept that the Secretary has the right to establish standards and has the right to exercise her discretion, which we believe she does both under the case law and as a result of the order she was responding to from Judge Lewis, the fact is this problem could have been resolved if the people asking for a manual recount, right or wrong, had completed the manual recount within the time period set forth as they did in Volusia County.
So the Secretary then would have counted those votes within the totals if they had been submitted by November 14th at 5 o'clock.
Neither the Secretary nor the Canvassing Board has the power not to, Justice Pariente. They would have to do that. Now, you asked a question earlier as to whether or not there's any history as far as Broward County is concerned. Since, of course, there's not a record, I can't respond there, but of course there is one case, which is the Broward County versus Hogan case, where the issue went up to the 4th District Court of Appeal on whether or not the Canvassing Board's decision not to conduct a recount was within their discretion, and they held it was. So I know at least on that one occasion that they did not exercise their right to conduct a recount. And you have to understand that the position of the Secretary simply has to do with her understanding as to how the statutes are written. If you go back to the 88 race between Senator Mack and Governor McKay, the issue there was the problems that had arisen with the mechanical voting machines. That is the reason why the statutory amendments were created. And if you look through the statute and taking respectful exception to the position of the Attorney General, wherever you see tabulation, they're basically referring to machine or electromagnetic, or however it's phrased, kinds of review of returns and not actual counting, which is referred to differently. But the position of the Secretary is if you look at those statutes, you can't simply pull the one subsection with respect to manual recounting out and pretend it's its own section. The fact of the matter is that the procedure is that if you have an automatic recount, which of course is done mechanically, you can then ask for the candidate and the party, not a voter, can ask for a manual recount. The manual recount, you have to go through the 1% and the 3 precincts.
Does the Secretary, though, play any role in determining whether or not there shall be a manual recount in any county?
Absolutely not, sir.
And so who has the authority and responsibility for that?
The Canvassing Board of the county has the responsibility in response to a request from a candidate or a political party to conduct a manual recount, which is this test.
Well, under the circumstances that we have here, then, isn't in essence the Secretary of State, who has no authority to determine that, overruling a decision by the proper body that has the authority to do that, to do it? Isn't that what the net effect of this is?
To the contrary, Justice Anstead.
Well, if the Secretary is saying, I'm not going to count the recount that started very late in the process and at a time in a large county where effectively the recount could not be completed before the 7 days were up, isn't that the net effect?
Justice, I don't know that the recount couldn't be done in that period of time. And of course, we have no trial record to know whether the recount could be done in that time.
Don't we also end up sort of discriminating between small counties and large counties? If we take Dade County, for instance, and Okaloosa County, clearly there's going to be a vast difference in the time that it takes in Dade County to do that manual recount compared to a small county. Would you agree?
Justice Anstead, yes. May I continue?
Yes.
The fact of the matter is the Florida legislature has all of this in front of it. It has an election code that understands that there is voting, that there's automatic recounting of voting, and that there are provisions for manual counting. They have considered all of that. It is part of the scheme. It has to be done in 7 days.
How do we know that they considered this specific issue with reference to a recount that is not started, for instance, until the 6 days after the election, and that they contemplated that in mandating that everything be in 7 days? How do we know that they considered that?
Justice Ansted, I'm sure they probably didn't consider the fact that someone would commence a recounting whenever they felt like doing it.
The scheme allows for that, does it not? The scheme allows for a request for a recount very late in the process.
The scheme, the fact that something, if you are permitted to initiate something at any point in time, and it has to be turned in at a certain time, that is the same basic rule that I had in high school with term papers. You can start the term paper the night before if you want to, but it is unlikely that you'll be able to turn it in the next day when it's due.
So by giving that right to initiate the recount at that time, that really is an illusory right. In other words, that is not really correct in the statute, that you have that much time before the certification of the results, in other words, to make that request.
You have the 7-day period within which to handle all of the counting of the votes, the initial counting, if you have an automatic recount, and if there's going to be a manual recount. But the other point, Your Honor, that I think is very important to note is that we're not talking about a manual recount on a statewide basis. It's 3 selected counties.
Let me talk about the 7 days, too, and ask for your help, and let's work by way of a hypothetical. Are you suggesting, by the language that has this 7-day deadline, that if we had, for instance, in Dade County, that the election officials down there, after they compiled the vote and everything, and they were the only county outstanding, and that there was gross negligence then, that they all went off on vacation to the islands and just let the election returns sit there, and 7 days passed, and 8 days passed, and 9 days passed, and 11, so on, that the Secretary of State, because of that 7-day rule then, and the gross negligence of the election officials down there, would simply say, that's it, and under the language of the legislature, I cannot count the votes from Dade County, the largest county in the state of Florida, in the election returns. Is that what the position of the Secretary of State is?
I don't believe so. Of course, that's not the situation we're in now.
What is the position?
There's a case.
When we have a week past the deadline of 7 days, we have negligence on the part of the local officials, and they simply have not sent the results up to Tallahassee. What is the obligation of the Secretary of State?
Judge, we don't know that there's a matter of negligence. The court's assuming that.
I'm saying in my hypothetical, to assume it's negligence.
Well, we know from case law, if it's gross negligence, if it's a matter of marking up ballots or something like that, that the court has specifically held that can't be held against the voters. But Justice Ansted,
what would the Secretary of State do? A week has passed past the 7-day deadline. What would the Secretary of State do?
If she hadn't noticed that the Dade County results weren't in for a week, I think as a practical matter, the Secretary of State would be a little bit more proactive, that if the returns aren't in on a certain day, I'm sure inquiry would be made. If it was clear to the Secretary of State that there was gross negligence involved in not getting them in, she's bound by case law to accept them, or, Your Honor, it would be raised in the context of a contest. But if we could get back respectfully, sir, to the situation that we're in here, the situation we're in here was not caused by the Secretary. The difficulty we have here, all we need to do is to be able to certify the election. Once the election is certified, the contest period can begin. The petitioners are trying to conduct a contest proceeding prior to certification, not for legal reasons, for political reasons.
How can a contest occur while the manual recount's still going on? As you just said, we don't know whether there is going to be an issue as to the integrity of how the recount was done. So how can that start before the recount, the manual recount, is completed?
Because, Justice Pariente, you have to read all the statutes together. And one of the clearest things when you look at the statutes is the mandatory nature of certain actions that have to be taken by the Secretary. Not even the petitioners, Your Honor, could come up with some way of balancing between 166 and 168. And what the court is being asked to do is an extensive amount of legislation. I mean, you're going to have to do away with the 7-day rule. You're going to have to abolish 166. You're going to have to do away with the the Secretary's discretion, and then the court enters the great universe of Chad to decide on the record that you have whether or not 2 corners are enough or 3
Well, I
corners
thought you
are enough.
said that the 7-day rule does not apply, that the Secretary of State has some obligation, if this 7-day period passes, to contact the county and now inquire into the circumstances of why the 7 days. And if she determines, for instance, that it's just the negligence of the local officials in failing to send the ballots up, that she can ignore the 7-day time and accept.
Your Honor, I'm not specifically sure what the Secretary would do. All I'm saying is the case law says if it's gross negligence on the part of election officers, that the votes will be counted.
But
we do not have a situation.
7-day period is not absolute then.
No, of course it's not absolute. Judge Lewis ruled that there was discretion the Secretary had to exercise, and irrespective of how we may interpret 111 and 112 as shall or may, we are operating under the ruling of Judge Lewis.
What was the position of the Secretary of State going before Judge Lewis as far as whether or not the 7-day rule was absolute?
Your Honor, from looking at the record, it appears that they agreed that discretion of the Secretary could be appropriate, that the may standard would probably trump the shall standard. That's my understanding of the position that he took. I don't know that that legally is correct. That's the position that was taken, and consequently, when the order came down, they lived with it. And that order, I might add, was perfectly happy. The petitioners were perfectly happy with that until such time as Judge Lewis ruled that the Secretary had not abused her discretion.
Justice Shaw has a question.
I'm sorry, sir.
If the state of Florida has provided a protest procedure, can the Secretary of State exercise her discretion under 102-112 so as to frustrate that procedure?
I'm afraid I don't understand the Justice's question exactly. If the question, I'm sorry, I don't understand the question.
Do you agree that under 102-112 that the Secretary has some discretion? What would be your position? That
I would agree, Your Honor, that based on the record as it is and the agreement of the Secretary to be bound by that, she has the right to exercise discretion after she establishes standards.
Can she exercise that discretion in such a fashion as to frustrate the scheme in which a protest can be lodged?
No, because the contest is under 168, Your Honor, not under 166.
Not a contest, a protest.
With respect to a recount?
Yeah.
Your Honor, all the Secretary can do is she has the right to be able to establish criteria for determining whether or not a late filing will occur. She established those criteria drawn from precedents of courts. She then applied the requests against that and found them to be wanting. As I said before, Your Honor, the entire problem could be solved if the certification had taken place on time because they had complied with the timing. That completely, of course, avoids, I'm sorry,
but
Justice
doesn't
Quinn.
that argument really blur the lines between a protest and a contest? Now, under 166, you can contest returns or protest returns within, the 72-hour period or the 7-day period under 166. Isn't that a completely different procedure from 168, which is the election contest? And it seems to me that your argument is blurring those two procedures.
No, and I apologize if it is, Justice Quince. I think that's exactly the central issue here. The procedure with respect to certifying an election is, as has been said by the Attorney General, mostly ministerial, okay? What has happened here is that
once the certification is done, isn't that when the contest comes in?
Yes, ma'am.
Okay, but
yes.
The protest is a different matter.
But
you don't have to certify to have a protest.
We do not have any kind of procedure under Florida law for dealing with a full-fledged contest kind of action prior to certification. That's the difficulty we have here. And that's the reason why the court is being asked to engage in extensive statutory rewrites and then the entire issue of how you're going to make judgments with respect to these ballots.
Mr. Glock, let me follow up on Justice Quint's question. Why wouldn't it be in this unique circumstance a better thing to do to wait and unless there is a specific reason that's going to prejudice Florida's certification to the Electoral College, wait and see to a point in time when the manual recounts are completed. Allow those amended certifications to be made, and then there will be a point in time in which a determination can be made as to whether the contest in respect to those are going to jeopardize Florida's electoral vote.
Mr. Chief Justice, what you're talking about is making a value judgment as between whether or not the rights of 168 trump 166. On behalf of people, there's no suggestion anywhere here in the record that we have a problem with the voting machines or there was any fraud or anything else. What we're trying to do is to deal with the problem of people who did not follow instructions. The instructions were to put the stylus through the hole in the ballot. They did not follow those instructions. Now, balanced against that is being suggested that the entire contest period should be stood on its head and that the Secretary of State loses her ability to conduct her constitutional exercises. The legislature loses its ability. The Attorney General, for instance, points out all of the states that have elaborate statutes to make judgments on manual recounts. Well, that's wonderful, except the Florida legislature hasn't done that yet. Is this court to do it?
We've had cases dealing with this issue in Florida since the 1800s, and all of them in some way, shape, or form come about because voters do not follow the instructions. And in all of those cases that I have read, when you can look at the ballot, even though it is improperly marked and even though the voter did not follow the instruction, but you can tell the intent of the voter from that ballot, that vote has to be counted.
And Mr. Justice Harding, I would suggest to you that all of those cases that you have seen have been a voting contest. And the difficulty we have here, as I say again, the court is being brought into something it need not be brought into. This is not a legal problem. This is a political problem. If the voting is certified, everyone can then proceed with the contest. The difficulty is the political problem that is created.
How would you proceed, Ms. Locke, that this matter would be resolved? If it is challenged, then we would order a recount, or some court would order a recount?
You could do that, yes, Your Honor. But you have a record, for instance.
Isn't that discretion given to the canvassing board under the statute?
The canvassing board is free to, the manual recounts are going on right now, and I believe irrespective of what this court had said, the manual recounts could go on. They may well be material in a later contest. It doesn't mean that because someone starts a manual recounting process that the rest of the Florida statutory scheme stands still and waits for them to come back from vacation or whatever it is they're doing. And the record shows that in one case, there was somebody off on vacation for 4 days. Miami-Dade has just started today, maybe their count, after having had apparently hearings every couple of days over the last 2 weeks. It is now, at this point in time, we are almost 2 weeks beyond the election.
Isn't part of that, though, that the Secretary of State said you cannot go forward and have this recount?
I think the record shows that no one paid any attention to the opinion of the Secretary of State. Your Honor, clearly in Palm Beach County, they didn't. It's in the record in the circuit court that they didn't pay any attention. And as far as Broward County is concerned, I don't know precisely what they did or didn't do. But the issue here, again, this is of course completely avoids the issue that has not yet been indulged by the court, although it was raised by one of the justices, is how about the folks in the other 64 counties that don't have the benefit of having their ballots flexed and recounted and dropped on the floor and all the other things that are occurring with respect to the ballots in the 3 counties that are being counted.
Thank you, Mr. Glock. Your time is up. For the Election Canvassing Commission, Mr. Bryant, or I beg your pardon, for Governor Bush, Michael Carvin. Thank you, sir.
May it please the court, as the colloquy today indicates, there is a very clear procedure for resolving all the questions that the justices have asked, and that's set forth in the statute. You set a firm deadline, and you make sure that everybody gets their votes in at the same time. And if there are any problems in terms of voter tabulation or the kinds of questions that we've done, you've got to keep to that deadline so you'll have time to do the election contest after that.
May I ask you a question? Does this only come up as far as this interpretation of this 7-day deadline, even though counties are wanting to do manual recounts as requested by the voters in that county, because this is a presidential election? In other words, is this requirement of the deadline on one end, going back to what Justice Wells has been asking, created because of the deadline on the other end?
The this comes up in all. I mean, there's a firm deadline for all statewide.
Well, would you think that we would want to, for all time's sake, interpret this statute that if, for example, in a legislative race, it is a close race and the unsuccessful candidate has requested a manual recount under the statute and requested it on the 6th day, that we would say that because that's not an extraordinary circumstances, it's a foreseen circumstance, that we would say, well, Secretary has the discretion to not recognize that manual recount and could declare the other person winner? I mean, would that make sense in any other context other than this presidential election?
I think your case would be an easy hypothetical. If the losing candidate waited 6 days and gamed the system so that they backed the canvassing board up so they couldn't do a manual recount until they requested it, then for that reason alone, the canvassing board
would... The statute allows up to 6 until certification is made on the 7th day. So the statute, if somebody was exercising their statutory right within 7 days, you're saying that the Secretary on the 7th day said, too bad, I'm not going to recognize it.
Because it's not a statutory right, with all respect, Your Honor. It's an option that they provide to the counties. The legislature has no preference for manual recounts as the most accurate way of determining votes, which is why they make it entirely optional. The only right and duty in the statute is the right of the state officials to have the election returns after 7 days. That is a mandatory duty. And they expressly contemplated that all counties, regardless of whether they were conducting manual recounts, would play by the same rules and get their election returns in on time.
Well, the same rules really don't apply because only certain counties use punch cards, which is really what creates the problems in the 3 populous counties to the south. That's not the same problem with an optical scanner, correct? So there's not uniformity even within the state as to the type of voting machine that is used or the procedures that are used in each county.
We have complained about the ad hoc nature of the way in which votes are tallied in differential counties. That is a problem.
When you say you've complained about it, where has that been complained about?
I'm sorry, in federal court, Your Honor, and I'm not trying to introduce that here. We do.
Let me ask you that question. And is there a constitutional attack on this statute being made?
Well, we don't think you need reach the question, but
well,
yes.
Is that because you're requesting the federal court to reach it and you don't think that the state court has it within its jurisdiction to decide whether a statute is being constitutionally applied?
Oh, no, clearly state courts have that power. I'm simply making the point that there's a much simpler basis for deciding this case than going all the way to the U.S. Constitution, which is state law clearly prohibits the relief the petitioners are requesting because state law makes it quite clear that they have no right to ignore the mandatory statutory deadline imposed upon them by state law. They seek to rewrite the statute to create a scheme that serves their personal problems or conveniences. But in doing so, they posit a hypothetical that cannot be found in the statute. In other words,
Mr. Gorman, let me roll my initial concern I stated by you, but tell me when Florida's certification would be in jeopardy if the certification is not made by that date.
Well, it's clearly in jeopardy now. But I mean,
why is that?
December 12th is the cutoff date.
Why is it in jeopardy now?
Because if they're not certified, then there is no way to come to an accurate statewide count. And that, as we've seen over the last 10 days, is an enormous undertaking. So if we continue to delay the certification process, remember that deadline is not the end of the process for finding accuracy. It is the beginning of the process for finding accuracy.
You're referring to the contest under 168.
Precisely.
But how can those contests, under these circumstances, be made until the recounts are completed? I mean, why isn't it somewhat like a proffer, that you've got to proffer the evidence in the form of these recounts so we know what is in those recounts and whether there is a proper basis for there to be an amended certification?
Well, there's 2 problems with that, Your Honor. One is, in court, not only one side gets to make a proffer, and here we're talking only about counties selected by one political party. So at the end of the day, if we continue to wait until Miami-Dade finishes its recount and Broward finally chooses the standards for determining which ballots it will count, we will not have any better understanding of how many votes were cast and for whom in the presidential election, because we've only looked at a selective subset of the counties in this state. If you were doing a recount in a municipal proceeding, I don't think anyone would take seriously the notion that, well, we've had some problems with our machines, so what we're going to do is recount in 3 of the 67 precincts here, and then we'll know who the winner is. No, obviously you have to recount or apply the same standards throughout all 67 precincts so you can come to a judgment as to who indeed is the winner.
Well, was it requested in the other 64 counties?
No, notwithstanding their devotion to the manual recount as the only means of assessing voter intent and counting all votes, the Democrats did not request all 67 counties.
Was there something that prevented your client from requesting recounts in the other counties?
Yes, they believe the process is inherently flawed and unconstitutional, but moreover, it doesn't matter if they requested it because
Are you asking us to resolve that issue even if we said that everyone has a chance for a window period to request a recount in whatever other counties are in question, are you saying that it is the position of, you're representing Governor Bush?
Yes, sir.
The position of Governor Bush that he would not go along with wanting recounts in the other counties because the process is flawed?
No, Your Honor. I think we should follow the process that's set out in the statute.
But I'm asking you that question, is that you're saying that recounts weren't requested because there was a belief that the process was flawed.
Right.
What part of the process was flawed?
Well, as has been indicated, we think the process is entirely subjective, subject to mischief, and most important,
the manual recount process.
Well, the process, for example, that we were discussing in Broward County today.
But is it the manual recount process that's inherently flawed?
Yes.
And isn't that the exact process that is set forth by, has been represented to us, as the statutes reveal, in Texas law for this exact process to take place where there's manual recounts and that those are preferred over the machine recount?
I really don't know what Texas law is. I know in Florida, though, there's no preference for manual recounts over machine recounts.
But the statute provides the opportunity for a manual recount.
Right, but it requires...
So then the legislature, if that is the case, then the legislature should delete that from the statute.
No. Obviously, they coexist quite comfortably. It says you've got to get your returns in 7 days. That's the mandatory part of the statute. You have an option to do a manual recount or 2 other things if you find that there's a problem, or you don't have to do a manual recount at all.
So you wouldn't have objected if the county had completed it within 7 days, the manual recount?
Oh, yes. No, I want to really emphasize the point here that notwithstanding petitioner's position, the Secretary did not express any preference for machine counts over manual recounts. She expressed a preference for timely returns over those that were 2 or 3 weeks late, whenever they will come in. There are manual recounts in the certified numbers that she will certify when and if this injunction is lifted. There is no preference because the Secretary, like the legislature, was agnostic as to whether or not you used a machine recount or a manual recount. They made no judgment as to which one was more accurate, which is really the basic flaw in petitioner's argument. They want this court, on the basis of no evidence, to enter a judicial fiat that the only way to determine voters' intent is through manual recounts. But we do know what the voter's intent is, at least presumptively, because we have certified returns from 67 counties sitting in the Secretary's office. Those votes have been tallied and calculated in precisely the same way that every Florida election up until this time has been calculated, and no one has ever suggested that it is somehow inherently flawed.
What is the purpose, then, of having a statutory scheme that allows for manual recounts at the option of these local canvassing boards?
I assume it's because in some circumstances, maybe manual recounts, the legislator thought, would be preferable. And they said, look, if in your circumstance you want to do it this way, go ahead and do it. But you've got to do 2 things if that's your preferred course. The first is you have to do it quick, and if you have problems doing it quick, you need to assign enough people to get the job done. We understand, obviously, that larger counties are going to have a lot more votes to count, but we also understand that larger counties have a lot more money and resources and staff that they can devote.
So effectively, if you're asked on the 6th day to do it, the answer has to be no in a large county because it can't be done.
Remember, Your Honor, it is...
I mean, would you just answer that question? That effectively, if you're asked on the 6th day, that is the local canvassing board, the answer has to be no, because in a large county it can't be done.
I would think that's true, but who is that unfair to? The candidate, the losing candidate who has waited and waited and waited before he even asked that this process begins? Surely if he thinks a manual recount will affect the outcome of the election, it's utterly improbable that he will wait until the time when the recount can't be done before he even makes the request. So I don't think that's a glitch in the statutory scheme.
Have you researched the statutes in other states to compare them to Florida's?
I'm not aware of whether they're mandatory or not. I know that there's never...
I'm just asking whether you have researched other states to see whether they have comparable statutory schemes. Have you?
No, I'm not aware of...
So, I mean, you haven't researched other states, is what your answer is?
No,
You haven't? Okay, thank you.
Did I understand your previous answer to be that you would not be interested in opening up this window of opportunity under any circumstances since you believe that the system is flawed?
Your Honor...
Was that your answer?
My answer is that anything which departs from the rules that were set before November 7th, before the election by the Florida legislature, would be a gross abuse of discretion and impermissible. And that's why we have deadlines. And that's why we have uniform rules. Because we want election contests to be decided not in this fevered partisan environment where everyone knows that the way they proceed in counting ballots, or whether they use a two-corner rule versus a dimpled ballot, it may well affect the outcome of the election, because that introduces subjectivity and partisanship into it. And that is why it is very important that we follow the rules that are set forth in the statute that were written by the legislature long ago.
Also rules in the recount process too, aren't they? That it's open and that there be people there for both parties, and that there be an opportunity to observe what happens, and that it is an open and fair system subject people's differing opinions, but it's not closed.
Yes, and of course, if that is the preferred methodology, at the end of the day, if you grant the relief petitioners seek, only 3 counties or 4 counties will have gone through that open and fair process. 63 counties will not have. And if petitioners are correct that machine recounts are somehow inherently unreliable, and for some reason they are disproportionately rejecting ballots with the name Gore on them rather than ballots with the name Bush on them, then those people will have been disenfranchised. The point I'm trying to make is, at the end of this long and arduous journey, as we wait for Dade County's returns to come in, we will be in no better position to know who the true winner is in Florida than we are today. And that's exactly why the legislature said, look, here's what you do. Take all the returns in, pursuant to a methodology that we've used for decades. Certify those results. If petitioners have the kinds of proof that they assert they have in their brief, then it should be a fairly simple matter to show that legal votes were illegally rejected by the machines, and it could affect the outcome of the election.
So you have no objection then for these manual recounts to be going on while at the same time a contest is filed?
I have no objection, but I will point out that the law doesn't contemplate superfluous acts. Now,
well,
obviously,
once excuse me, I mean, you seem to be saying on one side that you don't need to go through this process. And then on the other hand, you're coming back in and suggesting, well, it would be improper to go through the recounts. And then you're saying that, no, you don't have to go through recounts because that's part of the contest process. I mean, at some point, we have to understand which is it. Is it part of the contest? Is it to stop? What's to happen?
Yeah, and I would again go back to the legislative scheme, and if I've been confusing on this, I'll try and clarify. What I'm saying is that the certification process doesn't, as petitioners have acknowledged, involve the secretary in determining the accuracy of the votes up front. The certification process gives to the county boards the ability to conduct a manual recount so long as they do it in a timely manner.
And what happens if it's not there in 7 days?
Well, here
we stop?
No, what we have here, which is they do have certified returns on file. And obviously, if they can't finish the job, then those are the returns that declare the winner.
What do they do with the recount? Does it stop?
I would think that would certainly make sense, but I don't think the legislature contemplated that eventuality, because I don't think the legislature ever contemplated people continuing to count past the time that the votes were tallied.
If it stops, then it cannot be part of a contest then, correct?
Oh, well, what I meant by a contest is what they would do is...
Under 168?
Yes, exactly.
So it cannot be. If it stops, how can it still be part of a contest? That's what I don't understand.
Oh, no, I'm sorry. I think your proof in a 168 would not be, again, on these chads and all of that. I think you would point out, which they claim they can do, that the machines have improperly counted.
But you wouldn't have the recount to prove that, correct?
Well, obviously, if the margin of error of the machines is so bad that they can't accurately predict the winner, then you would be able to show under the 168 procedure that the margin of error is such that it wouldn't affect it could affect the outcome of the election.
But you would not have the recount, correct?
Oh, I don't know, but I don't think there would be any problem in producing it. Just so I'm quite clear, Mr. Justice, that producing that kind of evidence in a election contest procedure. You could go through, I mean, as I understand it, we're almost through in Broward and these other places, and instead of having every court in Florida resolving on an ad hoc basis the kinds of ballots that are valid and not valid, you would be centralizing that factual inquiry in one court in Leon County. So you would bring some orderliness to the process, and they would be able to resolve that evidentiary question. One way or another, a court's going to have to resolve it.
Let me ask you really simply.
Yeah.
In a machine-counted ballot, where someone has gone to the polls and they have punched the hole properly, but for whatever reason, the chad didn't fall out. Are you saying, under your analysis of this, that, and even if this happened to half of the ballots in the county, that there is nothing that can be done?
No, obviously, if there was machine malfunction, that...
No, I'm not saying there is a machine malfunction. I am simply saying that the person punched the hole, whatever hole they wanted to punch, but for whatever reason, the chad did not fall out. What would we do with all of those ballots?
I think we'd have to know whether or not the hole didn't fall out because the person punched and the machine malfunctioned, it didn't go out, or whether the person intended to punch where the hole was. And that's...
It's not a machine malfunction, is it, when you punch the
my only
down?
My only point is, Your Honor, you don't have the voter in front of you. You have the ballot in front of you. And what you need to do is what's been going on is look at the ballot pursuant to some objective criteria and determine whether or not the punch, if you will, is sufficiently strong showing that the voter intended to do that to figure out whether or not they intended it. But as we know, and as the colloquy before indicates, that is a standardless and subjective inquiry, which there are no Florida rules on, and that is why they are asking you for some guidance. My point is, how can this court, after the election has been held, start deciding, resetting the statutory deadlines, reanalyzing the statutory terms for resolving empirical questions of the sort that you're discussing, and redoing everything that reflects and considered judgment that's already in the election code?
But that still sounds like you're coming back to all of these ballots would just be not counted. All of those voters would be disenfranchised.
No, I want to make it quite clear. If they did a timely manual recount, all of those ballots would be included in. Now, let's assume that they were not. Let's assume that they were not, then they would be in precisely the same position as all the other voters in Florida. But I don't think the people in those 63 counties were disenfranchised because the legislature did not believe that manual recounts were the only proper way of discerning the voter's intent. And for the court to disagree with that would require this court to substitute.
What other way would you determine the voter's intent? If it's not picked up by the machine and you don't do it manually, how do you determine?
Well, the question is accurately assessing the number of votes. And you only get to the question of the voter's intent either in a contest election or in the protest election under 166. And I would think you would do it presumably in the same way in both contests. My only point is there are no standards established by federal law, which is why we have ad hoc switching back and forth. And I would urge that the court not, after the election has been held, change the rules by which the election should be conducted.
Mr. Garvin, I think you should let Mr. Richards have his time if he's going to use it.
If I may just wait one final point. He also represents Mr. Bush, and I just did want to bring the court's attention very quickly, if I could, to 3 U.S.C. Section 7, which makes it clear that the federal law will not allow this court or the Florida legislature to change the rules of the election after the election has taken place to avoid precisely the evil I have been discussing, which is that there will be ad hoc decision-making that could be influenced by subjective or partisan concerns. Thank you,
Mr. Garvin. Does Governor Bush have 5 more minutes for Mr. Richards? Okay, thank you, sir.
May it please the court. When all is said and done, when the questions posed by this court have been asked and answered, we come down to a single final issue, which is this. What the appellants are asking this court to do, and in fact what the court must do in order to arrive at the conclusion that they seek, is read a statute that says that returns must be filed by a date and time certain as though it said may be filed, to read a statute that says that the Secretary of State may accept late filed returns as though it says must accept late filed returns, to disregard a statute that says that the Secretary of State's opinion as to election matters is binding upon all those officers and agents within the election system, and to disregard the well-established and long-standing doctrines regarding clearly erroneous standard and implied repeal. And finally,
would you address the question that was posed before, that if we stop, or if you have the 7-day cutoff, do recounts stop at that point, or do recounts continue to be used as part of the contest?
Well, I think the recounts must stop if the 7-day cutoff occurs unless the Secretary of State, in the exercise of the discretion that the Florida legislature has given her, determines that there is rational reason for them to continue. It is the job of the Secretary of State. It has been reposed in her by the legislature, and 2 constitutions, the United States Constitution and the Florida Constitution, in unusually explicit language, have delegated that decision not to the state of Florida, not to the courts of the state of Florida, but to the legislature of the state of Florida. And the legislature of the state of Florida has reposed that authority in the Secretary of State. Now, in order for us to do anything else, this court would have to disregard the most fundamental principles of separation of powers and do what these appellants are asking, to step into the shoes of both the legislative and the executive branches, to rewrite these statutes and to begin the process, which I suggest to this court is never ending, of sitting as a determiner, of an ultimate arbiter of the minutia of facts that go into the election process.
Mr. Justice Quince, you.
Yes. Would you agree that the parties, the party, meaning the political party, and the candidates have a right to request a manual recount, correct?
They have a right to request it, although, interestingly, their request has no meaning under the statutes. It's entirely within the arbitrary discretion of the canvassing board.
All right, and assuming that the canvass board says, yes, we will do this, how do you square that statute with the 7 days? If, in fact, suppose it's asked the very day after the election, yet for whatever reason, it cannot be completed by the 7th day. How do you read these two statutes together? How do you make sense of it?
Somebody, whatever the date may be, whatever it may be, there's going to be a date. It's to the legislature to decide what that date is, and if somebody fails to reach it, some agency of the state of Florida must decide whether or not there was a rational, acceptable reason for failing to do so. The Florida legislature, which two constitutions have given that power to, has decreed that the agency that shall do it is the Secretary of State, not the courts.
And what are the guidelines for the exercise of what you see as that discretion?
Well, the legislature has established no guidelines. The guideline that this court has established, as long as institutional memory exists, is whether or not the exercise by that state agent is clearly erroneous. And I suggest to this court that the appellants have given this court no basis in this case for finding that the Secretary of State's decision was clearly erroneous. That's the issue. And whether or not history ultimately looks kindly upon what we do here, I believe, will depend upon whether we have abandoned those principles of law and statutory construction and separation of powers that we have adhered to for so long.
Does the statutory scheme contemplate that there be initial returns first filed within a certain period of time?
Well, the statutory scheme contemplates that there will be only two things. One set of returns filed 7 days by 5 o'clock, 7 days after the election, and a second set of returns mandated only because the federal law takes precedence over the states and because only to the extent that there's a conflict, the state must therefore comply with it. The suggestion by the appellants...
But the Secretary of State cannot certify official results until she receives the absentee ballots, and the official results also include manually counted ballots. Don't we also have to look at those portions of the statute and read them to come up with a logical whole in this case?
Justice Parenti, I would suggest that that is not the statutory scheme that the legislature has given us. The suggestion by appellants that there can be a continuous certifications and supplemental certifications is not what the statute says. If you read the statute, it says there is one certification mandated by 5 p.m. 7 days after the election, and that's the only one. The only reason there's a second one for overseas absentee ballots is because the federal Congress has stepped in, as they have the right to do, and has said that the states must allow that, but only to that extent.
Mr. Richards, your time is up.
Thank you
very much. And on behalf of Mr. Butler, Mr. Mardenborough.
Mr. Chief Justice, may it please the court. Your Honors, I'm here representing a voter. And I'd like to spend the next few minutes talking about what this entire process has really meant, not from the voters in South Florida's perspective, but what it really means to the voters in the other 63 counties in the state of Florida. And the first thing that I'd like to clear up is, Justice Parenti, you asked a question before that said something like, could the voters have asked for a recount? And they couldn't. There is no right under Florida statute that would allow the voters to ever ask for a recount under these circumstances. Now, unfortunately, we've spent the last hour and a half to 2 hours, and certainly the last few weeks, listening to everybody trumpet the rights of the voters. But the rights of the voters aren't what this is about. This is about the crafty use of a statutory scheme and an attempt to skew election results. And that's just not appropriate. The legislature set up a statutory scheme that puts two different levels of challenges to election returns. That's been talked about now for a while. The first part is the protest period. The protest period is a separate and distinct thing from the contest.
The protest can be asked for by any elector qualified to vote in the election?
That's absolutely true, but that's not true when it comes down to the manual recount provision. If you look at subsection 4 of section 102-166, that provides only that a candidate, a political, well, and in fact, when it's a person being voted for, it's just a candidate or a political party that can ask for a manual recount. A voter cannot ask for a manual recount.
But they have a right to protest.
Well, they can do the other portions of the protest provisions, but those do not include a manual recount right.
Well, that's what since that Section 1 was here before Section 3 and 4, and since there were manual recounts in the state of Florida before 1989, we must assume that the right to protest carried with it a right, if the court decided, to have a manual recount.
Well, if a court decided to have a manual recount, that may be true, but there's certainly not a right for a person, a voter, to go in and ask for a manual recount. Just as you pointed out, subsection 4 was added later, but the legislature specifically restricted who could ask for it, under the normal principle that when the legislature identifies certain parties that can do something and they omit other parties,
but here
they appear to mean it.
The canvassing board has authorized it, has it not?
Where?
Hasn't it authorized the manual recount?
It has authorized manual recount.
Request period.
I'm sorry?
We are past the request period. The canvassing board has authorized the manual recount. Is it?
That's true in the counties that we're talking about, but there was a request made in all of those counties by one of the statutorily permitted people within the 72 hours. Although some of these counties have just now made the decision, they were asked to do this 2 weeks ago or 10 days ago. But the problem here is the voters in the rest of the state of Florida couldn't do that. And we believe that that's probably not constitutional. We believe that it violates the equal protection rights of all of the people in the other counties in the state of Florida, because their right, to the extent that it is provided by a statute, to have their ballots looked at to see whether they made a complete punch through their punch card, is dependent solely on where they live and whether or not they're lucky enough to have a candidate or a political party ask to have somebody look at their cards. Now, I understand that Governor Bush may have had good reasons and he may not trust the process and may not like the manual recounts. However, his decisions shouldn't affect the rights of the voters. Again, I think it was said earlier, the real parties in interest here are the voters. But they can't even ask for it.
Position that the right to have a manual recount should be open for any county where that decision is made by the county canvassing board?
I'm not sure if I understand your question.
You're saying now that the way that you're saying you're raising a constitutional attack on the fact that voters do not have the right to request a manual recount. So is the remedy then, what is the remedy you're seeking? And you sought it within this.
Well, and I need to be completely candid here. That because we were an intervener, that wasn't specifically asked for in this case. That has been addressed in Leon County Circuit last Friday, and that decision of Judge Clark has been appealed. I'm not asking you to rule on the constitutional issue. What I'm pointing out, though, is that the scheme as it exists is unfair, and one of the things that it really comes down to is if you look at the difference between a protest and a contest, you can find some fairness to take care of that. And here's why. If there's a protest, somebody goes to the local canvassing board and says, we want to pick in our little area, we think we can change the votes in this little part of the state. We think that in Palm Beach County, we can change the votes. But that doesn't take into account that there may be a lot of changes that would happen if you did it through the rest of the state. It's a completely local decision that has statewide ramifications. The legislature, in its wisdom, said these protests are going to have to be done, at least the results are going to have to be done within 7 days. They said that the results have to be certified within 7 days. Now, we happen to take a different position on whether or not those manual recounts could go on. It may be that the legislature intended that manual recounts can keep going, but they're of no use in the certification process. They may become evidence at some point in a contest. The difference, and this is a fundamental and a critical difference in this case, is that when somebody is contesting the election, as it's been discussed before, they would be doing it in a Leon County Circuit Court because the statutes recognize that if an election is going to deal with or affect more than one county, it shouldn't be local, it's going to come up here. And a judge here is going to have to make that ultimate decision under the case law that's been set forth by this court as to whether or not the results would change whether any ultimate findings would change the results of the election. That would mean that a judge wouldn't only be looking at, did you end up getting a few more votes in a few select counties chosen by a political party, but it would also take into account a consideration as to, well, what if that same standard had been applied through the rest of the state? If we got some more votes by checking punch cards in the heavily Democratic parties, what would have happened if the same thing had happened in the other counties? And that's a factor that a judge could take in a contest, an election contest. And that's exactly why we believe that the Florida legislature provided for both a protest provision and a contest provision. If this court were to take the protest provision the way that it's being suggested by the appellants, there's never any need for a contest. There would be absolutely no purpose in the Florida legislature having a section of Florida statutes that defines how an election contest works, because they're saying everything gets done before you even certify it. They're saying the Secretary of State has to sit back and cannot certify the winner until everybody's disagreements have already been resolved. The problem is there is no arbiter to make a decision about the disagreements. There is nobody who makes the factual decisions there. It's just local canvassing boards making decisions based on choices of candidates, whether or not to look at ballots again. There's nobody who's actually looking to see whether overall this is going to change the results of an election.
But why isn't it really what they're saying is that you don't have a contest, an election contest, until you have had the procedure that concerns a protest? Because there certainly you can go through this protest procedure and still get to the contest procedure.
Certainly. However, the legislature wrote both of those provisions. The legislature said there's going to be a protest provision, but the legislature also wrote that there is a 7-day deadline for getting the certifications in. And for this court to, the first step this court has to take in interpreting that statute is, can you read that whole thing together? Can you look at Chapter 102 and can you read it in a way that all of the provisions actually make sense so you don't have to just ignore one of them? Because you're being asked to ignore the 7-day rule. You can read that entire statute together in a way that makes perfect sense by simply recognizing that the protest period, which conceivably could even be asked for after certification takes place, because they've got 72 hours from the time that the results are certified. So if somebody certifies their results on...
provision was 72 hours or 5 days or before the votes are certified. It seems to me that provision doesn't allow for the protest once the votes are certified.
I'm sorry, I don't have the specific...
Those time standards are in the alternative with the later date prevailing, are they not?
Right, yes.
So you either have the 72 hours or the time of certification.
Right. I think that it's certainly conceivable, and in fact, I think the only reasonable assumption is that the legislature knew that sometimes there were going to be protests that were going to be going on, and that the legislature recognized that sometimes there were going to be manual recounts that were going on, and it still chose to leave the 7-day deadline in there. They didn't eliminate the 7-day deadline, and when they... I see my time is up.
Thank you, Mr. Martinborough. Mr. Hancock, as I indicated, I think you have 3.5 minutes, and I would pose this question to you, and I'd like Mr. Boyce to also respond to it, that in Section 5 of Title 3, they specifically refer to contest, in that it's for its final determination of any controversy or contest concerning the appointment of electors of such state. Now, under our statute, which is 168, those contests cannot begin, as your opponents say, until such time as the ballots are certified under its express language. Now, why isn't it correct that we are jeopardizing with each passing day Florida being able to have its votes counted in the Electoral College if we don't allow the certification?
Because the 168 provisions do not relieve county officials of certifying election results correctly correctly in the first instance. We know here from Palm Beach County's situation, as Justice Quince points out, that people have cast ballots that under the laws of this state, the opinions of this court are valid votes. They have not yet been counted. Once that final count is done, then the procedure for contests kicks in. That is a completely different procedure. That places a burden on a plaintiff to prove that the election results are wrong. Again, however, in the first instance, that burden is on the county election officials to certify a correct result. If I may correct, Justice Sand said, Professor Rogow has asked me to correct a statement he made to you. In fact, the Palm Beach County Canvassing Commission did request the Attorney General to issue the legal advisory opinion that was issued on the 14th.
Mr. Hancock, Chief Justice has asked a question, and I don't know whether you want to use your time to rebut your co-counsel or not, but where do we find from this record the limits that we're to set in making a determination that we've been asked to say the votes have to be in by a certain time so that the contest provisions can kick in? Where do we find from what has been filed before us the wisdom to do that?
Justice Shaw suggested giving that authority to the Secretary of State. We would suggest, if the court considers that, the court set standards. The standard should be that the counties are entitled, and the paramount interest in doing this is to recognize voter intent. The counties should be given all reasonable opportunities to complete the process consistent with the time obligations in a manner that recognizes voter intent.
Is it the position of the Attorney General that, although we don't have Miami as a part of this case, it's been mentioned several times that they have just not decided to start their manual recount until today? Would that fall within a reasonable limitation to say this is just too late to do that?
I'm not, Your Honor, I'm not sure of all the facts in Miami. My understanding was that they requested, there was a request, they decided not to do it and then reconsidered that request. I'm not sure. Obviously, the request has to be timely to be considered.
And under the circumstances of this case, do you have an opinion as to whether that would be timely?
I don't have an opinion. I would say one other point, if I could. Justice Periani expressed concern about the dilution of votes with recounts. Obviously, no one's vote is diluted in a legal sense by counting other valid votes. We are concerned, as you are, about other counties that don't have this process. One remedy that the court might consider is having a recount statewide. The problem, as you correctly point out, is on counties using machine-readable punch cards. It would be appropriate, perhaps, to review those punch cards in those instances where a vote for president or vice president was not recorded to determine whether the intent of the voter could be ascertained. That would not be a major burden on any county of the state, and those counties with optical scanners would probably find that the ballots were being read properly.
Could you comment on the federal statute that was referred to as to whether this court, in fact, does have the authority, or are we treading into the separation of powers by making such a determination in this case?
No, this court clearly has the power. In the Harkey versus Rothstein case in the United States Supreme Court, which was a United States Senate election, clearly said that that was a matter that was left to the discretion of the state pursuant to the same article of the Constitution that's at issue here.
Thank you, Mr. Hancock. And Mr. Boyce.
Your Honor, let me make two preliminary points. One, I want the court to understand what the nature of the other side's argument is. They say that what they want to do is have a contest. But what they have said, and what they have said also even to this court, although maybe not as directly as they might, is their view is once the results are certified, then the recount becomes superfluous and ought to stop. And second, that as soon as the results are certified, the Secretary of State can, under 103.011, declare who the electors are. And it is their view that when that declaration of the electors has been declared, it's over with. So one thing that I would urge the court is that when there is a deadline so that the contest can start, that the court stay the declaration under 103.011 so that we're not faced with an argument that says it's all over and the contest has become irrelevant.
But you would have to agree that at some point in time between now and December the 12th or 11th or whenever it is, that Florida's votes are going to be in jeopardy.
Your Honor, I think they need not be for the following reason. We don't believe that Section 111 or 112 of Chapter 102 says there is one and only one certification. That's what they argued, but you won't find that anywhere in the statute. In fact, in 102.111, what you find is a discussion of returns, the returns, and then the official returns. And the official returns, as we've said before, is defined in 101.5614 subsection 8 as being returns that include not only the initial returns, but the absentee ballots and the manually counted ballots. There is nothing, in our view of the statute, that precludes them from making a contest under 168 of the certification that has already been filed with respect to the votes other than the manually recounted votes.
The statute says it's the last certification, the last county canvassing board certification. That's what 168 says.
Yes, and the last county certification for every county except these three. They were talking about the overseas ballots and they were talking about other things they said they wanted to contest. Except for the three counties, the last county certification in those counties has already been made. And each of these three counties have also made the initial certification on 5 p.m. last Tuesday. We think that there's nothing in the statutory provisions that prevents a contest with respect to what's already been certified from going forward while the supplemental returns from the manually recounted ballots are also going forward.
But there's no way, for presuming that it's Governor Bush that would have the right to contest the manual recounts that are being conducted in at least 2 out of the 3 counties, for there to be a record in order to contest that, those have to be completed.
Absolutely right, Your Honor. And in order to allow him to contest the manually recounted ballots, you must have a deadline for that too. My only point was...
But now we go back to this. Deadline is not in the statute. How do we have the authority to set a deadline?
Because what this court, I would respectfully suggest, has to do is to reconcile the entire statutory scheme. And the statutory scheme, long before there was this election, provided for manual recounts. And this court, I suggest, cannot presume that the legislature meant to provide for these manual recounts and yet to make that an illusory right by having a circumstance where they could not be practically taken care of in what was the most important election that this state has perhaps ever seen. I think that the standard is exactly the standard that the Chief Justice has referred to, which is when will the date be such that passing that date endangers the ability of certifying and finalizing any contest that may result, so that the votes of Florida are not imperiled. And I believe that that's not an issue in this particular situation, because the counties have said that if you'll tell us what the standard is and leave us free from interference, we can get this done in a matter of days. Now, Broward County stopped because they were told to stop. Then they started again after this court said they could start, and you know what happened? Republican official or Republican attorney subpoenaed the canvassing boards to a circuit court, and the counting had to stop.
That's not part of this record.
No, but Your Honor, what is part of the, I think the court can probably take judicial notice of what happens in a circuit court. But I think the thing that's important for the court to understand is that this is a process that if people will simply get out of the way and let it continue, can be done in a matter of days. This court could, if the court would just give the county canvassing boards.
Where in the record would we find that it could be completed in a matter of days?
Well, Your Honor, in the, I think it's Exhibit G to one of the, to the exhibit that was filed in the circuit court, Judge Lewis's court, that is now part of this record. You have the letters from the various counties, Broward, Dade, and Palm Beach. And I think that the Broward County letter, for example, includes an estimate of that, and also includes a detailed statement as to why they had not gotten it done before, and that is in the record. I also think another way of approaching it is to say, we'll give you the standard to apply, we'll tell you to get it done in 7 days. If the court were able to do that, you would certainly have enough time after that to complete a contest. And I'm not urging in any way that this court do anything that will imperil Florida's electoral votes. What I am asking is that the court use its power to make sure that all of the votes of the voters in Florida that have been cast for those elections counted.
Would you agree that if the court lifted the injunction and allowed the certification to be made, that absolutely there wouldn't be any imperil as to Florida's votes?
I would agree with that, except to the extent that if you did it in a way that permitted them then to declare the electors under 103.011, what you would have done is you would have electors that were not, in our view, the electors elected by the people.
Well, are those two different statutes then? Is that the only problem, is 103.011? Or is it the certification under 102.111?
I think that if the court were to make clear that the certification under 103.011, the declaration of the electors, was stayed pending the result of any contest, and were to make clear that the manual recount continues and will be considered, I think under those circumstances, having whatever certification is required under 102.111 to permit the contest period to begin would not prejudice anyone. We believe that that period can already be taken advantage of. That is, we believe that because 102.111 refers to both results and official results, and official results is defined elsewhere to include manually recounted votes as well as the initial returns, they could, and the contest statute does not depend on the official results being certified, but only results being certified. I think our view is that under the current statutory scheme, they can, or anyone can, file a contest with respect to the votes that have been certified. Obviously, you're entirely correct that even with respect to the recounted votes, those have to be done within a time period that allows a contest of those votes. But because those are a relatively small number of votes, that is a period of time that we are well within. So that I think one solution that would prejudice no one would be to provide that a party could file a contest with respect to the votes that have already been certified, that is the non-manually recounted votes, right now, because they're not the official results, but they have been certified, and to provide that the manual recount would be completed within 7 days of the court's order defining what the what the standard is.
Mr. Boyce, I think your time is up.
Thank you very much,
The
Your Honor.
court is very appreciative and indebted to counsel for each side who has worked so hard and long on the presentations here and on what has been presented to this court for the court's benefit in attempting to arrive at a fair and just solution in this case. We also are very appreciative to our guests who have been here in the courtroom for the argument today. I make one final request of you, and that is that we now recede from the courtroom on the basis that all counsel be permitted to exit the courtroom and the building, and so that all post-argument interviews will be conducted not in the rotunda here, but outside the building, and then our visitors will be asked to, for security purposes, to exit the building after all counsel have exited the building. Thank you, and the court will be in recess.
So there you have it. It took a little more than about 2.5 hours for the Florida Supreme Court to entertain arguments from attorneys for George W. Bush and Al Gore about whether to permit hand recounts and when to certify a victor in the state of Florida. In the final moments, there may have been a proposal of sort of a grand deal, and I'm going to let law professor Paul Rothstein explain what we may have seen there in the waning moments of this hearing.
Well, it looks like Boys had a fallback position for Gore, that there could be certification, that the state Secretary of State Harris would get her way. There would be certification now without the recount, but that the recount would go on and it could be amended later, and there'd be another final certification.
In other words, she could certify a winner, but it may not be the final certification pending a series of recounts.
That's right. Semi-final certification. But the court was concerned with a timing problem on both sides. The court was concerned with the Gore proposal that the recount would go on so long that it would bump up against the December 12th deadline for having an electoral vote. That's under federal and constitutional law. On the other hand, the Bush thing of cutting it off right away 7 days after the election, they felt that that was a problem because the law does provide for recounts. A bit ridiculous. So they have a problem with timing, and they may have to set their own deadline for the end of a recount.
Another piece of timing, of course, is when they reach a final verdict on this, and we'll find out. But now that's it for right now in Washington. I'm going to throw it back to my colleague, Neil Cavuto, who's standing by in New York. Neil?
All right, Tony, thank you very much. Welcome, everybody. We should tell you that as this was going on, I was closely monitoring the market's reaction to all of this. And whenever it looked like this could drag on a while, stocks fell even further. When it looked like it might not drag on a while, stocks rallied from off their lows. So we should point out here that that was an encouraging development for those in the markets. David Boies now is talking to reporters in Washington. I think we're going to go, or in Florida, I should say. We're going to go to that right now. Let's listen in.
Okay. We are not going to have any, I don't know whether you can hear me or not, but we are not going to have any comment at this time. We have made our arguments to the Supreme Court of Florida. The Supreme Court of Florida now has this case under submission. It will be up to the Supreme Court to make its decision. We've made our arguments in our brief and orally, and we will not have any comment on it until the Supreme Court rules. Thank you very much.
All right, David Boies indicating that he would not be talking to reporters just yet. Speaking outside the Tallahassee courtroom, the Supreme Court has weighed in on this case, has not made a final decision yet. But just to update you on something I was saying a little earlier here, stocks were buffeted again, down 167 for the Dow, down 151 for the NASDAQ. Wall Street fears that in this vacuum of uncertainty, the better part of valor is to sell and maybe ask questions later, and that seems to have been happening in a big way in this case. Judge Stephen Grimes, the Fox News legal analyst, former Florida Chief Justice, joins us out of Tallahassee right now. Judge, let me get your take on what you heard here today. Any way to read what these judges are thinking?
Well, let me say at the outset, you know, in the way the questions were asked, and this is true of most appellate court proceedings, you often get a sense maybe of what's concerning the judges, and they want to probe the vulnerable positions on each side. But sometimes you can't tell for sure, and there have been certainly you may read too much into the questions, and so I caution the listeners that just because a judge seemed pretty hollow to a position might not necessarily be the final position. But having said that, it's clear that they're concerned. I think it's very evident that they don't want anything to last past December the 12th if they were to authorize a recount. They're also concerned.
All right. Excuse me, Justice, I just want to go to the Bush attorneys who are speaking very quickly. Let's listen in.
Those questions illustrated the difficulties that are posed by the suggested relief that the appellants in this case have been seeking. We have every confidence that the court is going to deliberate carefully and make a reasoned and appropriate judgment.
All right, this is one of those rare occasions where these lawyers are not talking to reporters, at least to any extent. Justice Grimes, let me get back to you on this notion of the tone of the questioning. You're the legal expert, sir, certainly not I, but I noticed that the Bush attorneys were more badgered than were the Gore attorneys. Now, should I read anything into that or no?
Oh, I don't know. I don't know. I think it's more the nature of the questions and what was being asked. It was obvious that there was concern that by having the statute says clearly the returns are supposed to be in 7 days except the absentees, and there was concern that, and then, on its face that sounds clear, there was concern that as a practical matter that would be virtually impossible for the larger counties, and therefore do you look at other portions of the statute to try to put them all together and have a result that would allow the votes to continue. It's possible the court could allow the votes to continue up to a point. There was also some exploration as to whether or not they should open up the all of the other counties for a recount.
Indeed, the whole state.
Followed, yeah, the whole state.
Okay.
Although that wasn't followed up too much. What the lawyers were trying to do, I think the Republican lawyers felt that it would be more appropriate to have a contest rather than a protest, because the burden of proof is probably a little higher in a contest. And they say that the opportunity to protest really should be over, but perhaps the Gore people could have a contest.
All right.
Which the burden of proof might be a little higher, but that's just one of the arguments that's being made among a lot of them.
All right, Judge Stephen Grimes, I want to thank you very much. In Tallahassee, Florida, appreciate your legal expertise here. We are shortly going to get some more legal expertise on this. I want to first go to Carl Cameron in West Palm Beach, Florida, get his read on this and how soon we might expect a decision. Any read on that, Carl?
The timing of it's very much up in the air, although it is expected probably within the next 48, 36 hours or so. But while the court was in session, hearing the arguments from both sides, another development outside the courtroom, which potentially has an opportunity to significantly help George W. Bush's effort. The Attorney General of Florida, a Gore campaign co-chairman, a Democrat, Bob Butterworth, has written Florida's 67 counties and urged them to go back and recount and include the overseas absentee military ballots that did not contain proper postmarks. There's been quite a controversy in the last few days because of the 3,500 some odd overseas absentee ballots that were due by the midnight deadline of the last Friday, about 1,400 of them were disqualified. The majority of them disqualified because they were military absentee ballots that did not contain or did not have on them proper postmarks, because in the military, quite often, they go into military postal bags, don't get into the actual postal system, and they're not postmarked, date stamped. The controversy erupted, causing the Bush campaign and Republicans to accuse the vice president's lawyers of, quote, trying to wage war on American military servicemen and disenfranchising them and their votes. The Attorney General of Florida now writing the counties saying that, in fact, those military overseas ballots without postmarks should be counted. Now, George Bush got a 600-vote boost from the absentee overseas ballots, bringing his total over the weekend to about 930 votes advantage over Gore. That was with only about 2,000 of the 3,500 absentee ballots counted. If 1,500 go back into the mix and the ratio holds, it could mean anywhere between 300 and 500 more votes for George Bush from those military votes, Neil.
But, Carl, you could also read that cynically, that maybe the Attorney General knows something that we don't, that maybe the count is sufficient enough in the recounting procedure to more than dwarf that, or am I being too jaded here?
Well, that's certainly possible. I mean, the numbers are crunched seemingly by the hour in a variety of ways, depending on who you ask. The other thing that should be noted regarding the absentee overseas military ballots, on various different naval ships, various different military vessels around the world, there are said to be bags of overseas ballots that didn't make it in time because the ships didn't make port or because the military ability to ship the mail from one place to another broke down before the midnight deadline. And when you see in court, as we did a moment ago, arguments on both sides about whether or not deadlines should be held or not, there's an open question about whether some of those late absentee overseas military ballots might yet be counted, though the deadlines have seemingly passed. Yeah.
All right, Carl, thank you very much. Carl Cameron in West Palm Beach, Florida. I want to get the read from the Gore folks. Jim Engel in Tallahassee, Florida. Jim, any knee-jerk read on this?
Well, the one interesting thing I thought here, Neil, was the continued discussion by both sides and the justices about the predicament that they are in as a result of this case. You notice that they kept saying, now look, if you set this deadline after 7 days, but the legislature also allows for recounts, then how do those two work together? Because it seems that big counties won't be able to finish recounts. And if you can request a recount on the 6th day, obviously they're not going to be through by the 7th day. So how does that work? Then they turn around and ask the flip side of that question. They say, but yes, for the Gore people who say that there should not have been this deadline, then what should the deadline be? Who sets that deadline? And where do you think we get the authority to pick the deadline? So the justices obviously are in a quandary. I mean, there seems to be a conflict over how you do recounts and still get in by the 7-day deadline. But on the other hand, they seem a little bit reluctant to just sit down themselves and argue out what the deadline should be. And you heard several questions from them to the Democratic lawyers saying, now look, at what point do Florida's votes are they in jeopardy because they come up against the December 12th deadline for Florida to name its electors? And of course, if you continue this process of counting votes out for several more days, you have to allow Governor Bush a chance to contest those at the end of the process. And then where is there enough time for this to go back and forth? So you can see the difficulty they have. They are sort of between a rock and a hard place on this and trying to decide if this isn't the deadline, what is the deadline? And if the legislature didn't intend to set one, where does the court set one? And you heard Republican lawyers say, look, you cannot step into the shoes of the executive branch. If you start doing that, you're on a slippery slope and you will have to make all sorts of decisions that were intended by the legislature. This is a real legal thicket for the court, and it's going to be a tough one to negotiate.
All right, Jim, thank you very much. Jim Engel in Tallahassee. Bob Crawford joins us right now. He's with the Canvassing Commission, one of 3 members of that commission that's sort of in the rather unfortunate position, fortunate, depending on how you want to look at it, of being in the middle of this brouhaha. Mr. Crawford, thank you for joining us.
My pleasure, thank you.
If the read is, Mr. Crawford, that this could go on a while and that the court were to conceivably grant more time for a recount, even open it up to the rest of the state, what would that mean?
Well, I think the court expressed clearly they had some real concerns about putting in jeopardy Florida's 25 electoral votes. We do have a deadline of around December 12th to get those votes in, and if you move the goalpost now and retreat from the statutory deadline, I think those votes become in jeopardy, and there's a lot of questions about that today.
Are you saying that the December 12th deadline itself would be in jeopardy?
That's correct. If we don't get our votes certified, we don't get them counted, then there's provision in the federal law that says we may not get them counted.
Which means, by the way, we should step back, which means Florida would not count then, conceivably, in the final electoral count. A map that would favor the vice president, right?
Right, but it would also disfavor the 6 million voters that did cast their votes and would like for their 25 votes to be cast. So I think the court was saying those voters in all the counties in Florida who have their votes in, there's no problem, they would be prejudiced. And I think the other thing that was clear was that the side that was arguing that we should change the rules, that the court would then have to refashion a whole legislative scheme that really is up to the legislature. And I think when you start going down that slope, the Supreme Court gets into all kinds of issues that are clearly legislative and not policy decisions made by a court. So,
but the genie's already out of the bottle, is it not, Mr. Crawford? I mean, this recounting has been going on and on and on. So the court is, as my friend Jim Engel pointed out, between a rock and a hard place, right? If it were to go ahead and say, forget the hand count the way it stands right now, it would be disallowing all this work that's been going on for, what, a couple of weeks, right?
Well, I think what you have to do is run an election by rules, and the rules are in the Florida statutes as dictated through the people by their elected representatives, and we need to follow those rules. While those rules have some unhappy consequences for some, to ignore those rules has tremendous negative consequences for all of us.
All right.
And I think that's what we have to understand.
All right, Bob Crawford, thank you very much for joining us. Appreciate it. With the Canvassing Commission in the state of Florida, Bob Crawford. Now I want to bring in here the big judge, the guy who's getting it done with his own show, Power of Attorney. Of course, he's our Fox News legal analyst as well, Judge Andrew Napolitano. Good to see you, Judge.
Oh, thank you, Neil. Good to
All
be
right.
with you.
It's fairly black and white for me as I see this decision, but again, you're the expert.
Okay, tell me what's black and white.
Well, you tell me. That they can either allow the recount to continue and broaden out conceivably, or shut it down, period, right?
Right. Here's the dilemma that they have. It is clear that they are concerned that they want to resolve this problem. Their questions were right on the point. Their questions, in my view, were just as aggressive to each side's lawyers. But they don't want to usurp the powers of the legislature or the powers of the executive. For example, if they were to extend this recount, it would not be for them to say the recount must be completed by December 1st. They would have to say to the Secretary of State, who is the entity under the Florida legislative scheme and the Florida Constitution, who decides when these recounts have to be finished, you set a date. Don't abuse your discretion, but you set a date. So it's not something that can easily be done because we're talking about an equal branch of the government, the executive and the legislative.
Hang in here, Judge. We're going to take a quick break and play our bills here and then come back with Newt Gingrich and Charlie Rangel and more of the judge after this.
ビデオになりました。怖がらないで。大統領に噛みつく骨のあるアニメ。あんたら一体何者？ FBI のモルダーとスカリーです。
わかりますね。
はい。
宇宙人だ。覚悟しろ。子供って残酷になれるものよ。ハッピー。ありがとう。
シンプソンズ始まった？まだ。ザ・シンプソンズ選び抜かれた傑作が4話。それで一つのビデオに入ってます。ビデオですから繰り返しご覧になれます。おい、俺のビデオが出るぞ。ザ・シンプソンズ。これを置いてないビデオショップはもぐりです。
親父見る気ある？
Opinions. I have them, you have them. In fact, on any given subject, there are as many opinions as seats in this theater. And that's good, people speaking out, sharing ideas. But opinions are not the same as facts, and you should know the difference. And that's why at the Fox News Channel, we label all opinions right on your TV screen. And that should help you form your own opinion, so you can decide what's right and what's wrong.
Thursday. 今日は楽しいハロウィンナイト。平和な仮装パーティーのはずが、またも悪巧みの気配。ショータイム。
ハロウィンで幽霊のコスチューム着たら本物の幽霊になっちゃった。
バフィーが貴婦人になっちゃうなんて。
バフィーどうする？
バフィー恋する十字架、木曜夜10時 on Fox。
right, welcome back, everybody, to hand count or not to hand count. That is the very big question, and a historic one at that. Welcome back, everybody. I'm Neil Cavuto. Florida's highest court today weighing in on this issue, listening to both sides, the Gore and the Bush sides, as to what is an equitable way to get this process moving forward and decide who will be the next president of the United States. The hand count issue is what's at stake here. The Bush folks want it stopped and go ahead and declare a winner, which, as things stand now, would be George W. Bush. The Gore folks want to continue the hand count, which by their math might favor their man, ultimately leading to Vice President Gore becoming President Gore. No one seems to know, but we're going to continue debating it ad nauseum. All right, and here to do that, our Judge Napolitano still joining us here. We've got Charlie Rangel joining us as well, who has an interesting view from the perspective of Congress, and the former Speaker of the House, Newt Gingrich. Speaker Gingrich, I ended with you. Let me begin with you. What is at stake for Republicans if this hand count is allowed to continue? Is it the end for George W. Bush? How would you describe it?
Well, I think this whole election has been so wild and woolly, it's pretty hard for anybody to say what is the end. In some of those counties, as you know, I think Volusia, Gore did not gain much. In Palm Beach, the latest count showed Bush actually gaining a little bit. So I don't know that we have a clue what's going to happen. The Attorney General down there correctly ruled that we ought to count the other 1,400 military ballots. If that's implemented, I think Bush's lead grows by 200 or 300 more. So I think you can't be sure what will happen. What I was struck by, though, and I'd love to get Judge Napolitano's reaction, is I thought the judges were being very aggressive, and this is clearly the most important decision they'll make in their judicial career. But it does strike me they could rule in a way that's balanced, that you could go forward with the counts, but they would not usurp the Secretary of State's right to decide whether or not to accept those counts. That would put them in a position of not blocking it, but at the same time not shifting her discretionary power into a court mandate. I'd be curious
what do you think of that, Judge?
This is just what you and I were talking about during the break. This would allow the Secretary of State to exercise her discretion, which the legislature and the state constitution have given to her. It would allow the recounts to continue, but this will, because she will declare George W. Bush the winner and thus appoint a slate of 25 Bush electors, put enormous political pressure on Al Gore to call off his dogs, to stop the lawsuits and to stop the recount.
Charlie Rangel, let me ask you very quickly on that issue alone. Would Democrats then start telling Al Gore, fold up your tent?
No, I think that the federal courts probably would reject any appeal, but I think that it will happen so fast, it'll be expedited, that you wouldn't have to tell them anything. The most important thing is to make the American people believe that the decision was fair and equitable and the voters' rights were respected. I think that that the voter would be entitled to have a review by a federal court, and probably one from the U.S. Supreme Court.
All right, we'll see what happens. Guys, hang around here. We're going to quickly pay our bills again and back to this argument as to what happens now in this legal morass. You're watching Your World.
Here in the studio in Washington, CNN's Frank Cesna, who's been talking to folks in both political parties about what they think it means, whether Governor Bush's side loses coming out of the state Supreme Court and those ballots are counted, or conversely, Vice President Gore is seen as victorious and the ballots are counted.
Well, Judy, a keen observation of the obvious to say that what's happening at the Florida State Supreme Court is really what, what all sides are watching. That's the big game in town right now, and a very interesting divide. Allies of George W. Bush, prominent Republicans around Washington, actually most of them are scattered out in their districts. I'm talking about elected representatives, senators, strategists, that sort of thing, say that if George W. Bush does not prevail, if his viewpoint does not prevail, he needs to press on. He needs to basically continue to say that this is a process that is riddled with mischief or problems and go to the next legal level, or even if he's pushed to it, say there should be a statewide recount. The Democrats, on the other hand...
The next legal level being what? The United States Supreme Court?
Or go back to federal court in Atlanta, or wherever they need to go to take their next recourse. And there is obviously some question and debate about precisely where they do go, to not even rule out action, with the Florida State Legislature or in the U.S. House of Representatives if it comes to that, but that's premature. On the Gore side, another very interesting observation, and that is the opposite, that if this goes against Al Gore, according to many very senior Democrats, this is really the end of the line for him, that more legal challenges would be difficult to bear out, more legal challenges would be difficult to explain. In the words of one senior Democrat, Judy, if he loses in the Florida State Supreme Court, he should say, "I've been robbed, but I'm going to play the role of the injured prince, and I'm going to step out."
Is that because the Florida Supreme Court, Frank, is seen as perhaps a sympathetic body to some of the arguments the Gore team are making?
The way it was explained to
and that if they lose there, then, you know, the hurdle becomes much higher.
The way it was explained to me last week is that there needed to be 3 legs to the stool that was supporting Al Gore and the continued demand for the recount. One was the recount itself. It needed to proceed. People needed to see election officials holding up those ballots or whatever, actually counting votes. 2, they needed to hear that there were going to be additional votes, that they were actually finding votes that hadn't been counted for the vice president. And 3, that the Florida State Supreme Court, with its jurisdiction and its stature, would somehow bless this operation. They needed all 3 of those things. Lose one, according to these strategists and observers and participants, and you pull the stool out from under Al Gore.
All right, Frank Sesno, I should tell our audience that I've just been told in the last few seconds that the Florida State Supreme Court has announced that there will be no decision today. No decision today. That's not a particular surprise. I think most of us expected that it would be tomorrow or Wednesday or perhaps even later. But I think most of the thinking has been that it would be Tuesday or Wednesday of this week, given the Thanksgiving holiday and given the urgency of the matters before the court. We'll be back in a moment with more coverage of today's arguments before the Florida court. We'll be back.
The digital revolution is bringing the world together. ITU Telecom Asia 2000 in Hong Kong from the 4th to the 9th of December. Meet the future.
Your business, your world. In association with HSBC.
A woman came to me for a job, and I turned her away because she had a small child, and that started haunting me. I realized that these women need childcare facility to keep their job. So I started Fulki. Fulki is a Bengali word. It means spark.
That it's going to happen very fast if it happens that way. And I think that Vice President Gore is already in this thing. He doesn't have much to lose by pushing for an extra 3 or 4 days. What I don't think would happen in the case you described is I don't think it would last 2 or 3 or 4 or 5 weeks, both because procedurally it would end and also because public pressure wouldn't tolerate it. I think on either side. I think the country, the clock's really begun to run on this whole process in terms of the country's patience with the electoral process.
I agree with Newt
let me ask you,
completely.
Congressman, would Democrats have a tough time swallowing that? Let's say it's a President Bush. Would they have a tough time working with him?
I don't think we're going to have a choice. First of all, I don't think the federal courts would take jurisdiction. And if they did,
pass,
the decision is going to be so swift that it would be a question, really, of George Bush, who is the president. He will have in his hands the ability to determine whether he's going to bring our country together.
So this court, yay or nay, this is where it stops, you think?
I'm not saying that. I'm just saying that I do think that there would be an obligation by either party to get a ruling from the federal courts.
All right, well, here's where I'm confused, guys.
But
I'm talking about my...
They have to find some constitutional reason to do it.
But here's what I'm talking... I talk to my Wall Street buddies all the time, and they say, Neil, we just want it settled, period. We just want it done.
Right, well, you saw the way the market moved during the oral argument. I've never seen anything like that.
The better it looked for early resumption of this, the better it looked for the stock market. The more it looked protracted, the worse it looked.
Right, exactly.
So what is your feeling about the timeline for this going forward?
I think we'll get a decision before Thanksgiving. I think they really know that history is like Thanksgiving's Thursday. I think we'll get a decision Wednesday morning. And if they say to the Secretary of State, you may certify, you may exercise your discretion, she will declare George W. Bush the winner of Florida's 25 electoral votes Wednesday afternoon. They may also say you can continue counting. If the recount shows something different, you've got to challenge the certification. Or they may say to the Secretary of State, we want the recount to continue. This is what Charlie wants to hear. We want the recount to continue. You, Madam Secretary of State, fix a time by which the recounts must be complete.
Well, that's the clock's ticking in favor of George Bush in that event.
Yes.
Right, in either event.
Yes.
In that case. So Speaker Gingrich, what do you think of that? Does this make it now almost George W. Bush's to lose?
No, I think, first of all, you got to wait until the court does respond, because we don't know what they're going to say. We have pretty good ideas, but we don't know. Second, I think that the Gore campaign is going to try very, very hard, particularly in Dade County and in Palm Beach County, to see if they can't find those votes. And at least as I read the reports, there are a number of disputed ballots that are being set to one side. That could be, frankly, a big enough margin that would turn the election to Gore. So I don't think this is over.
All right, Newt Gingrich, Charlie Rangel, sorry, that's all we have time for. Justice Napolitano, I want to thank you. We'll have more coverage with Tony Snow and Brit Hume after this.
Come first to Fox News for breaking news, exclusive stories that impact the world, unique, timely interviews that shape our nation. First on the scene with breaking news, continuous coverage from over 70 bureaus around the globe.
We're the only ones here who still have live pictures out.
Reporters, anchors, and correspondents that are first, fair, balanced, powerful insight, powerful perspective, powerful news. Come first to Fox News for breaking news.
Fox News Channel Daytime. You want to make the right choices. We give you the power to decide for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide. Fox News Channel. Powerful all day. John Scott, Bridget Quinn, David Asman. Bringing the world to you. Making the issues clearer. Powerful hour to hour. Linda Vester, Shepard Smith, Neil Cavuto. Breaking stories, aggressive coverage. Powerful all day, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide.
Fox presents 科学分析ノー危険人物関与目撃証言消去
だが真実はそこにある X ファイル on Fox さあスカリー行くぞ2人の FBI 捜査官が挑む世界の裏側の巨大な謎
I think that we've succeeded in doing that first and foremost. It's become a lot of other things, but I think it is a scary show.
X ファイル全米のメジャーなテレビショーを連続受賞
The X-Files has really caught on because I think people around the world have to be scared.
X ファイルその魅力は今も世界中にファンを生み出し続ける
X ファイルよくできてますよねもっと続けて来週はどんな話なんだろう見ればハマる
テレビ史上
真実が知りたい
かつてない
答えを見つけて
進化し続ける最高傑作真実はそこにある目撃者はあなた X ファイル毎週月曜夜10時 Only on Fox
Welcome to Washington. I'm Tony Snow. A little more than a half an hour ago, the Florida Supreme Court in Tallahassee, Florida, completed a 2.5-hour hearing that included robust grillings of attorneys for George W. Bush and Al Gore. Our Brett Baier was in the courtroom. He's standing by with more in Tallahassee. Brett?
Hi, Tony. First of all, we want to tell you that we have heard from the public information officer for the Florida State Supreme Court that there will not be a ruling today. Just came out a few minutes ago saying there won't be a ruling today. Did not say when there would be a ruling, but it will not happen anytime today. Being inside that courtroom, as you mentioned, it was an amazing sight as it went back and forth, all of the 7 justices asking questions, really a barrage of questions to the different sides. Chief Justice Charles T. Wells was very concerned about the December 12th federal deadline for Florida to certify or to name all of their electors. That December 12th federal deadline came up again and again by Chief Justice Charles Wells. Justice Barbara Pariente was very concerned with the 7-day deadline stipulated in Florida law. and she wanted to know how a big county could possibly finish a manual recount in 7 days. So the questions affected both sides, and both sides seemed to grimace as a line of questioning continued on a specific issue. But both sides' attorneys defended themselves in front of the 7 justices.
This court certainly has the power to say, what we're going to do is tell the county boards that you've got this amount of time.
I think the recounts must stop if the 7-day cutoff occurs unless the Secretary of State, in the exercise of the discretion that the Florida legislature has given her, determines that there is rational reason for them to continue.
Now, I just talked to Joe Glock. He is the attorney who argued on behalf of the Secretary of State in front of this court. He said, we really like a hot courtroom, is what he called it, and he likes it when the justices continue to ask questions, even if it's against his side. He said that shows that we can provide more information. He said to me that he didn't think that you could say one way or another where the 7 justices were leaning. Again, they will not be making a ruling today, but obviously it was high drama here in Tallahassee. Tony?
Now, Brett, he was saying they could provide more information. Does that mean the justice would be asking them to supply additional materials during the course of the court's own deliberations?
No. Basically, by asking more questions, the justices were trying to gather more information, and Glock was saying that he enjoys a hot courtroom, being able to answer all of these questions to keep the justices on track with their argument.
Now, you said that he doesn't believe that you can read much into what the justices were saying, but we've heard a lot of people suggesting that perhaps already there may be some sort of grand deal in the works, that the justices may say to Secretary of State Katherine Harris, okay, you can certify an election result. Okay, counties, you can keep counting. And by some date certain, there has to be a, quote, final certification of a winner. What's the speculation around the courthouse?
Well, it's tough. It depends on who you talk to, Tony. I mean, one side believes that the Republicans believe that these justices may come out and say, hey, this is the end, that the Secretary of State indeed can certify the results as is, and there would be a jeopardy issue here, put the state in jeopardy, naming their 25 electors, as Chief Justice Wells kept on bringing up, that possibly if these hand recounts continue day after day, week after week, that December 12th deadline would not be met, and that seemed to be of great concern. Now, the Democrats say that they felt that these justices may even consider a statewide manual recount. They talked about that many times and asked questions about that. So really, it's still a roller coaster of emotions here, depending on what side you talk to.
Now, Brett, the Bush team has also filed a series of lawsuits in federal court. There's yet another pending. Do they have a sense that if they get an unfavorable ruling out of the Supreme Court, they might get a hearing in a U.S. federal district court in Atlanta?
They have talked about that, definitely, and as a matter of fact, former Secretary of State James Baker mentioned that specifically after the last ruling here. He came out and said that the 11th Circuit Court of Appeals in Atlanta left the door open, and once they had a ruling which way it comes down in Florida State Supreme Court, that perhaps they may address the issue of hand counts being unconstitutional in federal court. Really all depends on how this comes down with these 7 justices in Florida State Supreme Court.
Okay, and for more on the process of recounting, we now go to David Lee Miller, who joins us from Southern Florida. David Lee.
Hi there. We're getting some breaking news right now, Tony. We've just heard that they've stopped the hand count in nearby Broward County because the only Republican member there of the canvassing board has resigned. She said she couldn't take the long days. That just in moments ago. Now, let's talk for a moment, if we can, about Palm Beach County, which is where I am located at this hour. The counting here continues as it has all day. We can take a look inside now in the counting room. You can see them checking the ballots by hand. And we have some new numbers here, courtesy of the Associated Press. They show a net gain now for Al Gore. The pendulum has shifted now to Al Gore of +3 votes. and they have counted now, they say, more than 40% of the votes by hand here in Palm Beach County. So despite the hearing, as the hearing went on in Tallahassee, it was pretty much business as usual here in Palm Beach County. The attorney for the election supervisor, Paul Rogow, made an appearance before the court, and he described the hand count using terms such as tedious and tenderly. Well, there are many Republicans who would take issue with the description tenderly. They say it has been anything but. They say a number of the ballots here have been misplaced. They've been put in the wrong stacks of the wrong candidates. They also say, as we've heard so many times, Tony, that the chads have been torn off the ballots and they have fallen onto the floor, something that even the canvassing board chairman has acknowledged and said it is inevitable. Now, as for the Democrats, they have their own gripes. They said today that because the standard here is so strict that they are not counting the dimples on the ballots as votes as a sign of voter intent, their candidate, Al Gore, has been denied 276 votes. They say that it has cost George Bush a total of 73 votes. They've actually set aside those dimpled ballots so that if there's some type of decision from the Supreme Court or a federal court that says they have to be included in the count, they will be able to do so. But right now, they have been set aside and not included in the totals for either candidate. And in another legal development here in Palm Beach County, a county judge here today issued a ruling saying that he was not authorized to call for a new vote for president in Palm Beach County. The judge, Jorge Labarga, had said on Friday that it would be a very tough decision, possibly the toughest decision of his legal career. Meanwhile, the plaintiffs say they are going to appeal that case. An attorney for the plaintiffs, who, by the way, are Gore supporters, who say they mistakenly voted for Pat Buchanan. They say the so-called butterfly ballot here is not only misleading, it is illegal, and for those reasons, they would like a new vote. An attorney representing the plaintiff said, "We didn't have the opportunity to show the people of the world, we're not crazy down here, that the ballot was not valid." And as for the counting, it continues, and it's going to continue, it looks like, for some time to come. They now say that they are not going to make a Thanksgiving deadline. They had hoped to wrap this whole process up by Wednesday night. That's not going to be the case. Right now, they say the counters are going to get Thanksgiving off, Friday off. They might be back here over the weekend, possibly not. They haven't worked that out. But one thing is for sure, this isn't going to be done anytime soon. Tony?
Okay, David, a couple of questions. First, we need to note that the Broward County elections official, Jane Carroll, is 70 years old. That's why she said the toll of the long days was too much for her. Will they be appointing a successor for her? Will the Republicans get somebody else on the board? How does that work?
I do not have the information right now about Broward County. I just heard that news only moments ago, and they haven't worked out the details, and I'm not familiar how they're going to appoint someone else to the canvassing board, but this much is certain. Unless they have the 3 members to the board, on the board, the process is going to remain stalled, at least for now.
Okay, David, now let's talk about what's going on there in Palm Beach County. In Palm Beach County, there was a lot of acrimony last week, a lot of allegations from Democrats. The Republicans were deliberately dragging their heels, and by Republicans against Democrats, saying that there were all sorts of attempts to fool around with the ballots. Have the temperatures calmed down at all inside the place where they're doing the counting?
A little bit. We didn't see any outward hostility today. Judge Charles Burton, who is the canvassing board chairman, has gone out of his way to say, people, these are his words now, can't we all get along? And to some extent, it seemed to be going reasonably well inside the counting room, but still there are many objections being raised. And when you see the two sides come out here and to speak to the media, they still raise the same objections and the same concerns. The Republicans say this is an inherently flawed process. It is unfair. It has to be halted. The Democrats say this is the only way to ensure that every vote is counted. So there's spin by each side. We're hearing that out here. But in the counting room today, we haven't seen some of the same hostility that we noticed the past couple of days. And one other thing I should add, I noticed today something that is relatively new. Instead of holding up those cards, as we've seen to the lights, sort of the light test, they now seem to be using a red backdrop, so that if they see any of the red through the ballot card, they'll be able to judge how well the Chad itself is attached. For some reason, they have tried to change that process just a little bit, but they haven't made any public announcement about it. Tony?
Okay, David, thanks so much. Well, a lot of people have been seeing red the last few days. A quick update. We now know that in Broward County, with 40% of the vote counted, as David Lee Miller just pointed out, there's a net gain of 3 votes for Vice President Al Gore, and in Palm Beach County, The net gain after 80% of the votes have been tallied is 119 for Al Gore, total of 122. So that's the very latest. Also, counting began today in Miami-Dade County. We're going to take a quick break. When we return, we will hear from both campaigns. Stay with us. You're watching Fox News.
Opinions. I have them, you have them. In fact, on any given subject, there are as many opinions as seats in this theater. And that's good, people speaking out, sharing ideas. But opinions are not the same as facts, and you should know the difference. And that's why at the Fox News Channel, we label all opinions right on your TV screen. And that should help you form your own opinion, so you can decide what's right and what's wrong.
Lieutenant Hobbs.
Tom? What do they want?
You know a classified project known as Harsh Rail, Lieutenant? Situational war strategy. Sergeant Major Omar Santiago.
Completely wrong. I hear that you intend to kill me. I had orders to win the game. I don't know where he is, where he comes in and out. He's hijacked the whole damn program. It's no game. No getting out. No going home. I got the same mission.
X ファイルのクリエイターが挑む衝撃のサイバーアクションハッシュレルム12月8日ビデオレンタル開始
So how did George W. Bush and Al Gore react to today's hearing of the Florida Supreme Court? Did their hearts leap with joy, freeze with panic, something in between? For reports, we go first to Wendell Goler, who's been following the Gore campaign. Wendell?
Tony, while the vice president's lawyers were fighting for his political life in court, Mr. Gore and his running mate were carrying forth the battle in the court of public opinion. The vice president canceled the trip he had scheduled to Nashville and addressed his annual family reunion conference by satellite. Instead, the conference is usually held in the summer. The Gores scheduled it in the fall this year, hoping to address it as president-elect. And he joked about that judgment call, as well as his political life being in limbo.
I appreciate this chance to speak to the Florida Supreme Court, and we decided to move this one out of the heat of the election to late November so we could be sure that it was well after the conclusion of the election. And, you know, I just assumed that by November 20th, the election would be over with, but I guess not.
The Gore campaign is scrambling to deal with the political fallout caused by Florida Democrats refusing to accept military absentee ballots without postmarks that showed they were mailed before the deadline. Much of the mail from service people overseas doesn't get postmarked. Republicans argued a potential commander-in-chief was disenfranchising his troops. Today, Florida's deputy or Democratic Attorney General said the rejected absentee ballots should be recounted. But as early as yesterday on Fox News Sunday, Senator Joe Lieberman seemed to recognize there's nothing to be gained by seeming to slight the military.
Let me just say that Vice President Gore and I would never authorize and not tolerate a strategy that was aimed at disqualifying military ballots. In fact, we think that the ballots, both the absentee ballots and the ones that are being hand counted in the 3 counties in South Florida now, deserve the benefit of the doubt. The whole idea here is to let the people express their will when they vote.
One campaign official told me privately Republicans would have been crying a blue streak if Democrats had demanded that absentee ballots sent from Israel be accepted without a postmark. But the Democrats hope that the hand recounts going on now in several Florida counties will give them more votes than they lose to George W. Bush by recounting the absentee ballots. Tony?
Thank you, Wendell. Also, just a note of clarification, folks. The letter from Florida Attorney General Robert Butterworth seems to indicate that there should be special care paid to counting military ballots, but not all absentee ballots that don't have postmarks. He's distinguishing between the two for the simple reason, at least as Republicans have argued, that some of the military ballots do not have postmarks for the simple reason that they gather them up on ships, throw them in sacks, and ship them off to the United States as quickly as possible. In any event, it's important to make the distinction between absentee ballots that are not postmarked, or at least not postmarked in a timely fashion. Those will not be counted, that's our understanding, but the military ballots without postmarks will. Now let's switch to the Bush campaign, and Brian Wilson, who's been standing by in Austin, Texas, doing duty there. Brian, what's the latest?
Well, just let me address that one point. We've not heard any official reaction from the Bush campaign about that letter from the Attorney General of Florida, but it has been the position they've been advocating, so one would assume that they are very happy about that. Former Secretary of State James Baker is going to be speaking, we understand, in Florida within the hour, and hopefully he will have something to say about that will officially put the Bush campaign on the record today. Basically, over at the campaign headquarters, we are told that they were watching those arguments before the Florida Supreme Court with rapt attention. We do not know for sure if the governor was watching, but we assume so. We saw the governor a couple of times here in Austin. He went to his office at the state capitol, spent some time there, largely doing the business of the state of Texas, which some of it has been backloaded, I'm sure, trying to catch up on some of that. And then later again, when he went to his daily workout over at the University of Texas in Austin, we got another glimpse of him there. He bantered with reporters, but did not answer any questions substantially. Once again, the military ballot issue has been a big thing, very concerned about that. Colin Powell, a man who's been talked about as a possible Secretary of State in a Bush administration, if there were to be one, was out today talking about it. So it's been something of great concern to them. And basically, they could pick up maybe another 300 or 400 votes if those other military ballots are indeed counted. Tony?
All right, Brian, thank you. Also, I need to correct one thing I said earlier on the air. I said that, well, let me just get it straight. In Broward County, they have counted 80% of the ballots in the hand recount. And in that tally, Al Gore's picked up 119 votes. In Palm Beach County, they've counted 40% of the ballots, and the vice president has picked up a net total of 3 votes. We're going to take a quick break. On the other side, we'll get some legal opinions about what took place today before the Florida Supreme Court. Stay with us.
That's what happened.
Okay. Katie, now you tell me what happened.
Well, but Grandpa, I just told you.
Well, it's only fair if we hear her side.
What, you don't believe me?
Oh, now wait a second. It's important to hear both sides of the story so that we can understand everything that happened.
Grandpa, can I tell you my side?
Oh, yes, go ahead.
When I was playing, Greg just came over and pushed me. I wasn't doing anything.
Okay, Greg, now what about...
Fox News Channel, powerful all day. John Scott, Bridget Quinn, David Asman, bringing the world to you, making the issues clearer. Powerful hour to hour. Linda Vester, Shepard Smith, Neil Cavuto. Breaking stories, aggressive coverage. Powerful all day, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide.
Opinions. I have them, you have them. In fact, on any given subject, there are as many opinions as seats in this theater. And that's good, people speaking out, sharing ideas. But opinions are not the same as facts, and you should know the difference. And that's why at the Fox News Channel, we label all opinions right on your TV screen. And that should help you form your own opinion, so you can decide what's right and what's wrong.
Presents 邪悪な魔力と戦うために選ばれた一人の戦士フォックスが放つニュータイプのエンターテイメントキュートでクールなスーパーヒロイン
お待たせ
バフィー恋する十字架彼女は高校生彼女は恋する少女彼女はヴァンパイアスレイヤー
I'm Sarah Michelle Gellar
恋する十字架ヴァンパイアと戦うことが彼女の使命
運命だったのよ
信じますね
信じますよ
運命の人がいたらいいな見てほしいです
頭がぶっ飛ぶのが愛
君とは戦わない切ない恋の行方はフォックスが放つニュータイプのエンターテイメントキュートでクールなスーパーヒロインバフィー恋する十字架毎週木曜夜10時宿命の対決か運命の恋か Only on Fox
Whether or not history ultimately looks kindly upon what we do here, I believe, will depend upon whether we have abandoned those principles of law and statutory construction and separation of powers that we have adhered to for so long.
Well, now to help us sort through the many tangled legal issues raised today in the chambers of the Florida Supreme Court, we are joined from Tallahassee, Florida, by Steve Uhlfelder, former chair of the American Bar Association's Election Law Committee, and in New York, Judge Andrew Napolitano, an adjunct professor of constitutional law at Seton Hall University, and also the host of Power of Attorney. Mr. Uhlfelder, let me begin with you. Today, David Boies, the attorney for Vice President Al Gore, said to the state Supreme Court, look, we think it is up to you to decide, A, what counts as a valid ballot, and to lay down some rules by which counties go ahead and do the accounting. Does state law provide for the Supreme Court to make decisions of that sort?
It would be very unusual, but of course this case is very unusual. I think they were seeking guidance. I thought it was the most unusual oral argument I've ever heard in that court.
Some Solomonic way out of this where both sides could get a little bit and the public would say, okay, this is a just conclusion. Is that an unfair conclusion to draw?
No, I think you're right. I think the first hour you would have to say it looked very good for Governor Bush, and the second hour it became very, very muddy and unclear. And I think they were trying to find a way to make the statute work with this election. And I think the statute, if it was working properly, would put some finality to this situation. But because of the unusual nature of having a presidential election with an electoral college deadline and giving everybody all their rights under hand counting, plus the contest provision that hasn't even been talked about much till today, that gives people another opportunity after the certification to contest it again in circuit court. So what the judges are trying to do is figure out what they can do, get the electoral college completed, and still provide people's rights under this statute.
Okay, Andrew Napolitano, what Steve Uhlfelder was just referring to is the possibility that the Supreme Court could lift its injunction on Secretary of State Katherine Harris and say, okay, you can certify a victor, but David Boies, the attorney for the vice president, said, we just want to make sure that that is not a final certification, and that maybe there could be a different final certification. How do you read that as a matter of law?
Well, you know, David Boies seemed to fall back on that position in the end, and it was almost a concession by him that the Secretary of State does have the authority to certify when the statute tells her she must. So as a matter of law, it's almost like the Gore people were admitting that. As a matter of politics, I think once she certifies, and as she certifies Governor Bush, the political pressure on Al Gore to withdraw, to stop the recounts, to withdraw the complaints in the lawsuits will be extraordinary and irresistible.
Steve Uhlfelder, also at issue is the question of what can trigger a proper manual recount. One of the things that happens is that you're supposed to take 1% of the precincts in any given county and sample those to figure out whether you have a basis to continue. Right now, we've got 40% of the ballots counted in Palm Beach County, and there's been a change of only 3 votes. What does that tell you about the propriety of the hand recount?
Well, they have a lot, I believe, that are got to take to the canvassing board, though. They have a lot set aside, and that's where the time problems come in. I believe they've got quite a few that are disputed that they have to take to that canvassing board for a decision, both, I believe, in Palm Beach, Broward, and eventually Dade. And that's where the time starts coming in, because you almost have like a quasi-judicial body there making decisions on the challenged Chad problems.
Does it seem to you, I'm sorry, let me just add, does it seem to you that the Supreme Court is going to try either itself or to get Katherine Harris to set a deadline for the final resolutions of the counts in these 3 counties?
I would think if they go with the Gore position, they're going to have to lay out some guidelines. I think that's what they'll do, and they'll put some finality to it. But it's going to be very difficult in light of the fact they have very little evidence in front of them. I doubt they're going to go as far as to say which is a proper Chad and which is not a proper Chad with no evidence before them.
Now, Tony,
and so I think they're in a difficult situation.
Tony, I agree with Steve. I agree with Steve. The Supreme Court may lay down guidelines but not deadlines for several reasons. One, it is not the Supreme Court's job to make decisions as to when recounts are due and whether a dimpled or a pregnant Chad is to be counted. That's the Secretary of State's job. And 2, the Secretary of State is in the executive branch of the government, which is a branch co-equal to the judicial branch. They must defer to her when it comes to areas of behavior uniquely within her expertise, like decisions about counting votes.
Okay, Andrew Napolitano, Steve Uhlfelder, thank you both for joining us. I'm sure we'll be talking to you again and sometime very soon. We're going to take another break. We'll have some headlines, and then on the other side, more on today's hearing before the Florida Supreme Court.
You got the tickets? You bet I'm there. I'll pick you up. Oh, wait a second. You know, I can't make it. No, I can't. Yeah, it's pretty important. I gotta go. Okay, I'll talk to you later. There's Daddy's little girl.
You know, some mornings this is just too much. Especially when it's cold and nasty outside. But you're my pal. You're always there for me, unlike some people. And I'm not gonna let you down. Come on, man, let's go outside. So, Cosmo, got any big plans for today?
Mother Nature takes her toll, raging against the elements. Fox News Channel is there, bringing you the updates. From the eye of the storms to the aftermath of destruction, make Fox News Channel your only source for complete and up-to-the-minute reports.
Channel B.
Channel B. Channel B.
Channel B.
Check it out now.
Channel B. 24時間 100% music. US, UK のトップヒット on air. Concert, music news, star 独占インタビュー and more. International music scene をそのまま catch.
What does the V stand for?
It's all about music.
Channel B.
Thursday.
今日は楽しいハロウィンナイト。平和な仮装パーティーのはずが、またも悪巧みの気配。ショータイム。
ハロウィンで幽霊のコスチューム着たら本物の幽霊になっちゃった。
バフィーが貴婦人になっちゃうなんて。
バフィーどうする？
バフィー恋する十字架、木曜夜10時 on Fox。
Just about an hour ago, Chief Justice Charles Wells gavelled down a hearing before the Florida Supreme Court, and the balance may be the presidential election of the year 2000. For a quick update and wrap on what happened today in Tallahassee, let's join Brit Baier, who's standing by. Brit?
Hi, Tony. Sitting in the courtroom, it felt like a pendulum swinging, really, as the justices were asking questions again and again, different sides, on the different issues involved here. Now, the Democrats want the 7 justices to step in and to allow the manual hand counts ongoing to be included in Florida's state total. They also want some date set for those manual hand counts to happen, and there was a major concern from the Chief Justice, Charles Wells, that those hand counts would not be finished by December 12th, the federal deadline to get all of Florida's electors named. Now, I want to introduce this one section of during David Boy's argument where he's asking the justices to set that date, and Justice Major Harding pipes up.
You've got to have all of your votes manually counted that are going to be included in this initial certification by a particular date, and then the contest, if there is one, takes place between that date and December 18th.
Do we have information in the record that can guide us? Do we know how long it's going to take to do these things? Or are we just going to reach up from some inspiration and put it down in paper?
Now, David Boies is the attorney for Vice President Gore. He went on to say that they believed that these counties could be finished in days if they're just left alone to do this work. The justices seemed very concerned that there may not be an end in sight to this before the federal deadline of December 12th. I want to introduce another time frame, another questioning session where they were talking about Secretary of State Katherine Harris and her discretion of whether to include these hand recounts into Florida's state total by 5 p.m. Tuesday. That's last Tuesday. And there was talk about her discretion, and Justice Barbara Pariente was questioning Joe Glock, the attorney for it.
She didn't really exercise her discretion. What was said was that a reason that she was not going to recognize as a reason for late filing manual recounts being conducted in accordance with 166. There was no discretion exercised. It was in accordance with her prior legal decision that recounts that were not based on machine errors were not going to be allowed, and that was what she announced the day before.
So Justice Pariente there suggesting that there was really no discretion by Florida Secretary of State Katherine Harris. The bottom line here is the questioning. Just judging by the questioning from the 7 justices, both sides really are unsure how these justices are leaning. And at this hour, we can tell you that a ruling is not coming down today, but we expect one possibly by tomorrow afternoon. Tony?
All right, Brett, thanks so much. Now we're joined in studio by former Democratic Congressman from Indiana, Lee Hamilton, now with the Wilson Center here in Washington. You wrote an op-ed in yesterday's Washington Post talking about the aftermath of this all. And it's an important thing to think about. Partisan tempers are running high in Tallahassee and in Austin and in parts in between. But sooner or later, everybody's going to have to go to work at the Capitol and get along. And it's your view that the next president is not, in fact, doomed to impotence, but could have a considerable amount of leeway. Why don't you give us your take and tackle the conventional wisdom one more time?
Well, as soon as he's sworn in, the president has all the powers, even if he had won by a landslide. There's no difference in the presidential powers. What he confronts is a very difficult political environment, and that's a daunting environment. It's going to take, I think, on the part of the president, whomever he may be, extraordinary political skills. But he'll have the full powers, and I don't think he's going to be relegated to impotence. I don't think you're going to see major changes, radical, revolutionary changes. But the people on Capitol Hill are good politicians. They know this country is not happy with Washington and the tone here, and they know how important the people think cooperation, bipartisanship is, they'll respond to that.
It's very interesting because you look at the body language of members of Congress and even people who have been at each other's throats of late, including David Baier and Denny Hastert on the House side, Tom Daschle, Senator Trent Lott on the Senate side. All of a sudden, they're making it a lot nicer. Is it going to be the fact that members of Congress are going to have to provide the adult leadership in the short term?
Well, I hope so, and I think so. I think the Congress will start that way, and I think the new president will start that way. And I think those feelings that are being expressed now are genuine. They really want to try to make things work. I don't discount that at all. The problem's going to come as the pressures begin to develop for the next election. The next president is going to look at 2004 pretty quickly, and you will see then a kind of a gridlock, perhaps a gridlock with exceptions built in. But keep in mind, we've really had a gridlock for the past few years. Even so, some good things have been done. And given the mood of the country today, where people, I think, are reasonably satisfied, I think you'll find a Congress and a president working together reasonably well, given all the constraints.
So if you take a look at the platforms of George W. Bush and Al Gore, you basically take the more adventurous proposals of each and you throw them away. It's almost like, you know, throwing away the high scores and the low scores or whatever.
That's right.
And you take the middle ground.
That's right. And you work from the center. And I think the president is going to say, okay, he cannot invite the Republican leadership in or the Democratic leadership in. He's got to invite them both in. And he does that as he shapes his proposals. He's got to have a very realistic, pragmatic sense of what he can accomplish and what he cannot. And I think the new president will have that.
Should the first order of business, either for Al Gore or George W. Bush, be, however, to do personal outreach strictly to the leaders of the opposition? In other words, say, look, I can get along with my own guys, but I need to get along with you and do some sort of special bit of stroking?
I think the president-elect will have to do a number of things. He's going to have to invite some of the members of the opposite party into his cabinet. He's going to have to invite the leaders of the opposition in the Congress as he formulates his proposals to submit to the Congress. He cannot ignore them. But keep in mind, he's got to work with his own party as well. He can't ignore them. They're the ones that got him elected. And so I just think he's going, instead of formulating his proposals, as presidents often do, only consulting with their own party leadership, he's going to have to do it with both. And he's going to have to present proposals, as you suggested a moment ago, that are centrist.
And also, the interesting thing is you're going to have this group of swing legislators on both sides, you know, moderate Democrats and Republicans, are going to have an enormous amount of power because they're the ones ultimately who are going to be controlling the shots.
Absolutely. They're going to be in the driver's seat, both parties. Who, if it's a Democratic president, Gore, then those moderate Republicans become absolutely critical, and vice versa. If it's President Bush, the moderate to conservative Democrats are going to play a key role.
Now, as you look ahead toward the next election cycle, 2 years from now, there'll be a congressional election. Is it your view that the first year could be kind of a honeymoon year? After that, everybody starts doing their positioning because whatever the opposition party is, they probably are going to think they're going to be able to take both houses of Congress.
I think so. And I think it's going to be a very difficult environment within which to govern. And on top of all of that, I think you're going to see an economic slowdown, which will really make the problems even more difficult. Dividing up a surplus is kind of fun in a way. It gets a lot tougher if you don't have the surplus.
So the good news for Al Gore, George W. Bush will be that they've been elected president. The bad news is they will have been elected president.
And the good news is that the American people are looking for incrementalism, not a major revolutionary change. The American people are broadly content. These things, I think, work for the new president.
Has anybody called for your counsel so far?
No.
Okay, well, we can pass on the phone number. Lee Hamilton, thanks so much for joining us.
Nice to be with you, Tony.
We are going to take a pause so our advertisers can advertise and we can make a little bit of money. And when we come back, we'll have some panels to lend their wisdom to today's extraordinary occurrences. Stay right here.
がビデオになりました。
怖がらないで。
大統領に噛みつく骨のあるアニメ。あんたら一体何者？
FBI のモルダーとスカリーです。
わかりますね。
はい。
宇宙人だ。覚悟しろ。子供って残酷になれるものよ。はっていい？ありがとう。
シンプソンズ始まった。
まだ。
ザ・シンプソンズ選び抜かれた傑作が4話。
それで
一つのビデオに入ってます。ビデオですから繰り返しご覧になれます。
おい、俺のビデオが出るぞ。
ザ・シンプソンズ、これを置いてないビデオショップはもぐりです。
親父見る気ある？
Come first to Fox News for breaking news, exclusive stories that impact the world, unique, timely interviews that shape our nation. First on the scene with breaking news, continuous coverage from over 70 bureaus around the globe.
We're the only ones here who still have live pictures out.
Reporters, anchors, and correspondents that are first, fair, balanced. Powerful insight, powerful perspective, powerful news. Come first to Fox News for breaking news.
Fox News Channel Daytime. The whole story in context. Facts presented fairly. The issues balanced, so you have the power to think for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
You know, some mornings this is just too much. Especially when it's cold and nasty outside. But you're my pal. You're always there for me, unlike some people. And I'm not gonna let you down. Come on, man, let's go outside. So, Cosmo, got any big plans for today? There you go.
This court certainly has the power to say, what we're going to do is tell the county boards that you've got this amount of time to complete your recount. And at that point, those votes are then subject to being contested by Governor Bush or Vice President Gore. And those contests then take place in a time frame that allows everything to be completed by December 12th.
There, you got that? We're going to try to make it clear. We've got in studio here with me Jeff Birnbaum, Washington Bureau Chief of Fortune Magazine, and from Tallahassee, Bill Sammon of the Washington Times. Bill, you've been out there taking in the atmosphere. I gather we got a lot of protesters and other stuff going on. What is people's sense of what actually took place in that courtroom today?
Well, it's really hard to take anything definitive away because, you know, when I started watching it, I thought, boy, these guys are being kind of tough on the Democratic side with all their questions. But then when the Republicans got up there, they were just as tough, if not tougher. So I think it was almost a case of where the justices were playing devil's advocate, purposely being contrarian to draw out as much information as they could. The one thing I did take away is that they're very concerned with the timetable. I mean, they don't want Florida's electoral votes not to count. And in a broad sense, that may be good for Bush because, of course, Bush is ahead at the moment. And to the extent that you put in timetables, he may be able to run out the clock if he can remain ahead. But if they keep it completely open-ended, I think that tends to favor Gore.
Well, I agree with Bill, and I'd be a little more emphatic about it. I think the one thing that was clear was that these justices, if they have anything to say, they will bring an end to this in not too terribly long. They would definitely not like to miss the December 12th deadline, which is the deadline for the selection of electors to go to the state capitol and cast their votes for president on December 18th. And so that means that every day won't be election day, at least into January. It may come sooner. The question is, how do they balance finding a deadline and also allowing the hand recounts, which I think a number of justices absolutely did show a great deal of sympathy for? How do you allow that to be completed and yet meet the deadlines they hope to meet?
Well, in fact, the two might be on a collision course, because there was a lot of talk about working backwards from December 18th, to December 12th. And, I think even Boris said maybe there could be a 7-day period for a contest. Now you're into early December. Meanwhile, Miami-Dade has said, look, we're not even going to be done until December 1st. Now, we know how those deadlines have gone. Those have fallen by the wayside in other counties. It's perfectly reasonable to expect that there will be some snags that will push the Miami-Dade count into early December, and perhaps up against whatever timetable the justices may want to put out there, which I think is what the Democrats were asking them to do, is put out some framework, some timetable where we could have a bunch of deadlines set up. Okay, let's clarify the terms of our debate here a little bit. What you have is you got an election. Every county has certified results. Some of the counties want to change the results based on hand recounts. Now, the way the law works is once you get a certified result, once the Secretary of State says so-and-so has won, then begins what Bill Sammon just referred to, the contest period. People can contest certain ballots in different counties throughout the state, and that's almost certainly going to happen with regard to some of these punch ballots in southern Florida. Now, my question for Jeff Birnbaum is this. There has been no uniformity of standards. Broward County's changed its rules several times. Palm Beach County has changed its rules several times. David Boies, attorney for the vice president, said to the Supreme Court, you got to make up a standard and tell us what it is.
That's right.
Do you think that's going to happen? Do you think the Supreme Court is going to tell everybody what the law is on counting valid and invalid ballots?
I think it may end up in their lap no matter what, but it was pretty clear from a number of the questions from the justices asking where do we get the wisdom to decide what is a proper vote and what is not, a pregnant, a double-cornered Chad. They were clearly not very eager to wade into those waters, but even if they don't give guidance, it's pretty clear that during the contest period, that disagreement about what is a valid vote and what isn't will come back to them eventually. They may have to give at least some guidance or at least designate who is to decide what a standard is, whether it's the county or the Secretary of State. It is a very important issue that I guess my bet is the Supreme Court won't tackle this time.
Bill? And in fact, Tony, one of the justices asked I think it was the attorney for Broward County, why have you changed your standard even since you have filed papers with us? And when the guy explained why they had done that, the justice said, well, in all the previous elections that you've had in Broward County, didn't you establish a standard in any of those elections, for whether it'll be a swinging Chad or a dimple Chad? And the guy said, well, not that I'm aware of. He seemed fairly clueless as to whether there had been a standard. So, I mean, it opens up a whole other can of worms as to whether or not you can go back to previous elections and see whether they had standards for those elections. And if so, why aren't they adhering to them now?
Okay, Bill Sammon, Jeff Birnbaum, stay with us, folks. We're going to have a quick break, and we'll be back with more.
No. We agree on just one thing. A good argument's the best way to get to the core of an issue.
Wait a minute, I don't agree with that. A discussion's the best way. You have to explain, reason, justify your position.
Everybody on TV is discussing things, Alan. That's boring. If you want to find out what people really think, you need a good argument.
No, a discussion's better.
An argument.
A discussion.
We can agree on this. It's your turn to pick up the check today.
Well, I'll argue that one.
Alan, let's see if we can discuss this.
Remember him? He was such a jerk.
A complete jerk, but so cute.
So wrong.
Yeah, but
everybody told you.
I know, but I didn't want to hear it.
You listen to me.
That's different. I trust you. When you tell me something, I know it's the truth.
Well, in that case, trust me. That was one ugly dress.
24 hours, 7 days. The most powerful name in news brings you the world. Fox News Channel, the power to bring you the people and places, from mega markets to emerging nations, reports that make a difference. Power to cover the events that shape the planet, the global forces changing your life. The power of Fox News Channel. News and information, fair and balanced. The most powerful name in news, Fox News Channel. We report, you decide.
There's nothing new going on in Washington. No new issues, scandals, or controversy, because Washington has always been a hotbed of egos, emotions, and intrigue. The only difference now is that the press and media are all over it, with more cameras and more reporters than ever before. But how can you be sure you're getting the whole story, fair and balanced? Well, watch the political fireworks here and catch the best show around.
見たかったものがここにある。エンターテインメントチャンネルといえば FOX しかない。華麗なトリックの裏側を仮面のマジシャンがついに全て公開。破られたマジシャンの掟、謎に包まれたストーリー、真実を知るのは今。 X ファイル特別版モアシークレットファイル。あまりにも無力な人間、追跡、生死を分けた大暴風。生き残りをかけてかつてないバトルが繰り広げられるワールドレスリングフェデレーションスペシャルサバイバーシリーズ。救いを求める人を放ってはおけない危機一髪世界の救出劇。ニュース番組の裏側を描いたブロードキャストニュース。ドラマを超えた衝撃。ツインピークス劇場版。マイケル・キートン主演のマシンガン・ジョニー。12月も話題作続々 FOX ムービー。感動と興奮がここにある。本物のエンターテイメントはいつも FOX から。
Welcome back. There you are looking at a picture of hand recounts continuing now in Miami-Dade County. Those recounts began today. There is an action picture of somebody stacking cards and handing them to somebody else. And that's kind of the way it goes. This is tedious and extraordinarily boring work. In any event, none of us has any clue what's going to happen before the Florida Supreme Court. But that leaves us with one option, which is to speculate about various alternatives and various scenarios. First, I want to go to Tallahassee and Bill Sammon. Bill, today, Florida's Attorney General, Bob Butterworth, sent out a letter to the counties saying you need to count military absentee ballots. My first question is there any binding legal impact to that letter?
I don't think that the law rests within him to determine whether those things should be counted or not. It was my impression that that was more of a PR move, not to be cynical about it, but the Gore team has taken a lot of hits over this issue because this gets people riled up. I mean, our men and women overseas, they're not going to be able to cast ballots. So that was clearly a loser, and I don't think the Gore folks had pulled back enough from that. Lieberman backpedaled a little bit with you yesterday and on some of the other Sunday talk shows, but I think today this was a way of saying, look, we want all these things to count. I don't know that that's binding. I think that's more for public consumption.
Okay, Jeff Birnbaum, Florida Secretary of State actually had issued an advisory before the election saying you don't have to have a postmark, so she could instruct the various election boards to count them up.
Yeah, I think the result of this will be that these military overseas absentee ballots will be counted, and it will result in many more votes for George W. Bush, probably in the hundreds, maybe 500 or so, giving him an extra leg up, depending on what happens with the hand recounts that are going on in the heavily Democratic counties, Palm Beach, Broward, and Dade. This gives Bush a big advantage, and he may need it.
Bill?
Those 500 could, you're right, absolutely right, Jeff, because they could be so crucial because the vote is so close, and I've seen people have actually extrapolated based on how many votes Gore has gained so far and how many are still to be counted, that it would be extremely close with this 930, that it would be like 904 or something like that. So Bush could use a 500 vote cushion. So if these things if the military ballots do get counted, that's a big victory for him.
Now, Jeff, what happens also if the Supreme Court says, as many have speculated today, that the Attorney General can at least provisionally certify a winner, say George W. Bush is the winner pending any other stuff?
Right.
What's the political impact of that?
The Secretary of State.
Yeah.
The political impact is huge. Once a victor is declared, most Americans are not watching this as closely as we are, and they should be congratulated for that. But they will begin to wonder why Gore or whoever is certified the winner, why the loser hasn't conceded, being sort of a bad sport about it. Once an election is certified, people think that's the end of it. And so it is a public relations coup for whoever wins and a real conundrum for the loser at that point.
Bill Sammon, is the betting there that the Supreme Court is, in fact, going to permit the Secretary of State to go ahead and certify?
Well, again, I don't want to take too much away from the arguments I heard today, but one thing that was planned, at least in my mind, was that they seem to be setting themselves up to at least provide for a period of contest, meaning, you know, we could let her certify now, perhaps, and then, you know, if you still have a problem, you can contest it. So since the timetable is so limited, I came away with the feeling that one of the possible things they could do is come out and say, well, look, here's how we're going to split the baby down the middle. We're going to let her lift this stay, if you will, let her certify it, but explicitly then say, if anyone wants to contest it, you can go ahead and do it. But I agree with Jeff, once it's certified, you're locking into an official number, and it's sort of like protesting a baseball game after it's over. People basically don't pay that much attention to it. The game is pretty much won or lost.
All right. All right, Bill Sammon, thank you for joining us from Tallahassee. Jeff Birnbaum, thanks for joining us in Washington. We are expecting former Secretary of State James A. Baker to speak soon. On the other side of the break, special report with Brit Hume.
You know, some mornings this is just too much. Especially when it's cold and nasty outside. But you're my pal. You're always there for me, unlike some people. And I'm not gonna let you down. Come on, man, let's go outside. So, Cosmo, got any big plans for today?
Fox News Channel Daytime. You want to make the right choices. We give you the power to decide for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
And Grandpa, that's the whole story. That's what happened.
Okay. Katie, now you tell me what happened.
Well, but Grandpa, I just told you.
Well, it's only fair if we hear her side.
What, you don't believe me?
Oh, now wait a second. It's important to hear both sides of the story so that we can understand everything that happened.
Grandpa, can I tell you my side?
Oh, yes, go ahead.
When I was playing, Greg just came over and pushed me. I wasn't doing anything.
Okay, Greg, now what about...
Fox presents
科学分析クローバー危険人物関与目撃証言消去
だが真実はそこにある X ファイル on Fox
さあスカリー行くぞ
2人の FBI 捜査官が挑む世界の裏側の巨大な謎
I think that we've succeeded in doing that first and foremost. It's become a lot of other things, but I think it is a scary show.
X ファイル全米のメジャーなテレビショーを連続受賞
The X-Files has really caught on because I think people around the world have to be scared.
X ファイルその魅力は今も世界中にファンを生み出し続ける
X ファイルよくできてますよねもっと続けて来週はどんな話なんだろう見ればハマる
テレビ史上
真実が知りたい
かつてない
答えを見つけて
進化し続ける最高傑作真実はそこにある目撃者はあなた X ファイル毎週月曜夜10時 Only on Fox
Questions suggest it may be ready to set aside the deadline set by law. Meanwhile, a lower court judge says no to a Palm Beach County revote. First, though, other headlines.
Fox News Live, I'm Lori Dew. Our top story this hour, Florida Supreme Court is ground zero in the battle for the White House. 7 judges, all appointed by Democrats, heard arguments from lawyers for Al Gore and George W. Bush. The issue, should recounted votes be added to each candidate's total? Right now, Bush leads by 930 votes. The Texas governor spent the day in Austin. He did not comment on the Florida situation. Mr. Gore addressed a conference in Tennessee by satellite. Aides say he did watch the Florida hearings on TV. Meantime, the recount continues in 3 heavily Democratic counties. For now, it looks like Gore is not picking up very many new votes. Special report with Brit. Hume will have all the details from Florida in just a moment. To the Middle East now, where the Palestinian Authority is calling Israeli missile strikes criminal aggression. The missiles hit targets in and around Gaza City. Israel says the strikes were in retaliation for a bomb attack on a school bus. 2 teachers were killed, 9 people were hurt, including 5 children. And if you forget to get your flu shot before the cold season hits, have no fear. The Food and Drug Administration says the new drug, Tamiflu, is an effective backup if taken daily. But the FDA says you should still get a flu shot. Next update at the bottom of the hour. Now special report with Brit Hume. Much more on the election deadlock with reports from Florida, Texas, and Washington.
Welcome to Washington. I'm Brit Hume. Lawyers on both sides of the Florida recount dispute ran into a barrage of questions before the Florida Supreme Court. But the most persistent and aggressive question seemed reserved for those arguing that the Secretary of State's authority to disregard late-hand recounts should be upheld. More on the story from correspondent Jim Angle in Tallahassee. Hi, Jim.
Hello, Brett. Well, the lawyers for 2 campaigns, 2 counties, the Attorney General, the Secretary of State, and a voter group went before the state Supreme Court in hopes of ending the legal chaos over Florida's presidential vote. And the Democrats insist that a manual recount is only fair.
The right to vote includes the right to have that vote counted.
But the Secretary of State said last Tuesday's deadline was the cutoff. Gore's lawyers say no, that the legislature established recounts knowing they couldn't be completed by the deadline. But the Democrats not only want the recounts to continue, they also want the court to legitimize the loosest possible standard for deciding which votes will now be reinstated.
It is quite important that this court be as specific as possible in terms of the standard to be applied so that we will have uniformity.
The Secretary of State's lawyer says there was no fraud. The Democrats are trying to count votes that were not cast properly.
What we're trying to do is to deal with the problem of people who did not follow instructions. The instructions were to put the stylus through the hole in the ballot. They did not follow those instructions.
And the justices seem troubled by the constantly changing standards that the counties use to recount ballots.
Isn't there something unusual about changing the rules in the middle of the game?
If the deadline set by the legislature should not stand, the justices wondered, what should the deadline be?
What is the time limit then?
Well, Your Honor, if I were sitting in your chair, that would be a difficult question for me. It is an even more difficult question standing where I am.
A difficult question indeed. In fact, Britt, the justices wanted to know that if last Tuesday wasn't the deadline, then what is it? And who sets it? They wanted to know what authority the court has to impose its will in place of the state legislature just because Gore's lawyers want them to. They were also worried about another deadline that's out there that is unmovable, and that is the deadline in federal law, December 12th, for Florida to name those who will be voting in the Electoral College. And if it doesn't meet that deadline, Florida's votes will not be counted in the presidential election. Not only that, but the justices also wanted to know if there's no deadline for the recount, then when will George W. Bush have time to challenge it if he thinks it's wrong? Britt?
Jim, it struck me, and maybe it struck you, that the justices seem much more worried about that federal deadline than they did about the deadline set by the statute. Did anybody down there seem to think that these justices would be unwilling to adjust that state deadline?
No, it doesn't seem like it, Brett. In fact, they have twice ruled that the recount had to continue, so they seem perfectly willing to keep the recount process going. That would obviously mean having a new deadline. Their problem is they can't figure out what the new deadline would be or what authority they have. There did seem to be some misgivings on the part of the justices as they searched and asked people, what authority do we have to just pluck a deadline out of the air, as one justice put it. How do we decide what the deadline should be? Now, the Gore's lawyers clearly don't want the last deadline to stand, but they couldn't give them any guidance on who should pick it, what the authority would be, or when the next one should be. That's because they don't know when the recount process is going to be over with. And now they are depending on that recount process, Brit, because so far Gore is not getting enough votes out of that to overcome the lead that George W. Bush has at the moment, so they must have the process continue as long as possible. The problem is it can't go on forever because there has to be time at the end of this process for George W. Bush to come in and say, wait a minute, I don't think this was fair. I have a legal right to challenge it as well.
Or for Al Gore to do that.
Or for Gore to do it, that's true.
All right, Jim Angle, thank you very much. Meanwhile, workers in 3 Florida counties are combing through hundreds of thousands of ballots without knowing whether they'll ultimately be counted. Broward, Miami-Dade, and Palm Beach counties are all in the midst of full-hand recounts. And though Al Gore has picked up some votes, he still lags hundreds of ballots behind George W. Bush. And that trend could continue if the overseas military ballots are revisited. Fox News' Carl Cameron joins us now live with details from West Palm Beach. Hey, Carl.
Hi, Britt. Well, while the Supreme Court was in session in Tallahassee, a couple of developments elsewhere. In Palm Beach County, a judge ruled out the possibility of a revote, and the Bush camp got what may be very good news from the Democratic Attorney General, a Gore ally in Florida, who said that after having had so many of the absentees overseas military ballots disqualified for lack of a postmark, that they should in fact be re-looked at. And he sent a letter to the counties saying that they should go back and accept military overseas ballots if they don't have a postmark. That could mean hundreds of additional votes for George W. Bush in one big block, in a process that otherwise has been continuing at a snail's pace. In Broward County, the only Republican canvassing board member, Jane Carroll, has quit, saying she can't handle the long days.
It looks like another pregnant punch for Bush.
About 60% of Broward's 588,000 ballots have been manually recounted, with Gore gaining 119 votes. As many as 1,500 challenged ballots so far will not be countable now until the vacant board position is refilled. Republicans are railing against evolving standards for countable ballots, human error, and alleged partisanship to help Gore. For instance, this Democratic attorney, who was first a partisan observer, then became a ballot counter handling the ballots. In Palm Beach County, nearly half the 462,000 ballots have been manually recounted, and Gore has gained 3 votes so far, but as many as 500 ballots have been challenged and will be subject to recounting by the canvassing board's 3 Democratic members. Republicans complain here that after 10 years of not counting the indents or dimples, the county now does, again changing the rules to help Gore.
You can object all day and night if you want. You can sit here all day and be very upset and yell at all these folks. That's up to you. I don't care.
Miami-Dade County began its hand recount Monday at 8 a.m. and expects to continue through December. To speed up the process, they used a 3rd mechanical recount over the weekend to sort out about 10,000 ballots without any presidential holes punched. Republicans called the move an attempt to damage the delicate ballots to help Democrats. After the first few precincts were manually recounted, Gore had gained 12 votes, with 654,000 to be recounted overall.
Just so the canvassing board should read.
Elsewhere in Pinellas County, officials have asked Florida's Attorney General to investigate election night counting errors. 937 ballots were counted twice, and 1,435 ballots were never counted at all. In Seminole County, a pro-Bush region, there's another case that could prolong the uncertainty. A judge has agreed to consider a lawsuit next week to nullify 15,000 absentee ballots because Republican election officials filled in missing data on 4,700 absentee ballot requests. They would otherwise have been rejected, and Bush carried the absentee ballots in that county by 5,000. Tens of thousands of votes, still very much up in the air. The Bush lead ahead of Al Gore now by less than 820 votes. In the 3 counties that are currently recounting, there are 1.7 million votes that will be manually recounted when all is said and done, meaning his margin of error is about 1/20th of 1%. Democrats thus far not complaining about the process, everybody eager to get it over with. Brett?
So what did that judge say in turning down the request, if anything, when turning down the request for a complete revote in Palm Beach County? That was based, I take it, on the allegedly misleading ballot, correct?
The butterfly ballot in which so many of the votes that went to Pat Buchanan, even by that candidate's own admission, might have been meant for Al Gore. He said that he did not have the authority to call for a recount, for a revote, I should say, and pretty much laid it to rest permanently. Though after the court proceedings, some of the litigants, some of the plaintiffs suggested they may be appealing that decision, meaning uncertainty continues to loom. Brit.
All right, Carl, thanks very much. Coming up, were votes from the military wrongfully discarded or not? That story next.
If making money were simple, we'd all be millionaires. Let's face it, money decisions are tough decisions. You need to know what's going on here and how it will affect your finances, your future, and your family. We cover the markets in plain English so that when the bell rings, you can understand what happened and decide what's right for you. We bring Wall Street to Main Street so maybe you can live on Easy Street.
Fox News Channel Daytime. You want to make the right choices. We give you the power to decide for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
胸騒ぎの夜、フォックスが待っている。エンターテイメントが待っている。Fox Tuesday。夜9時、フィアンセはゲイなのか。調査の末に浮かび上がった事実とはスヌープス。夜10時、死にゆく赤ん坊を諦めきれない母親。シカゴホープ。夜11時、元殺人犯が精神病院からの退院を申請。ボストン弁護士ファイル。ザ・プラクティス。Fox Wednesday。夜9時、手かざしで患者の病状を言い当てる女性。エクストラオーディナリー。夜10時、女はその男に身を委ねた。ミッキー・ローク、キム・ベイシンガー共演。官能の世界が解き放たれる。フォックスムービー、ナインハーフ。Fox Thursday。夜9時、リサに強力なライバルが現れた。シンプソンズは2本立て。夜10時、仮想のつもりが本物になっちゃった。何者だ。バフィー、恋する十字架。夜11時、怪物ビッグブルーの正体は X ファイル。胸騒ぎの夜、フォックスが待っている。エンターテイメントが待っている。Fox Tuesday。スヌープス、シカゴホープ、ザ・プラクティス。Fox Wednesday。エクストラオーディナリー、フォックスムービー、ナインハーフ。Fox Thursday。シンプソンズ、バフィー、恋する十字架、X ファイル。吹き抜けるハリウッドの風、今日本にもうフォックスしかない。
Throughout this whole recount saga, one deadline has seemed definite: the timeline for overseas absentee ballots to be counted. They arrived, they were tallied, and many, especially ballots from the military, were thrown out. Now some say the men and women who protect our country are losing a voice in choosing their commander-in-chief. Fox News' William Jeunesse joins us now live. Hi, William.
Hey, Brit, it appears like a victory for Governor Bush that the Attorney General is now going to allow the counting of these overseas absentee military ballots. However, a word of caution. What the Attorney General said to the counties, it is only a letter. It's not an opinion, and it is not a directive. The Florida Democratic may challenge this, they say, if any counties go in and attempt to count overseas military ballots.
41 for George W. Bush, 59 for Al Gore, and 3 for Ralph Nader.
While canvassing boards in South Florida are bending over backward to find voter intent among ballots favoring the vice president, is the same consideration being given votes for Governor George Bush from soldiers and sailors overseas?
By a ratio of 2 to 1, the votes of overseas ballots, largely men and women in uniform, were knocked out and disqualified.
Fact is that the decisions are being made by local officials who are there to represent the public, not any political party.
But this is a political fight over 1,527 overseas military ballots, disqualified under Florida law by local boards.
What a shame. It had an address from your witness.
Here in Miami-Dade, there were 113 federal write-in ballots. 110 out of 113 were disqualified.
Disqualified because, according to state law, the ballot lacked a postmark, the signature of a witness, or the witness's address. Problem is, Florida law contradicts federal law, which allows members of the military serving in combat zones to mail their ballots without any postage at all.
They're our heroes. My husband is risking his life for our freedom, for our right to vote.
Abby Krug's husband, Chad, is a carrier pilot whose vote wasn't counted because he mailed it from aboard the USS Washington.
He was very disappointed to hear that.
According to the Pentagon's policy, there are instances when time constraints do not allow for proper postmarking or cancellation of the mail. No one is going to refuse to take a letter or ballot at the last minute because they don't have time to postmark it.
So these are some of the discrepancies that we've been dealing with, but we keep losing.
The idea that one party or the other is manipulating this system is just myth and fraud.
The political fight continued till noon Monday when Florida Attorney General Bob Butterworth stepped in with a legal solution. He said this office believes Florida and federal law support the counting of overseas military ballots from qualified electors registered to vote in the county if one of the following two conditions is met. One, the ballot is postmarked no later than the date of the election, or the ballot is signed and dated no later than the date of the election. No man or woman in military service to this nation should have his or her vote rejected solely due to the absence of a postmark. Some believe this may be a political move on behalf of the Attorney General. We'll have to wait and to see if the Democratic Party accepts it. Brit?
So what is the practical effect, though, of this letter? It's the Attorney General's opinion. He's not the chief officer with regard to elections. I guess that's the Secretary of State. The deadline that she set has passed. Certification hasn't happened. Where is this matter? Practically, what's going to happen with regard to these military ballots?
Well, it does direct the counties to go back in and look at them again, which I anticipate will start happening tomorrow. I did talk to one county, and they plan on doing that. What it does do in terms of negotiations between the Democrats and the GOP is the civilian ballots, well, those had to be thrown out because they lacked maybe a signature or a date, and then the military did, and they both agreed to that. Well, suddenly now the military ballots have to, by directive anyways, or by letter, have to be accepted, and the civilian ones are still thrown out.
And the civilian ones, of course, are the ones thought most likely to favor Vice President Gore, correct?
Exactly. That's right, Brit.
All right, William, thanks very much. Coming up, how did the court hearing go in Tallahassee? To get a legal perspective, we'll ask Georgetown University's Paul Rothstein. Next, stay tuned.
Opinions. I have them, you have them. In fact, on any given subject, there are as many opinions as seats in this theater. And that's good, people speaking out, sharing ideas. But opinions are not the same as facts, and you should know the difference. And that's why at the Fox News Channel, we label all opinions right on your TV screen. And that should help you form your own opinion, so you can decide what's right and what's wrong.
Grandpa, that's the whole story. That's what happened.
Okay. Katie, now you tell me what happened.
Well, but Grandpa, I just told you.
Well, it's only fair if we hear her side.
What, you don't believe me?
Oh, now wait a second. It's important to hear both sides of the story so that we can understand everything that happened.
Grandpa, can I tell you my side?
Oh, yes, go ahead.
When I was playing, Greg just came over and pushed me. I wasn't doing anything.
Okay, Greg, now what about...
There's nothing new going on in Washington. No new issues, scandals, or controversy, because Washington has always been a hotbed of egos, emotions, and intrigue. The only difference now is that the press and media are all over it, with more cameras and more reporters than ever before. But how can you be sure you're getting the whole story, fair and balanced? Well, watch the political fireworks here and catch the best show around.
Presents 邪悪な魔力と戦うために選ばれた一人の戦士フォックスが放つニュータイプのエンターテイメントキュートでクールなスーパーヒロイン
お待たせ
バフィー恋する十字架彼女は高校生彼女は恋する少女彼女はヴァンパイアスレイヤー
I'm Sarah Michelle Gellar
恋する十字架ヴァンパイアと戦うことが彼女の使命
運命だった
信じますね
信じますよ
運命の人がいたらいいな見てほしいです
頭がぶっ飛ぶのが愛
君とは戦わない
切ない恋の行方はフォックスが放つニュータイプのエンターテイメント、キュートでクールなスーパーヒロインバフィー恋する十字架、毎週木曜夜10時。宿命の対決か運命の恋か、 Only on Fox。
The oral arguments in this case went on for 2 hours and 25 minutes this day, and here at Fox News, watching it with us, was Professor Paul Rothstein of Georgetown University Law Center. Welcome again, Professor. Nice to have you.
Thanks, Brit. Nice to be here.
Now, how much can be read into the questions that are asked by judges in a hearing like this about their intentions, as a rule?
Well, they were tough on both sides in this hearing. I think they were a little tougher on the Bush side, actually. And my conclusion is that maybe they were tending a little bit against the Bush side. But you have to be cautious because they play devil's advocate. You never know if they're just trying to elicit information from the side they're being tough on so that they can take those answers and put it into their final decision.
Or in an argument with another justice.
Or with an argument with another justice.
Now, the side that the Bush side of this argument, which was also the side of the Secretary of State of Florida, basically was that this is a simple case, that there's a deadline set in the statute, and that the deadline is a mandatory deadline, not a flexible deadline, and that she has some discretion to allow a little flexibility with regard to it, but that it's basically up to her. Yes. And that the legislature wanted it that way, that the state constitution makes her the chief elections officer, and so on, that this is a simple case. Was there anything about the questions that...
A little bit, and Gore doesn't get any more votes, that it'll have a natural end with a lot of legitimacy to everybody.
Now, there was talk about a different deadline today that the justices seem to take very seriously, and that is the federal deadline for submission of results so that the electors can come to Washington on the 18th and vote, and that is the 12th of December. Now, they did seem to care very much about that deadline, didn't they?
That's right. They have to. That's right. That was talked about a lot. They have to get this decided by December 12th so that by December 18th, the electoral vote goes to Washington. And that was the time pressure on that end that they were very concerned about when talking to Gore's people. How can you have all this recounting of the big counties? You bump up against that deadline. But on the other hand, the Bush folks wanted to have this 7-day cutoff, 7 days after the election. They said to them, the justices said, well, there's provision in the law for recount. How do you accomplish recounts of big counties in just 7 days? So there was a time constraint on both ends, and they're very worried about that. And I think the question before them does come down now, listening to them talk, it comes down in their mind to time.
Right.
We're going to have to set a time. Somebody's going to have to set a time, either us or we're going to have to tell the Secretary of State, Harris, to set the time.
Now, they talked about another process here, which has been contemplated on the Gore side. David Boies spoke about it on Friday before this stay was in, and that is the question of a contest, which is something that happens after the election has been certified by the Secretary of State. Explain how that fits into this equation.
First, there's a protest, which is what's been going on now, and then the Secretary of State or the state announces a decision as to who has won the election. Certification, right. And then after that, there's a period of contest where the grounds are much narrower and the burden of proof is very heavy on the people who are contesting that certification. Right. And as a matter of practical politics, I think once the Secretary of State does that certification, that a person who tries to contest it is going to look like a sore loser because it's one more official announcement that Bush has won.
Right, but on the other hand, as a practical matter, that is another factor adding pressure for a deadline, isn't it?
That's right, because you have to fit in the protest and the contest before December 12th. Boies said he's willing to accept as a fallback. He argued for Gore as a fallback that, all right, you guys can go ahead and certify as long as the judges order that you can still do the recount and modify that certification if the recount comes in for Gore, and that would be considered part of the contest period.
But don't the justices have to be concerned that if they allow this recount process to go forward and the contest can't really take shape until after it's over, that they don't prejudice the right of either side to contest the election and have enough time for that process to play out.
That's right. Ultimately, they're looming up against that December 12th deadline. If there are no Florida electors decided at that point, it goes forward to Congress without the Florida electors, and the election's decided on the basis of who has a majority of the remaining electors in the country. The Constitution says that, and that would be Mr. Gore. So I don't know, is there a stalling game going on here or not? I don't know.
Now, I suppose it would be, it didn't sound to you as if at the end of the day, I may have asked you this before, but it didn't sound to you as if at the end of the day, the justices were going to finish scratching their head and asking their questions and conferring with one another and say, you know, the legislature was right. That 1 week deadline made sense.
Well, they might, because the other things are fraught with practical difficulties. But I think what perhaps the most politic thing to do that would have the most legitimacy, that would go along with their predilections here, which are, I think, to let the recount go on some reasonable amount of time, but not bump up against December 12th.
Right.
I think rather than them setting the deadline, although they may want the Secretary of State to set the deadline so that it has some more legitimacy. It's not a court decreeing something. They'll give her some guidelines, and they'll do the same thing with standards for the recount. That was a big issue too. Standards
they've
for
also
the
been
recount.
asked to set the recounts on the dimples and the pregnant chads and all that.
If the court set standards like that, it would look like legislation. What's at war here is two views of what courts should do, the Republican view and the Democrat view. Should courts get into this and act like legislators or not?
I got you. Paul Rothstein. We have to take a quick break for other headlines, but when we return, find out why a piece of Chad is considered a piece of history in the making. Thank you.
News Channel, Primetime Power. Neil Cavuto, Brit Hume, Shepard Smith, powerful coverage. Wall Street, Washington, the world. Bill O'Reilly, Hannity and Combs, Paul Liasson, powerful insights, confronting the politics, the newsmakers, and the issues. Primetime Power, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide.
And Grandpa, that's the whole story. That's what happened.
Okay. Katie, now you tell me what happened.
Well, but Grandpa, I just told you.
Well, it's only fair if we hear her side.
What, you don't believe me?
Oh, now wait a second. It's important to hear both sides of the story so that we can understand everything that happened.
Grandpa, can I tell you my side?
Oh, yes, go ahead.
When I was playing, Greg just came over and questioned me. I wasn't doing anything.
Okay, Greg, now what about...
You Decide 2000, exclusively on the Fox News Channel. Powerful coverage from America's election headquarters. Review, Shepard Smith, Bill O'Reilly, Hannity and Combs, Paul Liasson. Fair and balanced reporting from America's election team, giving you the power to decide. You Decide 2000, from the most powerful name in news, Fox News Channel. We report, you decide.
Fox, Thursday.
今日は楽しいハロウィンナイト。平和な仮装パーティーのはずが、またも悪巧みの気配。ショータイム。
ハロウィンで幽霊のコスチューム着たら本物の幽霊になっちゃった。
バフィーが貴婦人になっちゃうなんて。
バフィーどうする？
バフィー恋する十字架、木曜夜10時 on Fox。
Fox News Live, I'm Lori Dew. In Florida, this question, should the recount count? The state Supreme Court is hearing arguments from lawyers for Al Gore and George W. Bush. The justices will not make any decision until at least tomorrow. If the election were certified today, Bush would win by 930 votes. The Texas governor says he feels great, but is keeping quiet about the Florida situation. Meanwhile, Mr. Gore joked about it as he addressed a Tennessee conference via satellite. But jokes aside, he kept a close eye on the court hearing today. Meantime, the recount continues in 3 heavily Democratic counties, and it looks like the vice president is picking up surprisingly few new votes. And a terrible day on Wall Street. Tech stocks took a nosedive, pushing the NASDAQ to its lowest level in 13 months. The Dow also took a beating. The closing numbers, the NASDAQ was down 151 points, or 5%. It's back under the 3,000 level. That index has fallen 43% since April. The Dow's loss was also in the triple digits. The blue chip stocks took a hit of 67 points to end the day at 10,462. Coming up at the top of the hour, the Fox Report with Shepard Smith. Shep is in Tallahassee, where he's been for the last week and a half, as Florida Supreme Court decides whether to allow the recounts to be counted. But now, more special report with Brit Hume. He'll have much more on the standoff in Florida.
And now the latest pickings from the political grapevine. When Gore advisor Warren Christopher and campaign chairman Bill Daley went to Capitol Hill to shore up support for the vice president last week, they reportedly told worried Democrats that if Gore could not win on the hand recounts in Florida, he would not pursue the matter further. Time magazine says the two men admitted that the principals, meaning Gore and Joe Lieberman, quote, weren't there, meaning they had not agreed to give up after the recounts, but says Time, Christopher and Daley said they, meaning Gore and Lieberman, will be there. A Miami Herald analysis of Broward and Miami-Dade County voting records reveals that at least 39 people who had been convicted of felonies illegally cast ballots in those 2 counties. The Herald said those who voted included people with convictions ranging from murder and rape to drunk driving and passing bad checks. One of them, the paper said, was even a poll worker. The Herald quoted her, a woman named Cheryl Jones, as saying she was convicted of dealing cocaine 15 years ago when she was 35, adding, quote, I feel like I'm a one-time felon, and that was years ago, and I think all that should be thrown out. The Smithsonian's Museum of American History is eager to gather historical relics of the Florida election deadlock and has dispatched a curator to West Palm Beach to begin gathering items. Among the things sought, one of those now famous voting machines that was actually used to count the punch card ballots. The curator, Larry Bird, says he does not expect to get one of those voting machines right away, but will certainly be collecting one of those controversial butterfly ballots and, of course, a sample of that remarkable substance collectively known as Chad. Statisticians are saying that Al Gore's chances of winning on the Florida recounts appear to depend on the rules that apply to the counting. One professor, Bruce Hansen of the University of Wisconsin, told the New York Post that based on results to date, Gore is on a path to get between 533 and 934 votes from the 3 counties. But under a restrictive counting rule, one that would bar, for example, inclusion of so-called dimpled Chad ballots, he would likely end up in the low end of that range, around 500 votes, and would fall short necessarily of the votes needed to win. Vice President Gore was supposed to be in Nashville this day, attending a so-called family reunion, end quote, with community leaders in Tennessee, but he changed his plans and decided to stay in Washington because of the unfolding legal drama in Florida. Fox News' Wendell Goler has details. Wendell?
Brit, the vice president addressed the family reunion conference by satellite, and that simple change of plans showed how much he counted on winning the election 2 weeks ago and how much his life has been left in limbo.
I appreciate this chance to speak to the Florida Supreme Court, and
The vice president joked at the start of a satellite address to the annual family conference he and his wife have hosted for the past 9 years. It's usually held in the summer. The Gores moved it to the fall this year, thinking they could host it as first family elect.
I just assumed that by November 20th, the election would be over with, but I guess not.
Gore also canceled plans to address the conference in person, and while the Florida Supreme Court held his legal hopes, Gore's campaign tried to douse a political fire over Democrats' initial refusal to accept undated absentee ballots from servicemen and women stationed overseas. Republicans said GIs should be given as much the benefit of the doubt as people who were confused by the ballots used in some parts of Florida, or those who didn't push the Chad all the way through.
We shouldn't disenfranchise our GIs if there's anything we can do to avoid that.
Service people appear to have favored George W. Bush by a wide margin, but Democrats can't afford to slight them. What they're hoping is that Gore will gain more votes in the hand recount of several Florida counties than Bush will gain if all military absentee ballots are allowed.
We think that the ballots, both the absentee ballots and the ones that are being hand counted in the 3 counties in South Florida now, deserve the benefit of the doubt.
One Gore aide said privately Republicans would have cried a blue streak if Democrats had pressed to count undated absentee ballots from Americans in Israel. But the campaign recognizes Republicans have caught them between a political rock and a hard place over the military absentee ballots. Brit?
Wendell, what is the likely response of the Gore camp on the question of if they don't win on this Florida Supreme Court? Are they likely to appeal that to the U.S. Supreme Court?
Well, officials won't rule it out. I pressed that question today, but they really hope to settle this matter under state law, and constitutional experts suggest why. Some legal experts say there is little chance the Supreme Court would accept for review a definitive ruling by Florida's Supreme Court. Brit?
All right, Wendell, thanks very much. Some analysts have noted that in the briefs filed before the Florida Supreme Court, the Gore camp does not raise any U.S. constitutional issues that would then form the basis of an appeal to the U.S. Constitution. The U.S. Supreme Court, excuse me, U.S. Supreme Court is not accustomed and does not usually hear cases growing out of state law as long as there's no federal question involved. George W. Bush, meanwhile, is back to the business of running the state of Texas. He has been in Austin for the past few days and has been at work at the governor's office in an effort to present a business-as-usual demeanor. Fox News' Brian Wilson joins us now live from Austin. Hi, Brian.
Hello, Brit. Exactly right. At Bush campaign headquarters, we know very clearly they were paying rapt attention to those arguments before the Florida Supreme Court, but no official comment from anyone here in Austin. We did see the governor a couple of times today coming in and out of his state capitol office. He bantered with reporters and camera crews, but although they tried to throw a few questions at him, he did not answer any specific questions. Then again, a brief glimpse of him at the University of Texas after his daily workout. We are told he returned to the Capitol and did watch some of the arguments of the Florida Supreme Court while he was conducting other business for the state of Texas. And again, Britt, there has been no official comment about the letter issued from the Florida Secretary of State suggesting perhaps that they should count those overseas military ballots. Now, that's a move that could, of course, net the the Bush camp several hundred votes. It is a position that they have advocated for several days, but no official reaction. They're remaining very, very quiet here in Austin today. Britt?
All right, Brian, thank you very much. Coming up, Florida's Secretary of State Katherine Harris is no media darling. Why has she provoked such a strong reaction from the press and others? That story next.
You know, some mornings this is just too much. Especially when it's cold and nasty outside. But you're my pal. You're always there for me, unlike some people. And I'm not gonna let you down. Come on, man, let's go outside. So, Cosmo, got any big plans for today? There you go.
Hey, kid, come on over here. I want to show you something. I want you to listen to me now, okay? Because you got to get this ready or else you're never going to make it. Now, if it goes over too much way this here, it's no good. If it falls over this way too much, it falls all over you. You got to make sure you got balance.
Balance?
All right.
見たかったものがここにある。エンターテインメントチャンネルといえばフォックスしかない。華麗なトリックの裏側を仮面のマジシャンがついに全て公開。破られたマジシャンの掟、謎に包まれたストーリー、真実を知るのは今。 X ファイル特別版モアシークレットファイル。あまりにも無力な人間、追跡生死を分けた大暴風。生き残りをかけてかつてないバトルが繰り広げられるワールドレスリングフェデレーションスペシャルサバイバーシリーズ。救いを求める人を放ってはおけない危機一髪世界の救出劇。ニュース番組の裏側を描いたブロードキャストニュース。ドラマを超えた衝撃ツインピークス劇場版。マイケル・キートン主演のマシンガン・ジョニー。12月も話題作続々 FOX ムービー。 感動と興奮がここにある。本物のエンターテイメントはいつもフォックスから。
For nearly 2 weeks, the country has been fixated on Florida and the efforts to stop and start recounts underway there. And since the saga began, one woman has emerged as a central figure in the case, Florida Secretary of State Katherine Harris. And she has quickly felt the venomous bite of the media. Fox News' Eric Shawn joins us now live with that story. Hi, Eric.
Hi, Brit. You know, she has been likened to Linda Tripp. She's even been called the Cruella de Vil of this story. Of course, that's the evil, mean woman of 101 Dalmatians. Katherine Harris learning the hard way that you can have a torrent of abuse when you're in the public eye and that prominence can bring pitfalls. Now the Media Research Center in Washington is coming her defense, calling some of the criticism offensive and unfair. Not just the Saturday Night Live send-ups, that satire, but other claims such as the Gore campaign spokesman Chris Lehane calling her a political hack and a Soviet commissar. Defense attorney Alan Dershowitz last week on television, national TV, called her a crook, although there's no evidence of that or of any wrongdoing. The center says many news stories even call her a Republican Secretary of State. They do not necessarily call Bob Butterworth, the Democratic Attorney General of the state, a Democrat in dealing with the party labels. Democrats, of course, say that she is partisan because she was the co-chair of the Bush campaign in Florida. So, Brit, we may, at the end of this process, not only find out who will be president, but how she feels about being in the public eye and the way that she has been portrayed in this process.
Is she doing any interviews or in any way defending herself?
No, not yet. She has had many news conferences, Brit, of course, but she basically restricts herself to the subject of the recount. But I'm sure when this is all over, she will be doing sit-down interviews, and I'm sure that here on the special report, you could be asking her about how she feels about the way that she has been portrayed in the media.
Well, Eric, if you just get out there and book her for me, I'd be grateful.
We'll try, Brit.
All right, thanks, buddy. See you later. A man who was one of the most visible defenders of President Clinton during the impeachment saga has died. Attorney Charles Ruff was 61. Recently, Ruff also helped advise Gore's legal team in Florida on the brief they filed Saturday before the state Supreme Court. Ruff's wife found him unconscious Sunday at their Washington home. Police say there was no sign of foul play. Fox News' David Schuster has details.
Charles Ruff made a career of defending politicians with legal problems. Nearly 2 years ago, he led President Clinton's defense in the Senate impeachment trial.
William Jefferson Clinton is not guilty of the charges that have been preferred against him. He did not commit perjury. He did not obstruct justice. He must not be removed from office.
Charles Ruff grew up in Cleveland and graduated from Columbia Law School in 1963. The wheelchair dated back to a post-graduation trip to Africa. Ruff volunteered to teach law in Liberia and was afflicted with an unknown virus that eventually paralyzed his legs. Over the years, friends say Ruff never talked about his disability and was unwilling to let it define him or his life. Ruff entered hardball Washington politics in the 1970s, serving as the fourth and final Watergate prosecutor. Later, he was an associate deputy attorney general. In the 1980s, Ruff worked for a private firm representing clients including Anita Hill and her sexual harassment accusations against Supreme Court nominee Clarence Thomas. In 1997, President Clinton named Ruff White House counsel. The Lewinsky scandal broke a year later.
There was no basis for the House to impeach, and there is now and never will be any basis for the Senate to convict.
Colleagues of Ruff say he was cool and calm and was the one who kept the White House team focused.
He was a great guy, and he was a very nice, easy guy to get along with. Even during the impeachment, at the most extraordinary of times, if you walked into his office, he'd always ask you about your kids, about your spouse.
Ruff's death, suspected to have been caused by a heart attack, came as a shock to the White House and especially the president. Hours after returning from a trip to Vietnam, Mr. Clinton visited Ruff's family. In a paper statement, the president said, "All of us at the White House admired Chuck for the power of his advocacy, the wisdom of his judgment, and the strength of his leadership." Charles Ruff was 61. In Washington, David Schuster, Fox News.
And please don't touch that remote, folks. The Fox All-Stars are coming up next.
Open the car. No sooner said than done. But don't worry, they're not making them to act that way when you're driving around a curve. It's just for demonstration. And there are slow-motion demonstrations of motors at the New York Auto Show. The magic mechanical speed creeps lazily, an intimate glimpse of intricate motion. And there's knee action, insight into smooth riding. New models galore, snappy models in this big year, boom year for the automotive industry. Here's a one-man top that works with the greatest of ease, sometimes with too much ease. It opens quickly, smoothly, and even indiscreetly. Uh-oh, it's a revelation, and how? The one-man top and the one-girl embarrassment. Cars for 1941, the latest in automobiles, and the newest thing in headlights. Here's a sleek auto equipped with another type of the shut and open. And now for something that isn't a shut and open question. One of the lessons of which we are constantly reminded these days is that the technical and industrial genius of a nation is all important for its defense. That hood opens and reveals complex automotive mechanism with interesting shapes and technological forms. Ah, and the whole body of the car opens and reveals some more shapes and forms. Interesting, if not technological.
You Decide 2000, exclusively on the Fox News channel. Powerful coverage from America's election headquarters. John Scott, Bridget Quinn, David Asman, Linda Vester, Shepard Smith, Neil Cavuto. Fair and balanced reporting from America's election team, giving you the power to decide. You Decide 2000, from the most powerful name in news, Fox News Channel. We report, you decide.
Channel V.
Channel V. Channel V.
Channel V.
Check it out now.
Channel V. 24時間 100% music. US, UK のトップヒット on air. Concert, music news, star 独占インタビュー and more. International music scene をそのまま catch.
What does the V stand for?
It's all about music. Channel V.
Whether or not history ultimately looks kindly upon what we do here, I believe, will depend upon whether we have abandoned those principles of law and statutory construction and separation of powers that we have adhered to for so long.
This court certainly has the power to say, what we're going to do is tell the county boards that you've got this amount of time to complete your recount. And at that point, those votes are then subject to being contested by Governor Bush or Vice President Gore. And those contests then take place in a time frame that allows everything to be completed by December 12th.
If two short pieces of argument can sum up the two sides, those two probably do it as well as any. You heard Barry Richards arguing for the Bush side, for a strict interpretation of law and statute and precedent. You heard David Boies arguing for a more expansive view of things, with the court stepping in to set various deadlines and to basically administer the proceedings. That is a pretty good summation of the difference between judicial activism, advocated by Mr. Boies, and judicial restraint, argued for by Mr. Barry Richards. To analyze all of that now are a couple of activists and restrained interpreters. First, for the restrained interpretations, Fred Barnes, executive editor of the Weekly Standard. For a more activist view, Mort Kondracke, executive editor of Roll Call, and right down the middle from our New York studios, Mara Liasson, correspondent of National Public Radio, Fox News contributors. All, first of all, your judgment, each of you, about how this argument went and what we can determine or safely guess from the behavior of the justices. Fred?
Well, I thought the behavior of the justices was they lived up to their reputation. They're going to be an activist court. They don't care what the law says in Florida much. In fact, at one point they asked about, well, what's the law in other states? You know, maybe we'll use that law if they have a good way to get us out of this fix. I mean, it's clear they agreed with David Boies, who argued very well, and that bite you had on there, he had sensed which way, from all their questions, which way they were going, and was offering the solution, you know, exactly how they might decide.
Yeah, he was acting like one of their clerks.
Exactly, and they may well decide that way. You know, when you got down, when the chief judge kept asking about, you know, we've got to meet the December 12th deadline to have the electors picked and so on. And then he said at one point, he said, well, wouldn't it be a better thing to do? In other words, this was their solution, a better thing to do, ignoring the law. I don't think any of those justices had read the briefs. They didn't mention them. I mean, they are very activist, expansive, and clearly on Gore's side.
Well, look, the law, there is a conflict in the law. One part of the law definitely says that the Secretary of State shall certify so many days after the election. That's the Republican position. The Democratic position is that the law says that in evaluating how people voted, or whether ballots are valid or not, you try to determine what, as best possible, the intent of the voter. Now these are in conflict, and this court is going to decide one way or the other.
In Volusia County. Volusia County had a hand recount and got it in on time.
I know, but
so why was that? So
but there was the whole issue of bigger counties, and can bigger counties meet these deadlines?
Hire more people.
Well, look,
hire more counters.
Okay, all right. Look, that is the dispute here between the two sides. I think that the court. I think that the court. Look, the only deadline that the court seemed to be caring about was the date. It was December 11th when they had to have the electors.
There was not much evidence that they cared very much at all about the deadline set by their own legislature.
That's right.
All right, Mara, go ahead.
Yeah, it doesn't seem like they're in any rush to shut this process down and give it back to the Secretary of State. But as far as Volusia County goes, yes, they were quite speedy in doing their hand recount. But I think that if the other counties had been equally speedy and had come up with a huge avalanche of votes for Gore, I think the Bush campaign would be contesting them right now. I mean, they wanted those hand recounts declared illegal. It's not just that they weren't done speedily enough for the Bush camp.
Well, I know, but what the Bush camp wanted and didn't want is a little separate from what the Secretary of State said her legal requirements were. I think that we all agree that the drift of the argument, at least as it can be interpreted from the justices' questions, were that they're quite ready to set up a regimen of their own here with their own with deadlines and so on, or as Professor Rothstein suggested, perhaps to order the Secretary of State to do it to meet their specifications.
Right.
It doesn't appear that there's any hope for the Bush side anyway that that they were going to uphold the statute or her actions as they stand. Correct.
Right. That's correct. And the other question is, will they go further? Will they lay down deadlines, and will they tell people how they should count? One of the things that's been the most confusing so far is that different standards are being applied in different counties. You know, whether or not a dimpled chad should be counted, or whether it has to be perforated, and that's something that the court is going to have to arbitrate too. I mean, if they're going to be the body that decides what is a fair way to count votes, they're going to have to get involved in a lot of minutia.
The Democrats are absolutely depending on somebody, either these county canvassers who are Democrat-dominated, or better, the Supreme Court, saying thou shalt count dimpled, pregnant chads that, or you know, little marks on them or something.
Well, statistical analysis has suggested that based on how this thing has gone so far in terms of the number of votes Vice President Gore has gained, that he will need a loose interpretation of the ballots and intent of the voters in order to get enough votes to win.
Right.
Does anybody doubt, by the way, on this panel, by the way, that if a loose interpretation is used, that he will ultimately win the election? What do you think, Mort?
This decision on the part of the Attorney General to count all the military ballots will run.
It's just a recommendation letter.
And
I think the Democrats are going to have to back off on that, and they're going to have to count these because it's so politically.
Why are they going to be nice now?
So politically damaging.
Go ahead.
The Democrats can't say that the military ballots have to be thrown out on a technicality and then argue for a looser interpretation of the Chad rule. I mean, they can't do that.
Exactly
they have to be consistent.
what they have been arguing, Mara.
But they can't. But they're starting to back away. You heard Joe Lieberman this weekend.
Well,
they can't pull that off.
Hold it. can the Republicans at the same time ask for a very gentle and easygoing interpretation on the military ballots and then turn around and want to be all strict on the ballots that come in from Israel and other places?
I don't think so. I don't think they can. And wait a minute. And I also don't think that the Republicans can delegitimize the Supreme Court, the state Supreme Court, and say they're a bunch of Democratic partisans, because if it turns out that Gore doesn't get enough votes in the recount, they're going to want the state Supreme Court to look very legitimate.
The Bush people haven't said that, Mara. I've said that. The Bush people haven't said that, though I have a feeling they think that.
There have been Republicans who've said that.
Let me explain to you, Mara, let me explain to you the difference between a ballot in Palm Beach or Broward County where you don't know who submitted it and a ballot sent in by a military person overseas who has signed it. You can easily find out what their intent is. Call them. And that's what, and because of that, it's completely different.
You can't call somebody on a secret ballot.
Well, wait a minute.
You can't call up somebody and ask them.
If you want to find out what their intent is, why can't you do that? Their names
No, it doesn't make any difference.
It's not a secret ballot because they have their name. They've signed it.
But the ballot itself is secret. It's in an envelope. It's on an envelope.
Get the envelope. You can find it. Of course you can do that.
Look,
you can't ask people how they voted.
Just a second. But the important fact is that everybody thinks that Gore's not gaining fast enough. The fact is that there are 2,300 ballots that haven't been counted yet that are on a reserve stack.
They're on a
disputed list in Palm Beach County and 10,000 in Miami-Dade.
All right, that's where the votes would come from. That's all the time we have for the panel, but stay tuned for a look at how other countries handle presidential disputes. We'll be right back.
Fox News Channel Daytime. You want to make the right choices. We give you the power to decide for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
What? You got the tickets? You bet I'm there. I'll pick you up. Oh, wait a second. You know, I can't make it. No, I can't. Yeah, it's pretty important. I gotta go. Okay, I'll talk to you later. There's Daddy's little girl.
Fox News Channel. Powerful all day. John Scott, Bridget Quinn, David Asman. Bringing the world to you. Making the issues clearer. Powerful hour to hour. Linda Vester, Shepard Smith, Neil Cavuto. Breaking stories, aggressive coverage. Powerful all day, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide.
Fox presents 科学分析クロー危険人物関与目撃証言消去
だが真実はそこにある X ファイル on Fox さあスカリー行くぞ2人の FBI 捜査官が挑む世界の裏側の巨大な謎
I think that we've succeeded in doing that first and foremost. It's become a lot of other things, but I think it is a scary show.
X ファイル全米のメジャーなテレビショーを連続受賞
The X-Files has really caught on because I think people around the world have to be scared.
X ファイルその魅力は今も世界中にファンを生み出し続ける
X ファイルよくできてますよねもっと続けて来週はどんな話なんだろう見ればハマる
テレビ史上真実が知りたいかつてない
答えを見つけて
進化し続ける最高傑作真実はそこにある目撃者はあなた X ファイル毎週月曜夜10時 Only on Fox
Finally, a possible preview of what it might look like if this election had to be settled in the Florida legislature. Watch the scene in the Japanese parliament as the man at the lectern, a former wrestling champion, now a first-term member of that parliament, was trying to defend Prime Minister Yoshihiro Mori against a no-confidence vote.
They want to deal with this situation right now. It is natural for them to feel that way. However, this action itself is very provocative.
内閣不信任案の採決が行われてまだ
これから採決という直前この内閣不信任案の採決が行われてまだ
And that's special report for this time. Please come again next time. And in the meantime, stay tuned for news, fair and balanced as always.
The Florida Supreme Court to rule with the presidency in the balance. Will hand-counted votes from 3 heavily Democratic counties be in the mix or not when the race is certified? The two sides' arguments, the justices' questions, and fair and balanced analysis as Fox reports right now.
Live from Tallahassee, the Fox Report with Shepard Smith. Fair news, balanced news now.
And good evening from the capital of Florida, where the focus of the world is on the state Supreme Court, as Fox reports tonight. To this date, the 7 justices heard 2.5 hours of arguments over whether hand-counted votes from Miami-Dade, Broward, and Palm Beach counties should be included in the final ballot totals. Now, George W. Bush has 930 votes more than Al Gore, but if the hand recounts are in the mix, both sides believe that could shift the lead to the vice president. We have Team Fox coverage tonight, beginning with our senior correspondent, Jim Angle, live in Tallahassee. Jim.
Hello, Shep. Well, the 2 campaigns, lawyers for the 2 campaigns, for 2 counties, for the Secretary of State and the Attorney General went before the Supreme Court in hopes of ending the legal chaos surrounding the presidential vote. Now, the questions they have to answer are, should last Tuesday's deadline stand? Should recounts of votes, manual recounts, be legal? And if so, what are the standards? The Democrats are worried about so many different standards being used, and they argue that there must be the loosest possible standard for deciding which votes will now be reinstated.
It is quite important that this court be as specific as possible in terms of the standard to be applied so that we will have uniformity.
Now, the problem is there are different standards between the counties. Also, some of the counties have used different standards at different times. The justices seemed a little perplexed by that, and they wanted to know if there was some, why there kept being changing standards in recounting those ballots. Here's what they said.
Isn't there something unusual about changing the rules in the middle of the game?
Was that a standard that was in existence as of the date that this election took place, or is this something that has come up after the fact?
Justice Pariente, this is something that came up after the fact.
So you can see the justices were a little concerned about the fact that the standards keep shifting. The other problem, of course, is if the old deadline doesn't stand, the justices wanted to know, what should the new deadline be?
What is the time limit then?
Well, Your Honor, if I were sitting in your chair, that would be a difficult question for me. It is an even more difficult question standing where I am.
Now, what they wanted to know, if last Tuesday is not the deadline, then what is it and who sets it? And the justices wanted to know what authority they had to impose their will over that of the state legislature, which specifically set a particular deadline. There was one other concern, and they said, look, if we can't figure out what the deadline is, there is one deadline that cannot be changed. And that, Shep, is December 12th, when the state must decide who will vote in the Electoral College. And if they don't meet that deadline, Florida's votes in the presidential election would not be counted. The justices also said if we don't have a deadline that gives some time before then, how would George Bush or Al Gore, whoever loses, have the opportunity to challenge that in the courts? So a lot of questions here from the justices, Shep.
No doubt about it. Our senior correspondent, Jim Angle, live for us at the Florida Supreme Court. Now, there are a lot of issues to tangle with between now and the time that the justices make a final decision. We know only one thing for certain: that decision will not come today. No one inside the court suggesting it will be tomorrow, but a lot of people are speculating. Inside that courtroom today, our correspondent, Brit Baier, with a coveted seat. Brit, what was the tone?
Well, Shep, it started out very cordial, about 200 people inside that courtroom, and then Immediately, when the questioning started from those 7 justices, the tension became thick. The justices, as Jim mentioned, really having a barrage of questions to both sides. Both sides were grilled equally. We want to show you a couple of those segments. One, David Boies, the attorney for Vice President Gore, was making the point that their side wants the justices to step in and set some sort of deadline where this certification can happen. Justice Major Harding then piped up.
You've got to have all of your votes manually counted that are going to be included in this initial certification by a particular date, and then the contest, if there is one, takes place between that date and December 18th.
Do we have information in the record that can guide us? Do we know how long it's going to take to do these things? Or are we just going to reach up from some inspiration and put it down in paper?
So that was a major concern. Where was this date coming from that the Democrats really want the justices to decide on? Another issue was when they talked about the 7 days that Florida Secretary of State Katherine Harris had by Florida law set that she was going to accept all of the counties' certifications. The attorney for Governor Bush, Mike Carvin, said that big counties have more resources and they could possibly get it done in that amount of time. But Justice Harry Armstead piped up and asked if he had done, that is, Mike Carvin had done, any research on this issue.
Have you researched the statutes in other states to compare them to Florida's?
I'm not aware of whether they're mandatory or not. I know that there's never...
I'm just asking whether you have researched other states to see whether they have comparable statutory schemes. Have you?
No, I'm not aware of...
So, I mean, you haven't researched other states, is what your answer is?
No,
You haven't. Okay, thank you.
So both sides grilled for more than 2.5 hours. Now 4 out of the 7 justices have to agree before something is decided on here. Again, obviously no ruling today, but there may be one tomorrow. An interesting time inside that courtroom, and tensions high as both sides winced at some lines of questioning behind the scene. Afterwards, both sides shook hands, and obviously it's anybody's ball game right now, Shep.
Still no decision. Brit Baier live for us at the Florida Supreme Court. Now, at the center of the dispute, Palm Beach County, Florida, the home of the controversial butterfly ballot and more than 500,000 votes. As Fox reports tonight, about 1 of 5 has been recounted by hand, with Al Gore picking up a net total of 3 votes. Fox News correspondent Carl Cameron in West Palm Beach now with a late update. Hello, Carl.
Hey, Shep. Well, they're saying here in Palm Beach County that they probably won't be done until after Thanksgiving. There was a decision in a district court across town that said that there will be no revote based upon challenges to the so-called butterfly ballot, wherein a lot of votes that people said were intended for Al Gore ended up going to Pat Buchanan. That was just one of the developments outside of the Supreme Court's proceedings in Tallahassee. In addition, today, there has been a development from the state's Attorney General, Bob Butterworth, a Democrat and Gore ally, who has written to the counties and suggested that they should go ahead and re-look at all the absentee overseas military ballots and consider recounting those that didn't have a proper postmark. Of the 3,500 some odd absentee overseas ballots, there were about 1,500 that were disqualified because they didn't have a postmark, and that caused quite a controversy. And now they could be recounted, and it could be several hundred new votes for George Bush. As we tick off the various counties here, we can start in Broward County, where they are about halfway through their 600,000 some odd ballots counting. And in that particular county, Gore has picked up a net gain of over 100 votes, about 112 at this point, which would bring Bush's lead down to under 800 votes. Broward County also facing a number of other objections from Democrats and Republicans particularly, who say they should not be counting the indent, the so-called dimples. Palm Beach County, same sort of a problem. Here, a net gain of for Al Gore of 3, and while they have counted about 1/5 of the precincts, in actual ballots, they're closer to halfway done. Still, the process has been very slow, and Democrats are complaining in Palm Beach County that the standards are so high that Al Gore hasn't picked up as many votes as they would have hoped. Moving down to Miami-Dade County, they began the manual recounts this morning at 8 o'clock after a weekend of mechanical counting, and there they're saying they won't be done until December. Finally, two other counties that aren't actually doing recounts but do have relevance here. Pinella County, they are actually now in a situation where they might have to go back and take a look at the overseas ballots again. There's a lawsuit there that would have some 15,000 of them tossed out because Republicans were taking part. And in Seminole County, also issues of what's been legal. They may be recounting there as well. Shepard.
Carl Cameron live for us in West Palm Beach, Florida. With the proceedings continuing in Tallahassee, where are the contenders? Bush and Gore sightings today. What did they do? What did they say? And what are their strategies now? We'll have live reports from Austin and the district. What if you were one of those justices today? Which side gave the more convincing argument? To which side did the court seem to lean, if either? Brit Hume weighs in just a moment. And a Fox focus on the Florida Secretary of State, Katherine Harris, thrust into the limelight. The inside story of one of the key players in the race to the White House as we report, so you can decide. From the state capital of Florida, live to homes around the globe, this is your news, fair and balanced. You're on a special edition of the Fox Report from Fox News Channel.
Fox News Channel, primetime power. Neil Cavuto, Brit Hume, Shepard Smith, powerful coverage. Wall Street, Washington, the world. Bill O'Reilly, Hannity and Combs, Paul Lazan, powerful insights, confronting the politics, the newsmakers, and the issues. Primetime power, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide. Fox News Channel Daytime, the whole story in context. Facts presented fairly, the issues balanced, so you have the power to think for yourself. Fair and balanced, the most powerful name in news. Fox News Channel, we report, you decide.
Hey, kid, come on over here. I want to show you something. I want you to listen to me now, okay? Because you got to get this right or else you're never going to make it. Now, if it goes over too much way this here, it's no good. If it falls over this way too much, it falls all over you. You got to make sure you got balance.
Balance?
All right.
感動、興奮、見たかったものがここにある。エンターテインメントチャンネルといえば、フォックスしかない。華麗なトリックの裏側を仮面のマジシャンがついに全て公開。破られたマジシャンの掟。謎に包まれたストーリー。真実を知るのは今。X ファイル特別版モアシークレットファイル。あまりにも無力な人間。追跡、生死を分けた大暴風。生き残りをかけてかつてないバトルが繰り広げられるワールドレスリングフェデレーションスペシャルサバイバーシリーズ。救いを求める人を放ってはおけない危機一髪世界の救出劇。ニュース番組の裏側を描いたブロードキャストニュース。ドラマを超えた衝撃。ツインピークス劇場版。マイケル・キートン主演のマシンガン・ジョニー。12月も話題作続々。フォックスムービー。感動と興奮がここにある。本物のエンターテインメントはいつもフォックスから。
Well, the lawyers for Bush and Gore telling their sides before the Florida Supreme Court today, but which side gave the more convincing arguments? And exactly what are they here to decide? Fox managing editor Brit Hume with us now from D.C. Brit, watching the proceedings today, it seems sometimes that they were deciding not whether to include the hand-counted ballots, but how.
I agree with you, Shep, and I think that without judging who gave the most convincing argument, it seemed to me pretty clear from the questions and the way that various lawyers were treated which side had the argument that the court was most predisposed to agree with. They were very interested in getting help, for example, from David Boies in figuring out what kind of regimen that they might impose on the process, what sort of new deadlines they might impose to allow not only for the hand recounts to go forward, but to allow enough time for contests, if any, to occur as well, and still not violate the deadline of December 12th for the electors to be submitted so that they could participate when the Electoral College meets on December 18th. That's the only deadline that this court seemed to care very much about, which was the deadline of December the 12th. The one written in Florida law seemed not to matter to them at all, and that may account for the reason why this particular court has had difficulties with this particular legislature in recent years.
But of course, this idea of how much time it would take to contest anything that might happen next is a very subjective thing and doesn't really have a place for partisan politics.
Well, but it's all about partisan politics. Now, it should be understood in political terms, Shep, that if the election is certified, and what you then have is a certified result that is being fought sort of after the fact by one side or the other, the court of public opinion comes into play here, and you begin to look like a sore loser. So while in legal terms that might be something that would be helpful to the Gore side, in political terms it may not be. Now, the court may figure out a way to rule on this or have Catherine Harris ordered to go ahead and certify, but with an asterisk that would mean that it was a certification without meaning and so on. We'll just have to see how it plays out. But this was a court that seemed today to be prepared to live up to its reputation as being activist and not necessarily one bound by what the Florida legislature has put into law.
And Brit, surprisingly enough, some of the analysts this afternoon suggesting that maybe, even if you add them all up with a recount, Al Gore still might not have enough. Then what would he do?
Well, that's one of the things that the court was asked to deal with, Shep, is the standards for the judging of the recounted ballots, whether dimpled chads and pregnant chads and all that sort of thing should be counted as a vote, and whether you can divine a voter's intention properly in that way. The more votes that are counted and allowed to count, the better Mr. Gore is almost inevitably going to do, because the counting is going forward in counties where the preference for him was overwhelming. So the higher the volume of votes counted, the likely higher volume of votes he gets. The smaller the volume, the other way around. The only thing that might offset that, Shep, is if those military overseas ballots are counted and Mr. Bush does overwhelmingly well, it's conceivable he could pick up 200-300 votes from that process, and that might offset the margin and make this much closer. But it would seem likely, based on the lead he now has, that if the dimpled chads and the pregnant chads and the partially torn chads and all that stuff that favors him are all counted, even if the ones that are the similar for Bush are counted too, that he will pick up enough votes, certainly that's what Democrats think, to take the lead.
All right, Brit Hume live with us in Washington. Brit, thanks. And though we don't see much of them, George W. Bush and Al Gore must be integrally involved with the process behind the scenes somewhere. So where were the two during the proceedings today? Team Fox coverage continues now with Wendell Goler following Camp Gore in Washington. But first tonight to Brian Wilson with the Bush camp in Austin. Hello, Brian.
Hello, Shepard. You know, they were paying very close attention over at Bush election headquarters on what was going on before the Florida Supreme Court. It could be heard on the monitors and TV sets throughout the building, but no official comment from the Bush campaign here in Austin. We did see the governor on a couple of different occasions today. This morning, as he came in and out of his office at the state capitol, he bantered with reporters and camera crews, but did not answer any specific questions. We saw him again at the University of Texas after his daily workout. The governor did eventually end up back at the Capitol office, where he watched some of the proceedings, we are told, before the Florida Supreme Court while he caught up on a backlog of Texas business. Now, there has been no official comment from the Bush campaign about the Florida Attorney General's letter suggesting that counties count the overseas military ballots. Now, that's a move that could, of course, net George W. Bush several hundred votes by some estimations. Certainly, they are pleased about that. Although we've had no official comment, it is a position they've been advocating for several days. Shep.
All right, from Brian Wilson in Austin, let's go to Wendell Goler in Washington now following the Gore camp. Hello, Wendell.
Hello, Shepard. The vice president canceled the trip to Nashville and addressed his annual family reunion conference by satellite instead. The conference is usually held in the summer. Gore scheduled the thing in the fall this year, hoping to address it as president-elect, and he joked about that judgment call, as well as his political life being currently in limbo.
I appreciate this chance to speak to the Florida Supreme Court, and we decided to move this one out of the heat of the election to late November, so we could be sure that it was well after the conclusion of the election. And, you know, I just assumed that by November 20th, the election would be over with, but I guess not.
The Gore campaign is scrambling to deal with the political fallout caused by Florida Democrats refusing to accept unmarked absentee ballots on postmarked absentee ballots from service people overseas. Now, Republicans argued a potential commander-in-chief was disenfranchising his troops. Today, Florida's Attorney General said all military absentee ballots should be recounted. But as early as yesterday on Fox News Sunday, Senator Joe Lieberman seemed to recognize there was nothing to gain by seeming to slight the military.
Let me just say that Vice President Gore and I would never authorize and not tolerate a strategy that was aimed at disqualifying military ballots. In fact, we think that the ballots, both the absentee ballots and the ones that are being hand-counted in the 3 counties in South Florida now, deserve the benefit of the doubt. The whole idea here is to let the people express their will when they vote.
Democrats recognize they can't nitpick over military absentee ballots. They hope to gain more from the hand recount in Florida, southern Florida counties than George Bush gains from counting all military absentee ballots. Shepard?
Wendell Goler live for us in Washington, and there's much more to come as Fox reports tonight, and You Decide 2000. Stay with us.
Remember him? He was such a jerk.
A complete jerk, but so cute.
So wrong.
Yeah, but
everybody told you.
I know, but I didn't want to hear it.
You listen to me.
That's different. I trust you. When you tell me something, I know it's the truth.
Well, in that case, trust me. That was one ugly dress.
If making money were simple, we'd all be millionaires. Let's face it, money decisions are tough decisions. You need to know what's going on here and how it will affect your finances, your future, and your family. We cover the markets in plain English so that when the bell rings, you can understand what happened and decide what's right for you. We bring Wall Street to Main Street so maybe you can live on Easy Street.
Opinions. I have them, you have them. In fact, on any given subject, there are as many opinions as seats in this theater. And that's good, people speaking out, sharing ideas. But opinions are not the same as facts, and you should know the difference. And that's why at the Fox News Channel, we label all opinions right on your TV screen. And that should help you form your own opinion, so you can decide what's right and what's wrong.
There's nothing new going on in Washington. No new issues, scandals, or controversy, because Washington has always been a hotbed of egos, emotions, and intrigue. The only difference now is that the press and media are all over it, with more cameras and more reporters than ever before. But how can you be sure you're getting the whole story, fair and balanced? Well, watch the political fireworks here and catch the best show around.
Decide 2000, exclusively on the Fox News Channel. Powerful coverage from America's election headquarters. John Scott, Bridget Quinn, David Asman, Linda Vester, Shepard Smith, Neil Cavuto. Fair and balanced reporting from America's election team, giving you the power to decide. You Decide 2000, from the most powerful name in news, Fox News Channel. We report, you decide.
Channel B.
Channel B. Channel B.
Channel B.
Check it out now.
Channel B. 24時間 100% music. US, UK のトップヒット on air. Concert, music news, star 独占インタビュー and more. International music scene をそのまま catch.
What does the V stand for?
It's all about music.
Channel B.
Well, in Miami-Dade and Broward counties, the card-by-card recount does continue, as Fox reports tonight, with more than a million votes cast in those 2 counties and heavily Democratic leanings. They could be crucial in the race to the White House. Team Fox coverage continues now with Orlando Salinas live for us tonight in Miami-Dade. Orlando?
Hey, Shep, this monster recount of more than 500,000 votes here in Miami-Dade County keeps rolling along as we speak. They started right around 9:30 this morning. They'll keep going till about 8 o'clock tonight. Now, a little while ago, we did speak with election officials at the Miami-Dade County Government Center. We said, look, do you have any sort of plan when the state Supreme Court finally makes its decision about those recounts? They told us, look, we're not going to speculate on anything. We're just counting. Basically, bug off. They've been bouncing back and forth between 14 and 25 teams of counters, slowing the process down just a bit. So far, officials reporting only 11 of 614 precincts have been recounted. Unofficially, Al Gore picking up about 12 more votes. They'll have new numbers in just a couple of minutes. Democrats very happy happy with that, but Republicans, no way. One Republican congressman even saying that Democrats are, quote, rigging votes for Al Gore. Other Republicans say the Miami-Dade recount is one big mess.
When you bend the ballot, like they're doing at this table right now, the effect of that is to run the risk of popping a chat that was never intended to be voted. And so our concern, frankly, is that they are creating votes, not counting votes.
Look for GOP lawyers to be in a Miami-Dade courtroom tomorrow morning trying to convince a judge to stop that recount. Let's go a little further north now in Broward County, where teams are into their 6th day of recounting. Now, that canvassing board in search of a brand new member, here is why. 70-year-old Jane Carroll, the lone Republican on that all-important board, well, she says after today she is done with this recounting business. Jane Carroll said she had no choice. She made plans a long time ago to visit her son for Thanksgiving. He lives out of town, so she is going to see her boy. Look for a Democrat to fill her post. Dems also say the recount will go on no matter what Carroll does, thanks to counters who they say are doing their duty.
They're trying to do their civic duty, and yet they're being disparaged as being stupid or incompetent or corrupt when they're actually being very patriotic.
The latest Broward numbers we have, 523 out of 609 precincts have been recounted. Al Gore's net gain unofficially, 120 votes. Obviously, though, Broward County did not make its 5 o'clock deadline. They put that on themselves. Now they're saying, look, maybe Tuesday, maybe Wednesday, the day before Thanksgiving. They will start tomorrow morning, no matter what, right around 8 o'clock sharp in Miami-Dade County, Shep. The exact same thing. They'll start at 8 and start recounting for 12 hours straight. Shep?
Orlando Salinas live for us in our Miami-Dade newsroom. Now, outside the political spotlight in South Florida today, haste leading to tragedy on an American Airlines jet. Crew members getting ready to evacuate the plane after an emergency landing at Miami International Airport when cops say one of the flight attendants opened a door before the cabin depressurized and was, quote, basically sucked out of the plane onto the tarmac. Several passengers also injured during evacuation of that plane. The jet heading to Haiti forced to land when a cockpit warning light indicated an engine fire, but rescue officials finding no evidence of any flames. And now from our newsrooms coast to coast, Fox reports across America.
North Carolina, up to 7 inches of snow surprising folks across the state. The rare pre-Thanksgiving snow causing traffic accidents, knocking down power lines, making it a shorter school day, and giving lots of kids an early chance for a snowball fight. Massachusetts, Boston City Hall getting into the holiday spirit, opening the Enchanted Village, a 7,000 square foot dome decked out with images of Christmas past. The display also offering kids a chance to meet the big guy himself. Michigan, a joyride on a tractor ending in some damage to a piece of the past. The driver crashing right into this historic home, demolishing the fieldstone porch. The damage estimate running about $250,000. Investigators looking for the joyrider. Massachusetts, legendary chef Julia Child adding another chapter to her amazing story, becoming the first American chef inducted into the French Legion of Honor. Created by Napoleon Bonaparte almost 200 years ago, it's still the highest award given by the French government. Child credited with creating nationwide interest in French food and culture. And that's a Fox Watch across America. Across America is brought to you today by Genuity.
Judgment Day coming in Tallahassee. The Florida Supreme Court hearing the whole story, but no word on what could be a historic ruling. When will they share it with the world? Team Fox coverage continues from ground zero. She could end up the most powerful woman of this election. But Katherine Harris was taking a beating from the media and her political opponents. Is it because she's leaning to one side or the other, or because she's a female? And the whole staff of people are ready to help the president-elect get settled into the Oval Office, except there is no president-elect. So what are these people doing while they wait? And how much does it cost all of us?
Fox News Channel, powerful all day. John Scott, Bridget Quinn, David Asman, bringing the world to you, making the issues clearer. Powerful hour to hour. Linda Vester, Shepard Smith, Neil Cavuto. breaking stories, aggressive coverage. Powerful all day, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide.
And Grandpa, that's the whole story. That's what happened.
Okay. Katie, now you tell me what happened.
Well, but Grandpa, I just told you.
Well, it's only fair if we hear her side.
What, you don't believe me?
Oh, now wait a second. It's important to hear both sides of the story so that we can understand everything that happened.
Grandpa, can I tell you my side?
Oh, yes, go ahead.
When I was playing, Greg just came over and pushed me. I wasn't doing anything.
Okay, Greg, now what about...
Fox News Channel Daytime. You want to make the right choices. We give you the power to decide for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
Opinions. I have them, you have them. In fact, on any given subject, there are as many opinions as seats in this theater. And that's good, people speaking out, sharing ideas. But opinions are not the same as facts, and you should know the difference. And that's why at the Fox News Channel, we label all opinions right on your TV screen. And that should help you form your own opinion, so you can decide what's right and what's wrong.
Thursday.
今日は楽しいハロウィンナイト。平和な仮装パーティーのはずが、またも悪巧みの気配。ショータイム。
ハロウィンで幽霊のコスチューム着たら本物の幽霊になっちゃった。
バフィーが貴婦人になっちゃうなんて。
バフィーどうする？
バフィー恋する十字架、木曜夜10時 on Fox。
Bottom of the hour, time for the top of the news and a quick update on Fox Top Story. The Florida Supreme Court hearing arguments for and against the hand recounts here. The lawyer for the Florida Secretary of State says Katherine Harris acted properly when she held counties to that 7-day deadline. Counsel for the Vice President says there is nothing in Florida law that says the ballot counting must stop 7 days after the election. And those lawyers asking the Florida Supreme Court itself to set a recount deadline once and for all. A circuit judge in Palm Beach County has denied a motion for a revote there. Several of the voters filed suit, saying confusing butterfly ballots caused them to vote for Patrick J. Buchanan when they meant to vote for Al Gore. Judge Jorge Labarga saying he did not have the authority to order a revote. Florida's Attorney General now telling election officials they should count overseas ballots that do not have a postmark. Bob Butterworth says those ballots will count if they're from qualified military voters and if the ballot is signed and dated no later than the date of the election. Much more on that story later in this newscast. On both sides going all out now for the big prize in Florida, the state Supreme Court mulling it over but making no ruling today. Fox News correspondent Rick Leventhal is here with the bottom of the hour update. Hello, Rick.
Hey, Shep, certainly the lawyers have spoken, but most didn't get a chance to deliver their prepared arguments because the 7 justices, as expected, interrupted frequently with some very specific questions on some very specific points. The Democrats' basic position presented to the court is that every vote cast should be counted and every deadline passed should be extended, arguing that if everyone would just get out of the way, they could finish the recount in a matter of days. The Republicans say those deadlines should be honored and that, to be fair, the machine counts should be the only counts and that the Secretary of State has jurisdiction here, not the courts, and that she acted properly within the confines of her position. Now, many of the justices' questions seem to focus on the consequences of certifying now in terms of how it would affect the recount, or the consequences of not certifying now and how that would affect the Electoral College. The state needs to name its electoral voters by December 12th, and they need to also allow time once this vote is certified for the losing side to appeal or contest the results of the election. So time is of the essence, and because of that, that's part of the reason why many courtroom observers and lawyers who were in the court believe the Supreme Court will, in fact, return a decision on this case sometime tomorrow. Shep?
Rick Leventhal live for us here in Tallahassee. Now, one of the key players in the election deadlock is Florida Secretary of State Katherine Harris. She's taken some hard knocks, according to many of her supporters, everything from her politics to her appearance. She's learning the hard way these days, the downside of the spotlight. In a Fox report now from senior correspondent Shawn.
She's been the subject of a torrent of abuse, from her eyeliner to her legal decisions. Katherine Harris, the embattled Florida Secretary of State, has learned the hard way that prominence can bring pitfalls.
You know, they're making fun of her makeup. They're making fun of her, the fact that she might be ambitious. I mean, she's really getting sort of a combination. It's just unnecessary, and the media shouldn't be piling on and joining in games like this.
She has reached the stature of being lampooned on Saturday Night Live.
George Bush won, we won.
The New Republic asked if she was separated at birth from rocker Ozzy Osbourne. And the Washington Post even lambasted her makeup, but such satire is tame when compared to the real stuff. Gore campaign spokesman Chris Lehane branded her a political hack and a Soviet commissar. Famed Harvard attorney Alan Dershowitz called her a crook. Critics charge the viciousness is offensive and unfair.
The media's carrying water for the Democrats' character assassination campaign against her. I mean, they refer to her as the Republican Florida Secretary of State so many times, it sounds like it's her official title. And it's not. It's brought up to impugn her credibility and judgment.
Democrats accuse her of being partisan because she helped run Bush's Florida campaign.
Given the fact that she's in a position with the Bush campaign as a co-chairperson, I think it creates, at the very least, the appearance of a conflict of interest.
But others, such as the Wall Street Journal's Dorothy Rabinowitz, think Mrs. Harris has brought on some of the criticism herself.
Katherine Harris has actually invited much of the treatment she's received, which is comic, satiric, and very nasty, which doesn't excuse it.
Mrs. Harris has turned down all requests for interviews and has restricted her public comments to the recount. When it's all over, we may not only know who will be president, but also how one of the central figures in this drama feels about the way she's been portrayed in the process. In New York, Shawn, Fox News.
Well, in this second week after the election, that's normally the time the president-elect and his transition office is working full steam in D.C. Just such an office already in waiting in downtown Washington, 5 stories high, 500 temporary employees, fully loaded with everything except the president-elect. But today's Washington Times is reporting that the White House has ordered a halt to all transition activities until all the legal challenges are exhausted in Florida. That would mean even if George W. Bush were declared the winner, he still would not get the keys to the transition office, supporters say, severely cutting down the time needed to be served. But the General Services Administration denies that report, saying no one, neither Bush nor Gore, will get those keys until there is a winner. Why all the confusion over the military ballots, the ones coming in from overseas? Why would they count if they don't have postmarks? And how did our servicemen and women feel when it looked as if their voices might not be heard? We'll have a report coming from the front line. He defended the president. Now, an untimely death, the sudden passing of one of President Clinton's #1 attorneys.